Good morning. We have what I understand is a um, jury instruction conference from yesterday afternoon, and might be a little on the dry side, but something to do while we're waiting for the closing arguments and getting jury watch. So we might as well do it. Just checking Twitter, and Judge Boyce is calling for the jury, and closing arguments are going to be starting any minute now. So, sounds like Larry Woodcock is feeling better, and I guess he got really emotional the other day in court, and they took him to the hospital. So he's doing better. Says he was playing JJ's favorite song, singing along, but he's a strong man to be going through all of this. So I'll keep checking Twitter intermittently to see how things are going with closing arguments. And as for the rest of today, I'm not sure when they'll post closing arguments on, but as soon as I see any of the big channels like Law and Crime post it, I'll go ahead and go with that so that we can have that to listen to while on jury watch. So, oops, Alan just got jumped up. So, I guess we're ready to start. So here we go. Oh, let's get the right tab here.
Thank you. Please be seated. All right, we are, excuse me. We're on the record on case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. At this time, we have scheduled a jury instruction conference with counsel, the parties having both rested. I'll note on the record that earlier today, the court conducted an informal conference with the parties we did take a stenographic record of those proceedings, and that was an informal jury instruction conference. We are now going on the record to look at final argument as to the proposed jury instructions. The prosecution's here present. The defense, as well as the defendant, is present in the courtroom. The jury is not present for these proceedings. The court would indicate the existing courtroom conduct orders are still in effect for this hearing, as well as the viewing locations and in this courtroom. At this time then, let me just inquire, we did redraft and sent the most updated version of jury instructions to counsel over the lunch break. I believe they've been received, and we'll go through them each at a time on the record. Did the state receive the new updated version of the jury instructions?
Yes, Your Honor.
All right, has the defense received those as well?
Yes.
All right, counsel, I'll note also we do have a draft version of the verdict form as well, which was just provided to counsel in paper copy. So at this time, we'll take up the instructions themselves. I'll note that the instructions 1 through 10 have previously been provided and read to the jurors. Those will be included in the jury instructions that will be provided to the jurors tomorrow morning. The court will go through and reread some of those instructions to be determined by the court as we go forward with the new instructions. So we'll take up starting at instruction number 11, and I'll just call through each of these on the record and indicate whether there's any objections or not. So on jury instruction number, what is now number 11, does the state have any objection to that as instruction as included in the draft?
No, Your Honor, we do not.
From the defense?
No objection.
All right, instruction 11 will be given. Jury instruction number 12, any objection from the state?
No objection as to number 12.
For the defense?
Your Honor, we had previously brought up that some of the evidence or some of the exhibits are not evidence. I think jury instruction, the following one, number 13, may cover that. But if the language in jury instruction number 12 needed to reflect that, was our request.
All right, the court's considered that request, that some of the exhibits were for a limited purpose. The court does have an instruction on number 15 that addresses that. I did consider that objection and will overrule it. So instruction number 12, as it's been submitted, is going to be supplied by the court. Jury instruction number 13.
Your Honor, the state would suggest one change to the last sentence. The defendant may be found guilty or not guilty on either or both of the offenses charged. I think we would suggest that be changed to any or all of the offenses since there are more than 2 charged.
All right, a response to that from the state?
That makes sense since there's more than 2 charges.
Okay, that's a good catch. Thanks, counsel. We will amend jury instruction number 13 to conform with multiple charges here. So we'll get an amended version of that, which will not say either or both. So we'll correct that language. Thank you, counsel. Jury instruction number 14.
The state has no objection to 14.
Defense?
On jury instruction 14, we proposed language to clearly identify what the court is talking about here. We proposed language that would, this evidence includes incidents in Arizona, including Charles Vallow, Brandon Bedreau, and 404B evidence. Since that's what this instruction is referring to, we thought a further explanation would assist the jury.
All right. Does the state have a response to that?
Your Honor, I think the state had previously indicated, and our position would be that adding that additional information may only confuse the jurors. The state's recollection and understanding is some of the evidence that came in regarding those individuals did not fall under 404B. While we recognize some did, and probably the majority, I think the court gave appropriate instructions throughout. And if anything, only a mention to those instructions given by the court. I believe those may be covered further in the jury instructions, but we believe the appropriate instructions have been given, and 14 as drafted would be the least confusing mechanism for the jury to receive this instruction.
All right. Thank you, Ms. Blake. The court has considered the comment from both the defense and the state. After the informal conference this morning, we did add a sentence into this instruction, which is the second sentence that states, at the time this evidence was introduced, you were advised of its limited purpose. I think with that reference back to the advisement that occurred in court, as well as the remainder of this being a standard jury instruction that the court views as properly defining limited evidence as it relates to 404B, that continuing or ongoing objection will be overruled. And so this jury instruction number 14 is going to be given as it's indicated here in the draft. All right, on jury instruction number 15, I will note that we went in and took out 3 of the listed exhibits, which were summary exhibits, not demonstrative, and made that amendment during the since the last conference. And so with that in mind, does the state have any objection to 15 as it states now?
No, Your Honor, no objection.
From the defense?
No objection.
All right. 15 will be given defense.
There was another instruction on aiding and abetting. We asked the court to consider the other language of aiding and abetting, and since they may be not defined the same, we will lodge an objection.
All right. Does the state have any response to that objection?
Yes, Your Honor. I do not see this jury instruction as providing a definition for aiding and abetting. I think that is provided in a later jury instruction. While I recognize that language is included here, there's no definition that the state sees as being provided. So we think the jury instruction should stand as is and let aiding and abetting be defined later on.
All right, the court's considered the objection, and I will overrule that and allow for this instruction to be provided as there is going to be subsequent definition of aiding and abetting within the substantive instructions. So jury instruction number 16 will be given. Jury instruction number 17. Any objection from the state?
No objection from the state.
No objection, Your Honor.
Thank you. 17 will be given. Instruction number 18. Any objection on that from the state?
No objection from the state.
From the defense?
No objection.
Very well. 18 will be given to the jurors. Jury instruction number 19. Response from the state?
The state has no objection, Your Honor.
All right. And I will note on that one, there were some revisions made as well on the break as accounting for the description of the crimes in the conspiracy charges. Mr. Archibald, upon review of that, does the defense have any objection to the way it's now written?
As it's alleged in the indictment, the grand jury combined first-degree murder and grand theft by deception into one count. That's count 1, and then both charges combined in count 3. I think the way jury instruction number 19 reads is that the jury in this case should consider those crimes separately. We've previously objected to that, and we've previously asked the court to send the indictment back to the grand jury for clarification if it was one crime or two crimes. And so we believe jury instruction 19 does not accurately reflect how my client was indicted by the grand jury.
All right. Does the state have a response to the defense objection on 19?
Yes, Your Honor. In looking at 19, there's a breakdown of counts 1 and 3, which included the crimes of first-degree murder and grand theft by deception, and then it references count 5, which is just an agreement to commit first-degree murder. Looking at the language moving forward, I don't have the same concern as defense. I don't see how there's any confusion with regard to what crimes are charged within each count. So I believe the way that it's written now would comply with the standard ICGs and be appropriate. And I don't see it as being confusing, indicating they don't need to agree upon every detail, and then defining or talking about how an agreement can be established. So we would request that it remain as written.
All right. The court did modify this instruction after the informal conference when the defense raised a concern about the conjunctive, well, having murder and grand theft by deception together, and whether that was a crime singular or crime plural. In order to resolve any confusion that could result, the court went back to the language of the indictment itself, now the amended indictment, and took the actual language out of there, indicating that on counts 1 and 3, it is crimes of first degree murder and grand theft by deception. So with that clarification, the court will keep this jury instruction as now modified and overrule the objection of the defense. So jury instruction number 19 will be given. Jury instruction number 20 from the state. Any objection?
No objection from the state.
For the defense?
No objection.
20 will be given. Instruction 21 from
No
the state.
objection.
Okay.
Oh, I apologize, Your Honor. No objection from the state.
No objection.
All right. 21 will be given. Instruction 22.
No objection from the state.
For the defense?
No objection.
Okay. 22 will come in. 23.
No objection from the state.
For the defense?
No objection.
All right. That one will be provided. Instruction 24 for the state.
No objection, Your Honor.
For the defense?
No objection.
Very well. Instruction 25, I'll note this is one that was modified after objections were lodged, and with the new instruction, let me first hear from the state. Is there any objection to instruction 25 as it's now written?
No objection, Your Honor.
For the defendant?
Our previous objection was to the addition of the federal agency or United States of America, so we'll stand by that objection.
Okay, I'll note the instruction initially did not contain that federal agency or United States of America language. The court considered that objection and it was added in. Again, looking at the amended indictment as it's charged and relating to who person would be defined of within the theft offenses charged, the court finds it appropriate to include that information based on the request of the state. So the objections overruled and instruction 25 will be provided. Number 26 from the state.
No objection, Your Honor.
For the defense.
No objection.
All right, that one will come in. Number 27
No objection from the state.
for the defense.
Your Honor, this jury instruction number 27 was a subject of the amended indictment with different code sections and different definitions of theft. So where there's been some confusion on whether my client is charged with intent to deceive or intent to deprive, we lodge an objection.
Okay, what's the response from the state?
Your Honor, the state's response is this is in compliance with the standard Idaho proposed jury instructions. It also, regardless of which code section it's charged under, theft would always include the wrongful taking, obtaining, or withholding of property from the owner of another. The difference would be potentially by which means that was done. But given the court's ruling on that and the language reflected in the indictment, as well as the evidence that came in, we feel that this does conform in all aspects.
All right, I've considered the objection on jury instruction number 27 as it relates to how the amended indictment now reads. The court does find that's an appropriate instruction that will assist the jurors in applying the law to the facts of this case. So jury instruction number 27 will be provided. Jury instruction number 28.
The state has no objection.
All right, and this is a long instruction. If you need a moment to continue to look at that, Mr. Archibald, you may.
On jury instruction number 28, the defense lodged an objection due to the language in this instruction not mirroring the indictment from the grand jury. The indictment from the grand jury, the defense had requested that it be sent back to the grand jury for clarification, and this is now reflecting that issue, that the jury instruction tries to clarify what the grand jury could not. So we believe that that's improper for the court to fix the grand jury's errors. Some of the errors are contained in paragraph 3, where the and or language has been added. That's not what the grand jury indicted my client on. The grand jury indicted Lori Vallow and Chad Daybell and Alex Cox and other co-conspirators. This jury instruction now says Lori with Chad and or Alex. So it's giving the state of Idaho more options in their charging, giving the jury more options to convict that the grand jury did not indict my client on. Also in paragraph 4, the grand jury described murder and grand theft as one charge. Again, the defense asked the indictment be sent back to the grand jury for clarification, and that request was denied. So we're stuck with murder and grand theft being one crime, not multiple crimes in paragraph 4. In paragraph 5, we believe this misstates the crime. Paragraph 5 of jury instruction number 28 says the defendant intended that at least one of the crimes would be committed. Again, we believe the grand jury indicted the defendant on one crime called murder and grand theft. And so because of those errors, we don't think that this court should fix those errors at a jury instruction conference. So that's why we're objecting to jury instruction number 28.
All right. Considered those objections, I'd like to hear a response from the state.
Thank you, Your Honor. And I'll try to take them through the way defense did, because there were a couple different sections identified there. So first, looking at number 3, I think adding the and or clearly comports with the evidence presented. It's also, this is clearly a conspiracy charge, and in an earlier instruction, it specifically says an agreement between one or more persons does not require multiple persons to enter into that agreement. So considering that it comports with the crime of conspiracy as well as the evidence presented, I think that that is well within the court's discretion to do that, and that it would be appropriate, as well as complying with standard jury instructions. Looking at number 4, I don't see the same issue there that defense is pointing out. It clearly says to commit the crimes of murder in the first degree of Tylee Ryan and grand theft by deception. I don't see where those are separated out differently. I think the and is there. So I think that is written appropriately, and I'm not sure of the objection there. With regard to number 5, I think that absolutely comports with the Idaho standard jury instruction. Again, I think it comports with evidence presented in this case and is appropriate. However, we would leave 5 within the discretion of the court for the court to make the determination, but we believe that they are appropriate as written and comply and comport with evidence and the Idaho standard jury instructions.
All right, thank you, Ms. Blake. This one, on paragraph 3, where it has an and or, I will agree with the state on that there are other instructions that cover that and the nature of a conspiracy where someone can, for example, enter later on. I think the evidence presented and the way it was charged in this case, it does not have the and or language in the information, which I considered, but also looking at the evidence that came about, and it does list all 3 people as co-conspirators, Lori Noreen Vallow, Chad Daybell, and Alex Cox. I think that given the other instructions that clarify how a conspiracy can be entered into, perhaps at different times, and also looking at the evidence of this case, that it would be appropriate to allow the jurors to consider the and or element of that as it relates to this charge. The paragraph 4, I think, does comport with the way the indictment now reads and has read, that it is a crime charge of first degree murder and grand theft, and so it's got that conjunctive in there, combining them together essentially by using the word and. On 5, I do wonder if, because of the way it is charged, it wouldn't be more appropriate for it to read that the defendant intended that and take out at least one of, and have it read the defendant intended that the crimes would be committed. So if I remove the at least one of language, that I think may assist the defense, at least in terms of their addressing that question of whether or not this provides an option that's not contained in the charging document. I'm not entirely sure I want to remove that or not, but I'd like to hear some further commentary if you think that would be an appropriate way to amend that to more accurately reflect. Mr. Archibald, any thoughts on that? If it read the defendant intended that the crimes would be committed, as to just paragraph 5, understanding you maintain your other objections, would that resolve that issue on 5?
Yes, I think that if we struck at least one of, because the way that it's charged, it needs to be both. So the defendant intended that the crimes, again, crimes plural. I think the way that the grand jury charged it, they called first degree murder and grand theft one crime. And so the paragraph 5 reads, the defendant intended that the crime would be committed.
All right. Any further response on that from the state?
Your Honor, I think given the nature of the defense's concern and maybe even what sounds like the court's concern, while the state does believe that this complies with the standard jury instructions and that I think there is other language contained in the instructions regarding there doesn't have to be agreement as to every element or every act taken. I think given the concerns, the state would defer to the court on this. Again, we think it complies, but we would just defer to the court's discretion.
Okay, thank you, Ms. Blake. The court is going to amend that paragraph 5 so the at least one of language will come out. It will still say crimes plural, not singular, so it will read the defendant intended that the crimes would be committed, and we'll amend 28 to reflect that. Beyond that, any other further objections or comments on 28 from the defense?
No, Your Honor.
Okay. We will move on then to 29.
And the state has no objection to 29.
All right, from the defense.
No objection to instruction number 29.
Very well. Instruction 29 will be provided. Instruction number 30. I'll just note here, this instruction in many ways tracks instruction 28 that we just went through. And so the court is going to, on paragraph 5 of 30, using the same logic that was on 28, take out the at least one of, and it will read, so paragraph 5 will read the defendant intended that the crimes would be committed. And so with that amendment, I'll hear from the state whether you've got any objections to that or any other part of this.
And Your Honor, I think we have the exact same comments on this that we would have on jury instruction 28. I'm anticipating the similar objections by defense. The state stands by our arguments that were previously put on the record. I think they are appropriate.
Okay. From the defense, do you also incorporate the same arguments you had on 28?
Yes, Your Honor, that paragraph 3 does not appropriately reflect what my client was indicted on, and paragraph 5 as well misstates what we believe the law is. So those are our objections to instruction number 30.
All right. For the same rationale as indicated in 28, I'll overrule those other objections. I will make the amendment to paragraph 5, taking out that at least one of language, and the other objections are overruled. So 30 will be amended in conformity with that and be provided. Instruction number 31.
And Your Honor, just briefly on instruction number 30, just so that it mirrors 28 on that number 5, I know the court has indicated we're going to take out at least one of. On this one, there's an S in brackets, and on the last one, there is no S in brackets. The state doesn't care which way it's written, but just if we want to be consistent.
Okay, and I'll intend to make that consistent, and it will read crimes without the bracket on the S. All right, let's look at 31 next.
The state does not have any objection to 31.
Yes, you may.
In jury instruction number 31, we had brought to the court's attention that the way this jury instruction reads is not how the grand jury indicted her. And in counts 2 and 4, the way my client was indicted says that as part of a common scheme or plan or continuing criminal transaction between Madison and Fremont counties, was concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation. So the way jury instruction number 31 reads, the defendant engaged in conduct or did aid, abet, advise, counsel, or procure another to engage in conduct which caused the death of J.J. Vallow with malice aforethought, and the murder was willful, deliberate, and premeditated. So my client was indicted as part of a common scheme or plan or continuing criminal transaction. That's not contained in jury instruction 31. The word counsel in jury instruction number 31 was not part of her indictment. Procure another is not, that's contained in jury instruction 31, is not part of her indictment. So we believe the court in jury instruction number 31 is instructing this jury completely different than how the grand jury indicted her. That would, these arguments would also go then to the previous count 2 in the indictment, or instruction
29.
29.
Okay. All right. So the paraphrasing here, but the defense has raised an objection, and now I'm addressing the state that I recognize there's Idaho Criminal Jury Instruction 704A, which is the standard instruction for first-degree murder, malice aforethought, contains certain language in that, and they are objecting based on differing language contained in the indictment. So how does the state respond to that disparity between the language of the indictment and the language of the standard malice aforethought jury instruction?
Thank you, Your Honor. With regard to the first part, the common scheme or plan or continuing criminal transaction between Madison and Fremont counties in Idaho, the state's position would be that was a preliminary issue regarding venue in order to have both counties as a potential place where the crime was committed when the actual element is to prove within the state of Idaho. So that was a preliminary issue dealing with venue, and I do not believe is a required element to be proven, so would not be included on jury instructions. So that's the state's response with regard to that. The second part, we would argue that this does comport with the standard Idaho criminal jury instructions, and it is the language contained under the statute for which Ms. Vallow is currently charged with regard to. The language comes from the principal statute under the Idaho Code, and then is attached to the crime of first-degree murder as a principal to first-degree murder. So the language is contained within the statute, and the language does comport with the Idaho standard criminal jury instructions.
All right. Well, in terms of the first objection as the common scheme or plan or continuing criminal transaction, I'll overrule that objection based on the argument of the state that that goes more towards venue than any other substantive element of the crime. The second part of the objection, I had seen this and thought about it, and upon hearing argument, I do think there's further concern that needs to be discussed about some language that is in the standard instruction but not in the indictment, and that is the terms counsel and procure, because the indictment talks about advised, encouraged, or by command compelled another, doesn't have any counsel or procure language. And I guess I'd like to hear a response from the state as to whether it would be appropriate to include those terms when they're not in the indictment.
Yes, Your Honor. And I was just comparing the exact language of the indictment with the language in the jury instruction. So we do have the did aid and abet, which is contained in both. We do have the not being present, advised and encouraged its commission. So I guess if we are going to make the changes, I would recommend or propose that it be changed to advised and encouraged its commission. Then we do have or by command compelled another to commit the crime. And so I think if the court were to consider taking out counsel or procured, then we would ask that the language be modified to have it be advised and or encouraged its commission, or by command compelled another to commit the crime, and include that in here. Because I do think when we have procure another, I think that is essentially synonymous with commanding or compelling another to do it. If the court wanted to change the language to reflect the indictment, I think we could do that, but we would object to it just being completely taken out. And I think the counsel is covered by encouraging its commission. So I think if you counsel or encourage another, I think those could also be synonymous. But again, if the court is to modify it, we would ask that we include those additional terms then.
All right. Any final argument as to those terms from the defense?
No, Your Honor.
Okay. On instruction number 31, then the court is going to take those arguments under advisement, and if any further edits are made to that, changing the instruction, will advise counsel and consider the matter submitted. The court will determine whether or not there should be some modification based on the arguments as it relates to paragraph 3 of instruction number 31, and also incorporating that same rationale and the objection made on 29. The court may also consider editing paragraph 3 of 29 for the same reason that's been raised by the defense. So if it's changed, we'll advise counsel before the final jury instructions are given to the jurors. All right, let's move on then to instruction number 32.
The state has no objection.
Mr. Archibald? I do see an edit I'm going to make, counsel, on paragraph 4, that to commit the crimes of, we will make that a singular crime. I think that was a carryover from the other conspiracy counts.
So in instruction number 32, we previously objected paragraph 3. The indictment indicates Chad, Daybell, Lori Vallow, and Alex Cox. Paragraph 3 in this instruction says Lori Vallow, Chad, Daybell, and or Alex Cox. So we believe that this instruction gives more options for conviction as to other than how she was indicted. So the and or language as proposed by the state, we believe, is not reflective in the indictment. The indictment contains language as part of a continuing transaction, common scheme or plan, did willfully and knowingly combine, conspire, confederate. That language is not included in instruction number 32. Did combine or conspire to commit murder. That language is not in instruction number 32. So again, we're concerned that the court is simplifying the matter for the jury in this case, where the grand jury did have some additional language. And we had previously asked for the indictment to be sent back for clarification. That request was denied. So we think likewise this court should not in essence grant that at this time.
Okay, I've considered those objections, and let me hear a response from the state, if you would, Ms. Blake.
Thank you, Your Honor. And before I respond, just briefly, in looking at this again on 6B, it appears that it has September with a large I or a Roman numeral 1. I don't know if we want to change that to the standard.
That would be the number 1.
Yes, the number 1. It was probably put in as a Roman numeral or.
Okay, I think that's a clerical mistake we can correct on 6B to make that September 1.
I just didn't want to forget. And then with regard to the response, as the state has previously indicated on that and or it does comport with the evidence submitted in this trial. It comports with also the previous instruction given regarding a conspiracy and that it can be one or more persons. So we do believe that that is an appropriate jury instruction with regard to that and or. In response to defense's position that this does not contain all of the language from the indictment, it would be the state's position that this does comport with the Idaho standard criminal jury instruction. In addition, there was mention that it may be oversimplifying. It would be the state's position. Part of jury instructions would be to simplify or make things not confusing for the jurors. And where it does comport with the standard jury instruction and it comports with evidence presented, I think it would be an appropriate instruction to be given as written. So for those reasons, the state would ask that it remain as in its current form.
All right. I've considered the objections there on the and or language as has been previously ruled on the counts 1 and 3 conspiracy counts. The court does find that the additional instruction relating to conspiracy would allow for the and or language, although that's not what's in the information, or I'm sorry, the indictment. It does comport with evidence that was presented in the case, as well as the law as it relates to applying the law to the facts of this case with the conspiracy definitions. So the objection's overruled on that. The paragraph 4, the court will take the S off the crimes and make that singular. We'll modify paragraph 6B to be a number 1 instead of a Roman numeral 1. Fix that as well. The court's considered the additional objections lodged by the defense on instruction number 32, and will overrule those objections as previously stated on the other conspiracy counts that were argued earlier. Let's next look at instruction number 33.
No objection from the state.
From the defense.
Yes, we previously objected to jury instruction 33 because the state yesterday asked for an amended indictment to clarify what type of theft they were seeking because of the different code sections were reflected differently in the indictment. And so whether she's charged with intent to deceive or intent to deprive, those are different. Those are different meanings. So basically jury instruction number 33 says it doesn't matter. So it doesn't matter why seek out the amended indictment. So that's why we object to instruction number 33.
All right, response from the state on that?
Thank you, Your Honor. And this is very similar to jury instruction 27 that we previously discussed regarding that language. The state's position would be, again, that this would be compliant with the Idaho standard criminal jury instructions. It is also contained within the language in the indictment. I know there's been reference back to that amendment made to the indictment multiple times. The amendment was made to correct a clerical error regarding a code section, not the language itself. So it would be reflective of what's in the indictment. Generally speaking, under theft, the theft can be committed by either taking, withholding, or detaining. So the jury instruction just simply indicates that either or any of those could be an option. I don't think that that is in opposition to what has been presented in the indictment, and again is allowed under the Idaho criminal standard criminal jury instructions.
All right, I'm just rereading this instruction. All right, I've considered the argument from the defense on instruction number 33. There's some case law that also talks about jury instructions. There's a case, State versus Lee's. It's a Idaho Court of Appeals case. I don't have a good site, but it's 364-16210 Westlaw 9587784. But anyway, it cites to other cases, the Severson case, 147 Idaho at 710, and talks about instructions that are on the nature and elements of the crime charged and essential legal principles applicable to the evidence that has been admitted. So I think it is within the discretion of the court to allow for instructions that also go towards the nature of the evidence that's been admitted in the case and not only the charging documents. I'll also note that in this instruction, this is specific to count 7, which is the grand theft charge, which was not. Let me review that. I think on that. Was that charge amended as part of the amended information to change the code site?
No, Your Honor, within the indictment, I think that one had, just one moment.
It does have the 24032A code site.
Yes, I'm looking at the amended indictment as if it were the original, so I apologize, Your Honor. I was double checking that. It was amended, but I would note the language in there has always contained the by deceit with intent to deprive another, and then it goes on to eventually say wrongfully take, obtain, or withhold. And I believe that is indicative of the same language within the jury instruction.
All right. Well, having considered that in the language of the indictment, the court finds that instruction 33 is a proper and standard jury instruction also from the Idaho criminal jury instructions, and would apply given the evidence that's been admitted in this case to help instruct the jury to appropriately apply the law to the facts of this case. So instruction number 33 will be given. Let's next look at instruction number 34.
The state has no objection, Your Honor.
All right, from the defense.
No, instruction number 34 does not contain the same language as the indictment from the grand jury regarding the elements of grand theft.
All right, what's the response from the state?
Your Honor, the state's position is this would conform with the evidence that was presented at trial, and it also conforms with the Idaho standard criminal jury instructions. In looking at it, again, it does have that common scheme or plan language that, again, as the state had indicated, dealt with the venue issue, which is a preliminary matter. And we
Idaho criminal jury instruction 543 and went through to make sure that all of the appropriate elements of that offense are contained in the instruction. It's the way the statutes set it out for the theft statutes. They're kind of mixed in between the types of theft by deception, and then you have to go to the definition section above that also. And so looking through that, the standard instruction 543 pulls those things together to cover the elements. So because this is based on the 543 instruction and having confirmed the language in the indictment, the court does find that the instruction properly instructs the jurors as to both the elements of the offense as well as comports with the evidence that's been admitted in the case for the jury to consider. So considering all that, the court will overrule the objection of the defense, and jury instruction number 34 will be provided. Let's next look at instruction number 35.
The state has no objection.
Well, and we can
the
discuss,
instruction.
there is also this gets to the verdict form. So once this is completed, we'll include we'll include the content of the verdict form will be part of instruction 35, but of course there will only be a single verdict form that will be provided to the jurors for the presiding officer to sign. The court did submit a proposed copy of a verdict form, so since we're on this instruction now that would contain the sample verdict, if you have any comments relating to the proposed verdict form, let's take those up along with instruction number 35. So starting with the state, do you have any comments on the verdict form?
Yes, Your Honor. With regard to question number 2, we would propose that the and grand theft by deception with the question and grand theft by deception be removed. And with regard to question number 4, similarly, we would request that and grand theft by deception be removed on that one. And then same on question number 5, that and grand theft by deception be removed. I believe those are the only proposed changes by the state.
All right, and then for the contents of instruction 35, any objections to the way that reads, sort of the verdict form?
No objection to the way the instruction reads.
All right, and looking at, I'll hear from the defense here in a minute, but that does need to be corrected. The grand theft by deception language that's not part of the charges will be removed on those verdict forms. We'll get another proposed verdict form to you before it's provided to the jurors in the morning and make those amendments on that verdict form. Let me hear from the defense now, noting those changes that will be made on the verdict form to comport with the charging language of the indictment. Do you have any comments, Mr. Archibald?
In the questions, it asks, is she guilty or not guilty? And then the check of the boxes is not guilty or guilty. So those kind of seem backwards if they're going to be consistent. So that's all I'd note in question, well, all 6 questions. The question is she guilty or not guilty? But then when you check the boxes, it says not guilty or guilty. So it's just switched. So we'd ask that the questions say not guilty or guilty to be consistent with the boxes that they check.
Okay, we're going to redraft the verdict form. We'll take out those. I agree. It makes sense to have some uniformity between how the language reads versus the options below. So we'll incorporate those changes as well. We'll get you a proposed revised verdict form by the end of today. And if you have any further questions on it, I'll allow any comments on that before the jurors are brought in and provided the final instructions tomorrow morning.
And then we also had a question about accessory after the fact.
Okay, I'll take that up. Let's finish the last couple of instructions and then we can go to your proposed accessory instruction. So 36 is a standard instruction I believe council agreed to yesterday. Is there any objection on 36
Not from the state, Your Honor. Thank you.
from the defense?
No objection.
Okay, 36 will be provided. 37 is a instruction about exhibits, and any objection on the way that's written now from the state?
No objection from the state, Your Honor.
Any objection from the defense on 37?
No objection.
All right, that'll be provided. Jury instruction 38 is an instruction for the jurors to select a presiding officer. It's a standard instruction. Any objection from the state?
No objection from the state.
All right, from the defense, any objection?
No objection.
That'll be provided. And then finally, the final instruction on 39 on deliberations and how those are done is from the standard instruction. Any response on 39 from the state?
No objection from the state.
For the defense?
No objection.
All right. So the next issue we'll take up then as it relates to a proposal that the court include an accessory instruction in this case. Mr. Archibald, I haven't seen a proposed instruction, but you've argued for one. That was, I think it's the instruction number 310 of the criminal jury instructions you wanted.
Yes, I know criminal jury instruction 310 is a reflection of Idaho Code section 18-205. A person who knows a felony was committed and willfully conceals it from a peace officer is guilty as an accessory. So there has been evidence submitted during this case that a reasonable jury could conclude that if she's not guilty of murder, she's certainly guilty of knowing a felony was committed and lied about it to police. And so the accessory charge here, even though she's not charged with accessory, we believe it's a reasonable interpretation for the jury to consider that, rather than if they do not convict her on murder.
All right, so if the instruction were given as to which counts would you request that would apply to?
I think it would apply to all of them, except the grand theft. So count one, if the jury believes, well, she didn't kill anybody, she certainly lied about it. I think that would apply to counts 1, 2, 3, 4, and 5. And then count 7, the grand theft of Social Security funds, probably would not apply to that, but it would apply to counts 1 through 5.
All right, I'd like to hear some response then from the state on whether or not an instruction in conformity with criminal jury instruction 310 would be appropriate in the case.
Thank you, Your Honor. The state's position is that it would not be appropriate. Essentially, it's being requested as a lesser included offense instruction for several of the counts here. In looking at Rome v. State 164 Idaho 407, that's an Idaho Supreme Court case from 2018. When we look at the language in that, it's a little bit different of specifically what was being determined. In that one, they were attempting to include accessory after the fact as a lesser included of an aiding and abetting, but that would lead into a jury instruction providing that you don't consider the differences necessarily between aiding and abetting and principles with certain things. But the bigger part of it, I think, and what we would indicate is that one offense is not considered a lesser included of another unless it is necessarily so under the statutory definition of the crime. And further, an offense will be deemed to be a lesser included offense of another greater offense if all the elements required to sustain a conviction of the lesser included offense are included within the elements needed to sustain a conviction of the greater offense. As a result, an offense is not a lesser included if it is possible to commit the greater offense without committing the lesser offense. And when we look at accessories defined, and specifically the Idaho Code 18205, all persons or accessories who, having knowledge that a felony has been committed, willfully withhold or conceal it from a peace officer, judge, magistrate, grand jury, or trial jury. In no way are those elements required to prove conspiracy to commit first-degree murder and grand theft. They're not required to prove conspiracy to commit murder, or they're not contained within those elements, and they are not required for grand theft, which I think the defense has recognized that, and they are not required to prove first-degree murder, and especially under the theory of a principle. In no way is there an element that a person having knowledge, withhold, or conceal that as a requirement to prove one of the greater offenses. So if we follow the rationale of the Idaho Supreme Court in Rome v. State, accessory after the fact would not be an appropriate lesser included. So to include that instruction would only confuse the jury. In addition, when we look at 310, there's actually a comment there indicating that it shouldn't just stand alone without more. And if I may have just one moment.
Yes.
So given, again, looking at that standard jury instruction in conjunction with the 18205, Idaho Code 18205 that it mirrors, and then looking at the case law from the Idaho Supreme Court, it simply is not an appropriate jury instruction and would only lead to confuse the issues and confuse the jury because it is not an appropriate lesser included offense. So for those reasons, we would request that the court deny the defense request to have that jury instruction added.
All right, any response from the defense before I make a ruling on this proposed instruction?
No, Your Honor.
All right, the court's considered the defense request to include the accessory instruction. As noted, it wouldn't apply to the count 7 grand theft charge because that charge is only as against the defendant here. The accessory instruction talks about another person, so it talks about the person charged. If you willfully conceal it says a person who knows a felony was committed and willfully conceals it and protects the person charged is guilty as an accessory. I've considered the argument by the state for the rationale stated in Rome versus State about whether or not it's an appropriate lesser included offense, and considering the evidence that's been presented as well as in this case just the evidence by the case in chief, and there wasn't a defense case put on other than through cross-examination. I've considered that. Looking at the elements charged in those conspiracy counts and the murder counts, also the court has to consider that with the conspiracy charges and the way the conspiracy law is defined, where someone can join a conspiracy later, the accessory instruction I think would not be applicable when the conspiracy charges have been charged on counts 1, I think it's 1, 3, and 5. I'll also note the evidence in this case was that the defendant was part of the conspiracy from the time before any of these alleged acts were committed. There wasn't any direct evidence that there was no knowledge of this before the alleged acts that are charged in counts 1, counts 3, and 5 for the conspiracy charges. So I'd find it would be an inappropriate instruction for those. And then also as it relates to the other charges, 2 and 4 for the murder charges, again, the evidence would have to support for the jurors to find that there was some knowledge of the defendant, and I don't really recall any evidence directly relating to any express knowledge. There's circumstantial evidence, but that would indicate that knowledge only would have occurred after the fact. So all the allegations were the knowledge occurred before and after. And looking at that as well as the elements of conspiracy, and again, the comment in the instruction under 310, which cites the State versus Teasley case and also the Rome versus State case the state has cited to, I think that it would be an instruction that would not properly advise the jurors of the evidence that's been here as it relates to the charges, as well as I think it would potentially confuse the jurors as well. So the court is going to deny, based on the evidence that was presented in trial, the defense request for an accessory instruction, and the court determined that would not be appropriate here. For those reasons, then we're not going to allow for the accessory instruction as either a freestanding option or to be in combination with the charges in the case. So that'll be the ruling on that request. Council, we do have a new proposed verdict form that's ready to be reviewed. Why don't we take a quick recess, maybe for just 5 or 10 minutes, and then we can come back on the record and go back to the verdict form. I'll get a copy provided to you, and then we can determine whether that's sufficient.
All rise.
Thank you. Please be seated. Okay, we're back on the record on case CR 22-211624, State of Idaho versus Lori Noreen Vallow. We took a recess while we redrafted the proposed verdict form. I just wanted to go through that issue again before we conclude. So that would relate to our jury instruction number 35, which would contain within that instruction a content of this proposed form. So has the state seen the revised verdict form now?
Yes, Your Honor.
Does the state have any comments on the verdict form or approve the verdict form as it's now written?
We approve the verdict form as written.
All right. Has the defense been able to review that?
Yes, Your Honor.
All right. Does the defense have any comment on the verdict form or any suggested further edits?
You know, just reading the verdict form, it sure seems like question number 6 is pretty similar to question 1 and 3, where they all contain the same charge of grand theft.
All right. The counts are as set forth in the information, and I'm sorry, in the indictment. So 6 is a question as it relates to count 7 of the indictment, which is the grand theft charge.
That's my only observation. I realize that's how they charged it.
All right. Understood. So, counsel, the court will intend to provide that as incorporated in that instruction 35. If there's any other revisions or rulings, the court will put up those on the record in the morning before our closing arguments. The court also will, before the jury comes in, plan on finalizing the ruling on the criminal rule 29 motion that was argued and taken under advisement. And then we will, assuming that allows us to move forward with closings. If so, then we'll have closings starting tomorrow morning. Is there anything else we need to bring up? This one other point actually I wanted to mention, counsel, on the information, which will be the amended, I'm sorry, I keep saying information, but it's the indictment. On the amended indictment, the jurors have not had a copy of that previously provided. They've been read from it in the instructions, but they will in deliberations have a copy of that. The court would intend to redact out the counts 6 and 8 and 9 that relate only to Chad Daybell and the defendant's not charged with. I think just leaving those in there may create some unnecessary confusion for jurors since those counts are not being considered. I'd like to hear if there's any comment on that plan to redact those uncharged counts as against this defendant from the amended indictment before it's provided to the jurors.
Your Honor, the state wouldn't have an objection to that. I guess the only thing that I would indicate is I'm not sure if those are going to show as redacted or if the court is considering renumbering the indictment counts in order to match up with the questions, because the verdict form will have a different number associated with it than the indictment will by redacting out those counts. So that would be the only concern at all, is if we could agree to potentially modify that for purposes of handing it to the jury, just those count numbers to match up with the question numbers.
Yeah. In thinking through that, I think what we would do is simply, physically redact a copy of the indictment by removing that with a notation so the jurors understand it was redacted by the court, so they don't wonder why that's blacked off of their counts. Would remain the same as they are in the instructions and as they are in the indictment. So it would track with what we've already put together. So I think that would alleviate that concern. Does the defense have any objection to the redaction of the Chad Daybell counts in the indictment?
Would the court also delete his name from the indictment in the title?
And Your Honor, if the court could be heard on that, if the court is considering that.
Yeah, go ahead.
I think that would only confuse the issue and confuse the jurors, because then they're going to see missing counts and wonder why. I think with his name on there, they may be able to piece it together easier. So if we're going to modify the indictment that much, I wonder if it wouldn't be cleaner then to just have an amended indictment approved for handing to the jury where we only have her name and then we number the counts to match up with the questions. Because as it is now, the counts won't completely match up with the questions on the verdict form, which I think could be confusing. And then if we take his name off and we just have blanked out spaces.
Well, I don't think there's going to be any change of the numbering. If we're just blocking off what's already in the indictment. So,
but I believe we'd be taking off count 6. And so if we take off count 6, then question 6 will actually end up referring to count 7 in the indictment. And I don't know.
But that's the way it's written in the verdict form. It says in regards to count 7 of the indictment.
It just said question 6 though. Yeah. So I think that was the only concern.
Okay. Yeah. We'll make sure the verdict form corresponds as well as the counts in the jury instructions to what's just in the indictment. That suggestion by the defense to remove the name also on the caption, I think is a well taken point to avoid any further confusion. Obviously, the name would remain in there, that because the case being tried is not his case. And so I think it should be removed just from that part of the caption. However, his name would remain in like the preliminary statement before count 1 and other counts that are charged. So the conspiracies under count 1, his name within the other counts 2 and 3. So I do think for purposes of clarifying the record that coming off of the caption there is also appropriate. So the court will get for counsel a copy of that redacted indictment and have that submitted to you before it's provided to the jurors also before we start with argument tomorrow morning. All right, counsel, thanks for your time. Is there anything else we need to bring up then this afternoon from the state?
Not from the state, Your Honor. Thank you.
All right, thank you. Anything from the defense?
No, Your Honor.
Okay, thanks. We'll be in recess till tomorrow morning. All right. All right, good morning. We're going on the record on KCR 22-21-1624, State of Idaho versus Lori Noreen Vallow. This is the continuation of the jury trial in this case. The state continues putting on its case in chief. Prosecution's here present, as well as the defendant and her attorneys. Before we bring the jurors in this morning, we had ended yesterday with a argument as to a proposed exhibit, which the court made a ruling on yesterday, indicating that the exhibit as proposed would not be admissible. The court's been advised now that an updated, amended exhibit's been prepared, and due to the nature of the legal argument, I think it would be appropriate to hear the issue before we bring the jurors in. And in the matter of efficiency, the court would note, received a courtesy copy of the proposed exhibit and have reviewed that, and I believe the defense has as well. So as we get started this morning, let's talk about the issue of the next witness's proposed demonstrative exhibit, which I believe the state's offering under Rule 1006. Ms. Smith, I believe you'll make argument as to the admissibility of that exhibit. Is that correct?
Yes, Your Honor.
All right. If you'd like to present argument at this time, I'll hear that, and then I'll give an opportunity for the defense to respond.
Thank you, Your Honor. Without repeating the state's position yesterday, the amended exhibit, I believe, addressed the court's concerns that headers were removed. Any slide, and we respect and absolutely do whatever the court, we still are, we suggest that it's admissible, but respecting the court's order, we removed any slides that could even border on argument. We removed any slides, we even removed a timeline, which the court had said was allowed. It is simply representative text in summary and representative data in summary from the iCloud. It was cut and pasted directly from what's already been admitted as part of States 29. Those documents, the iCloud Lori for Style at iCloud.com, the documents and data in Lori for Lolly Time in iCloud.com have already come in. So these items are already in evidence, and similar to has been allowed for a few witnesses. This witness reviewed, and his responsibility within the FBI to review in detail iCloud. He did that. And to aid the jury and to aid him in his testimony, this exhibit would allow him to testify as to texts that reflect the content, reflect the ideas in the defendant's own words. These texts are the defendant's own words or conversations with her co-conspirators. They are conversations that show the defendant's state of mind, motive, intent. It certainly establishes that there's no mistake in this plan. The probative value of this significant evidence is unparalleled. And Agent Hart has spent hundreds of hours reviewing the iCloud, and to ease his testimony, to make it easier for the jury, he prepared this summary, and using this summary will aid the jury in reaching questions and making an ultimate decision on this case.
All right. Thank you, Ms. Smith. I believe Mr. Thomas, are you going to make argument in opposition?
Yeah, sure. I received this last night, the final version shortly after 8 o'clock. We were reviewing that last night and this morning. And in our review, we found multiple pages that have impermissible hearsay. I understand that the court is willing to allow in hearsay of co-conspirators pursuant to evidentiary rule, but on pages 2, 5, 7, 15, 43, 46, 72, 73, 75, 80, 81, 82, 83, and 84. There are numerous impermissible hearsay statements from either witnesses who have testified already or witnesses who have not been called, including Melanie Boudreau, Cole Vallow, Zach Vallow, some unlisted individuals, Audrey Baratario, and Sidney Woodbury. We believe that this is far outside of what Mr. Hart will be able to testify to. And if he testifies to anything what these people said, if he gives any commentary, then that's going to be impermissible hearsay. And he's just going to read impermissible hearsay into the record. And so I would ask that this be excluded for those reasons.
All right, thank you, Mr. Thomas. The representation from the state is, and of course the court has not gone in and reverse engineered the exhibit to make sure that the summary in proposed 183 is pulled directly out of already admitted evidence, which was state's 29. That is the continuing representation of the state that in fact all of the communications in 183 are directly from 29, which was previously admitted.
I apologize, my microphone was on. Yes, Your Honor. In fact, to ease any concerns the defense might have with that, we have actually placed on thumb drives as states exhibits 29C and D, the entirety of the Lally time at iCloud.com and the entirety of lawyerforstyle.com, as we have, our practice has been in this case to prevent hundreds of thousands of pages being flooded the court file. We have admitted the business record certificate and then taken portions of the representative records and admitted those. But to ease any concerns, anticipating what defense counsel might suggest, the entirety of Lally time is on one thumb drive, the entirety of Lawyer for Silence is on the other. And we certainly, I'm confident that those had been disclosed to the defense a few times, but for these counsel, we know the earliest they got it was in August of 2021. And it was in that production they received. So it's a duplicate of what they received. It has been verified, the copy by Agent Hart. Then we can just make sure that the agent can testify to that.
All right. The court's then considered this new proposed exhibit 183 in terms of Idaho Rule of Evidence 1006 and whether or not it's an appropriate summary to prove content of voluminous writings records that can't be conveniently examined in court and may potentially assist this witness in providing testimony about that voluminous information. Also considered the objection lodged by the defense as the objection relating to hearsay on certain pages of the exhibit. Hasn't been argued this morning, but I considered the timing as well of the disclosure. And upon consideration of all that, and in particular also Idaho Rule of Evidence 403, whether or not this may be more prejudicial than probative in a balancing, the court would find that upon review of the exhibit, it would be admissible, assuming the witness lays an adequate foundation for the exhibit prior to it being admitted. The hearsay objection is overruled, as the court would find that was waived upon the entry of State's Exhibit 29, which was previously admitted, I believe, without objection in the case. So these are portions of an already admitted exhibit. Also, in terms of the timing here, because it contains the same content of the previously admitted exhibit, but in a shortened version, and also that it removed the argumentative nature of what was included in there, the court would determine that it now does appropriately comply with Rule 1006 as a summary that may be used by the witness. So I'm making just a provisional ruling at this point, subject to foundation being laid by this witness to get that in. But the concerns raised yesterday have been overcome with the new proposed exhibit. So the objection on those grounds is overruled.
May I be heard on a motion to reconsider here?
Go ahead, Mr. Thomas.
The issue I have, Your Honor, is that if the court doesn't require that the state take these out in these particular pages, 14 different pages, that the state has indicated that these are voluminous documents. We had no idea that they were going to pull in these hearsay statements. We had no idea that they weren't going to actually call any of these people that I've indicated, and it would be ineffective on our part should we just roll over and allow this to happen. And Your Honor, I believe that, ineffective assistance of counsel is a big deal. And I think that this state could cure this by pulling out those items that were in this hearsay, that are hearsay within this. I understand that it has already been admitted as an exhibit, but to have the jury hear impermissible hearsay just because of a mistake on Ms. Vallow's counsel, that we allow this to come in without the objection of hearsay, I think would be detrimental to Ms. Vallow's case.
All right. Any response to that, Ms. Smith?
While I respect and admire defense counsel's creative advocacy One, it's not an impermissible hearsay. It's the defendant's statement. We're not offering the statements of any of the people in there for the truth of the matter asserted other than the defendant. Those provide context for that. So while I applaud the advocacy, the law is clear. The defendant's statements, when offered by the state, are admissible. The statements of the others are not inadmissible hearsay in that we are not offering for the truth of the matter. For example, the comment that Ned was in Charles is been in multiple times, sometimes without objection. And we're not offering it for the truth of the matter asserted that Ned was in fact in Charles Vallow. We are offering it for the response that the defendant made to this case. So one, it's not inadmissible hearsay. Two, defense counsel has multiple reports on this, and the characterization of ineffective is just simply misplaced, though I understand and respect the advocacy. It's just flat out not accurate. The appellate record on this will be clear, and the state has no concerns offering this exhibit in the context it's been put forward and offering and purporting the defendant's own statements. So for that reason, legally, the defense's position is unfounded.
All right. Well, I've considered the request to reconsider the ruling offered by Mr. Thomas and the response from the state on each of those pages. I haven't made any determination that it is or is not hearsay. They are statements of other persons apparently contained in those pages. Whether or not they fall within impermissible hearsay has not been determined. What has been determined is the exhibit from whence these come was previously admitted, and to the extent if there is any hearsay in there, it may or may not be permissible hearsay, but the defense will be allowed to cross-examine on those issues as well as it relates to whether or not the credibility could be attacked or they could be impeached if in fact it is hearsay statement, which is inherently less reliable than direct statements. So the court doesn't find a reason to modify my prior ruling based on that finding. So that'll be the determination as it relates to the proposed exhibit 183. Before we get started also, as I'm thinking through with this witness counsel, the defense had raised an issue yesterday also as it relates to concerns that the witness may have violated the exclusionary rule. If there's going to be extensive argument on that beyond me just doing the normal question I'm giving to all the witnesses, I'm wondering if perhaps we shouldn't start there with the witness also outside the presence of the jury. If you think you're going to probe into whether or not the witness may have violated the exclusionary rule, I think it might be more appropriate to do that examination outside of the juror's presence.
Yes, Your Honor.
You do intend to do that?
Yes.
Okay. With that, then I would find that it's appropriate to conduct that voir dire on that issue without the jurors present, so that we can get into if in fact there was any violation of the exclusionary rule, the witness can disclose that without having the jurors hear that information. So if that's where we are on the issue, I would suggest we then call the witness, having brought in, go through the exclusionary rule issue, and then assuming the witness stays on the stand, we'll bring the jurors in after that if the court does not find that he is excluded.
Thank you, Your Honor. Do you want Agent Hart brought in?
Yes, let's go ahead and do that then.
Your Honor, prior to that, can I just get a ruling that I don't have to make specific hearsay objections on pages 2, 5, 7, 15, 43, 46, 72, 73, 75, 80, 81, 82, 83, and 84, that the court's willing to acknowledge for appellate purposes that I have made those objections. I don't want to call specific attention to the jury to those specific hearsay objections. Is that okay?
Yes, so the record will indicate that the defense has now raised objections on those pages as to hearsay on the proposed exhibit that is not yet admitted, but if it does become admitted, then pages 2, 5, 7, 15, 43, 46, 72, 73, 75, 80, 81, 82, 83, and 84 have lodged an objection on hearsay grounds to each of those, and the court will not require you to re-raise the issue before the jurors. And again, I don't have those in front of me. If you think for some reason it should be raised again, you're not prohibited from bringing it up, but it's lodged in the record that you've made your objection.
Your Honor, if the state may at some point get that list, that went pretty fast, and that we heard about it in chambers but couldn't write it down fast enough. So if we could get that list, if defense counsel could email it to us or something, just so that we can make sure we're paying attention to that issue as it comes up.
Okay, let me just read it off for you one more time.
Thank you. I'm sorry.
2, 5, 7, 15, 43, 46, 72, 73, 75, 80, 81, 82, 83, 84.
Thank you, Judge.
You're welcome. Okay, let's go ahead and have the next witness called and sworn then, and we'll go through an initial voir dire on the exclusionary rule issue.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Your Honor, as the witness is taking the stand procedurally, do you want the state to go first on this inquiry or the court? I just want to make sure I'm standing where I need to be.
Yes. So give me just a second, counsel. Sorry, apologies, just one moment. I would have a brief consultation. All right, thank you. Please be seated. All right, at this time then, Agent Hart's been placed under oath. The issues arisen as to a potential, I guess, issue raised by the defense as to whether or not there's been a violation of the court's exclusionary rule as it relates to this witness. The court would note it's previously entered an order that prohibits witnesses in the case from seeing or reviewing or being exposed to the trial testimony before they testify. And so because the issue has been raised specifically, I would ask the state if you want to conduct any voir dire on the issue of the court's exclusionary order, then I'll allow the defense to cross-examine on that narrow issue. This is prior to starting any testimony before the jurors, and I'll note on the record the jurors are not present for this stage of the proceedings.
Good morning.
Morning.
Sir, do you prefer to be called chief deputy or agent? I'm used to one, but I know you're something else now.
For this case, agent is fine.
Okay. Agent Hart, were you aware of a court order prohibiting witnesses from listening to the trial in this case?
Yes.
Were you aware that the court's order prohibited you from listening to or reviewing trial testimony of any witnesses?
Yes.
Did you listen to the trial in any part of this case?
No.
Did you listen to the trial testimony of any witnesses?
No, I have not.
Have you reviewed the trial testimony that occurred in the courtroom with anyone?
No.
Have you reviewed the trial testimony of anyone, even through conversation?
No.
Okay. Has the state shared with you the trial testimony of anyone?
No.
You have been present for some interviews and pretrial preparation of witnesses, correct?
Yes.
Have you been part of pretrial preparation of witnesses after those people have testified?
No.
Has anyone brought to your attention any trial testimony of those witnesses at any point?
No.
Is there any way that you have followed, listened to the trial testimony or the trial proceedings that have been available in the public?
No. Prior to the trial beginning, we received a strict instruction from the prosecution regarding those matters, that we were not to speak with other witnesses regarding their testimony, and we were not to watch any television, read any newspaper media, online media regarding the trial. I've obeyed that order rigorously.
Okay. Thank you. I have nothing further. Thank you, Agent.
All right, thank you, Ms. Smith. Mr. Archibald, you can inquire.
If I understand correctly, you're not with the FBI any longer, but that was your former job.
That's correct.
And as your former job as an agent with the FBI, was it part of your duties to review all summaries from other FBI witnesses?
I guess I don't understand your question when you say FBI witnesses.
There's been a number of FBI witnesses who've testified in this trial. Are you aware of that?
Yeah. FBI employees?
Yes.
Yes.
Have you reviewed their statements?
No.
Did you coordinate with anyone about what other FBI witnesses were going to say and what you were going to say?
I was part of the investigation from its inception. And so during the course of the past 3.5 years, on a number of occasions, I have met with our FBI analysts, our FBI forensic accountants. I approve reports that they wrote during the course of the investigation, but I have not discussed their testimony with them in any way.
So they would prepare a report, you would review that, sign off on it.
Correct.
Has there been anyone from the FBI who's been attending this trial?
Objection, relevance. This is about his exposure to the proceedings in the courtroom. This isn't about who was where.
I'll rephrase the question.
Okay, go ahead, Mr. Archibald.
Is there anyone from the FBI sitting in the courtroom right now?
Objection, relevance.
It's not relevant, I guess, if they're not testifying.
Has the person who is from the FBI, who is sitting in this courtroom, have you had conversations with him about what's been happening here in court?
No.
Have you received any emails or texts from this FBI person who's here in the courtroom?
No.
Objection.
Okay, we seem to have ended the stream when I wasn't noticing, and I wondered why we suddenly had an investigator. So we're going to switch over to the opening statements to see what we think they proved and what they didn't prove. So let me see. We've got, just to see if we've got the best one option. Let's see. Let's go with this one here.
You will also hear how she had begun receiving benefits on JJ's behalf approximately a month before he was last seen. And you will hear how she continued to collect those benefits and that money to fund her lifestyle. You are going to hear a lot of different dates and events that occurred on those dates, phone calls that were placed on those dates, messages that were sent, financial transactions that occurred. The reason you're going to hear about so many dates and so many events is because I talked about dates in 2019 and 2020. This case actually starts in October of 2018. In October of 2018, the defendant met Chad Daybell for the first time. You'll hear that she had read his books. She was a fan of his. But she traveled to a Preparing the People conference in St. George, Utah. She traveled there with her friends, Melanie Gibb and Sulema Pastenis. These are two women that you will hear more about, and you will hear from them during this trial. When she traveled there with them, she met Chad for the first time. You'll hear it described that there appeared to be some kind of an instant connection. The two of them talked a lot. The defendant was flirty. But what you will also hear is that during this first meeting, the defendant and Chad decide that they share purported religious beliefs, and that they share beliefs that the two of them had been married before in a prior probation. You will hear it talked about multi-creations or a prior probation or a prior life. But regardless of the term used, what they began to tell others is that they were essentially meant to be together. They'd been married in prior lives, prior probations. Not only that, but they both said that they had been prior figures from or persons from the Bible or other religious references. This will include that they designated themselves as James and Elena. And you will hear that they pursued this line of thought and they pursued these teachings to others to the extent that Chad Daybell wrote a story, the James and Elena story for Lori, for the defendant. And you will hear through testimony how that story mirrored some true life events that were going on between the defendant and Chad Daybell. And at the time they met, it's important to remember they were both married to other people. Their spouses were both alive and well when they first met. But again, remember, the defendant will remove any obstacle in her way to get what she wants. And she wanted Chad Daybell. She had decided that. Soon after that first meeting in October of 2018, you will hear how the defendants began communicating regularly. Their relationship moved quickly. You will hear how Chad traveled to Arizona that next month in November of 2018. He traveled for a conference, but the defendant also held a gathering at her house, and Chad Daybell was present. You will hear how shortly after, the defendant, with the help of Chad Daybell, began telling people and purporting religious beliefs and teaching people about a rating system of light and dark. The defendant told others that with the help of Chad, she could rate people as light or dark. And pretty soon this theory evolved and these teachings evolved. And they started to say, well, if somebody's dark, an evil spirit or an evil entity can come in and they can push the real person out and take over the body. And the defendant and Chad Daybell talked about how you would get rid of these evil spirits. So the first thing they did was the defendant would lead castings. And you'll hear the castings described a little different by different witnesses, but with the idea being that there was prayer and energy work. They wouldn't have to be near the person that they were casting on, but they would get together and pray or do energy work to get rid of this evil spirit. You will also hear that these castings, time and time again, didn't work. But you'll hear that these teachings evolved. And they evolved to, well, a person could be so dark or a spirit could be so evil that the person actually becomes a zombie. You can't cast a zombie out. But a common theme was the body had to be destroyed. The defendant and Chad used their self-proclaimed religious beliefs and teachings to justify their actions to others. Their actions from an affair to murder. This was especially true with regards to the defendant's brother, Alex Cox. You will hear how Alex and the defendant had an extremely close relationship. Alex would do anything for Lori. And you'll hear how when Alex would do anything for Lori, when she uprooted her life in Arizona on or about September 1st of 2019 and moved up to Idaho and moved to Rexburg to be closer to Chad, that Alex quit his job and moved up to Rexburg with her. If Chad and Lori asked it, Alex did it. You will also hear how Alex Cox was taught by both the defendant and Chad Daybell that his purpose in this probation or this life or this creation, whichever term they use, was to protect Lori. He was a warrior and he was here to protect Lori. When the defendant would talk about people being light and dark, she talked about her own daughter, Tylee, being dark. She told people this, and there's messages that she sent regarding this. But what you won't hear is anything about the defendant doing anything when Tylee went missing. There were no known actions taken by the defendant. No report to law enforcement, no missing person posters, no inquiries. Similarly with JJ, little 7-year-old boy. The defendant said he was dark. He was possessed. She told people this. There's messages about it. But again, what you won't hear is that when JJ went missing, that the defendant did anything. There are no known actions by the defendant to find JJ. No report to law enforcement, no missing person posters, no inquiries. You will hear how she described JJ's behaviors to others in an attempt to get them to agree that he must not be JJ anymore, that an evil spirit must have taken over his body. And you will hear how she was very convincing. You'll hear from witnesses how they believed what Lori told them. She was likable, energetic, and they believed her. They wanted to believe her. They wanted to follow Lori. They wanted what she was saying to be true. You will also hear how she told a friend of hers named April Raymond, who's another woman that you will hear from, that when she got divorced, that JJ would need to go live with Charles, his father. and that Charles would have to figure out what to do with them. And part of why she talked about this was that the defendant was also telling people that she was here on a mission. She was here on a religious mission to gather the 144,000. So she needed to spend her time and energy there. So JJ could go live with Charles because she had other things to do. She had more important things to do than care for her child. She expressed to people that what she did here on earth no longer counted for her. You'll hear how she'd hit her hand. Doesn't count for me. Doesn't count for me. She explained this to others by telling them that she was a translated being, and you'll hear more about that and what they taught with regards to that. But she convinced others that they were also in the translation process. Again, she's very convincing. People wanted to believe her. People trusted her. But what it really was she and Chad using their proposed religious beliefs and teaching to manipulate those around them into not questioning their actions and what they were doing. Their actions did not always comport with their teachings, and so you'll hear how those teachings evolved. They changed over time to justify or to support the actions of the defendant and Chad Daybell. You will hear how the defendant told others, because she was translated, she didn't have to repent. Again, doesn't count for me. You'll also hear how when she and Alex first moved here, Alex was setting the Wi-Fi password. He tells Lori in a message, "I set the password. Too many kids." Lori's short response, "Funny." That's before the kids went missing when they moved here. In the month or so after her children were last seen, what you will hear is the defendant went on several trips. She went on a trip to Arizona, and that trip was around October 9th of 2019. And that's a date that you will hear about. The defendant went to Arizona to visit her niece, Melanie Boudreau, also known as Melanie Pulowski, another individual that you will hear more about and you will hear from during this trial. While she was down visiting her niece, Zulema Pastenis came over. And Lori led a casting on Tammy. Meanwhile, back in Idaho, what you will hear is on October 9th of 2019, that same day, Tammy came home from work, parked her car, went to get things out of the back, and came face to face with a masked man holding a gun and pointing at her. You will hear how Tammy heard a couple pops and the gunman ran off. What you will also hear is that later a phone call was overheard between Lori and an unknown individual. Lori was mad. On October 9th of 2019, she was mad, and she made a statement along the lines of, "He can't do anything right." What we also know is that there were some phone calls that night between she and at least Chad Daybell. Not long after that trip to Arizona, you will hear how Lori then traveled to Missouri with her niece, Melanie. And while in Missouri, they visited some sites, and then they met up with an individual named Audrey Bartario, another woman that you will hear more about and you will hear from during this trial. And while they were there in Missouri, Lori led another casting on Tammy. By this time, you'll hear that the defendant and Chad had determined Tammy was dark. Tammy was possessed. She was possessed by an evil spirit named Viola. Shortly after the trip to Missouri, you will hear how how Lori then traveled to Hawaii. She traveled to Hawaii again with her niece Melanie, and Audrey joined them while they were there. And Lori was actually in Hawaii at the time of Tammy's death on or about October 19th of 2019. What you won't hear with any of these trips that the defendant went on You won't hear about JJ or Tylee because they weren't with her. They weren't with her when she went to Arizona. They weren't with her when she went to Missouri. And they were not with her when she went to Hawaii. But what you will hear about is how the defendant was still spending their money. She was also sending her other son, Colby, money using Tylee's phone. So Tylee's phone was with her, but Tylee wasn't. You will hear how when she was in Hawaii, she was in constant or consistent contact with Chad. You'll hear how just after Tammy died, she hurried back to Idaho. And just after returning to Idaho, you will hear how the defendant began to insert herself into Chad Daybell's life. It was as if Tammy never existed. The defendant met his kids, came to his house, and Chad started to introduce her to some of his friends. And you will hear how Chad introduced her to some of his neighbors a little over a week after Tammy's passing. And you'll hear from those neighbors, those friends of Chad's. And you will hear how when they were introduced to Lori for the first time, she and Chad couldn't keep their hands off each other. Tammy hasn't been dead that long. They talk about plans to get married. But maybe most interestingly, Chad Daybell makes a statement when Lori's asked about kids that she had a young daughter that had recently died. Lori says nothing about JJ. No mention of a young son. No correcting Chad on the whereabouts or if her daughter was alive or not. Just some indication about, well, I've got some stepkids. Not long after that meeting, the defendant was in Hawaii on a beach marrying Chad Daybell. They got married in Hawaii on November 5th of 2019. You will hear how the defendant had actually begun looking for malachite wedding rings as early as May of 2019. You will hear how the malachite stone was important to them. What you will also hear is on their wedding day, they exchanged malachite rings. And in May of 2019, when the defendant was looking for those rings, both of their spouses were alive and well. You will hear also how Chad Daybell began checking into adding the defendant to his to his health insurance policy. And when he went to fill out that application, you will hear how he said, no minor children. There's no minors that need to be added to this policy, just the defendant. You'll hear how similarly he was looking for a rental property for them in Hawaii. And on that application, same thing, no minor children, just Chad and Lori, just Chad and the defendant, just the way they wanted it. On November 26th of 2019, law enforcement showed up at the apartments located at 565 Pioneer Road in Rexburg, Idaho. They were looking for JJ. It was still unknown that Tylee was missing at this point. Chad Daybell was there with Alex Cox, and law enforcement made contact with them. Finally, later that same day, they were able to contact the defendant regarding the whereabouts of JJ. The defendant was less than forthcoming with law enforcement at that time. She told law enforcement that JJ was with her friend Melanie Gibb in Arizona. The problem with this? She'd told Melanie JJ was with Kay Woodcock, his grandmother. Problem with that? Kay Woodcock is the one that had reported JJ missing to law enforcement. So where was JJ? And where was Tylee for that matter? The defendant did not cooperate in locating them. Instead, when law enforcement returned, she'd cleared out her apartment and moved to Hawaii with Chad, her new husband. While Chad and Lori were starting their new life together in Hawaii, law enforcement had begun a massive search for JJ and Tylee. it became a nationwide search for those children. As they were searching for the children and beginning their investigation, they talked to Melanie Gibb because Lori had said that JJ was with Melanie. Enforcement, he was with me. What's going on? She recorded that conversation. And what we know from that conversation and what you will hear is the defendant refused to disclose where JJ was, but claimed he was happy. Claimed and ultimately ended up saying she knew exactly where JJ was. I remind you, JJ was last seen on September 22nd of 2019. This is December 8th of 2019. And I'll remind you how JJ was found. And yet the defendant's statement to Melanie Gibb was, I know exactly where he is. When confronted about Tammy's death, the defendant indicated they did what they had to do. Now remember, Chad and Lori had determined Tammy was dark. And if someone's dark and castings don't work, the body has to be destroyed. They did what they had to do. The defendant and Chad did what they had to do to remove any and every obstacle that was in their way of getting exactly what they wanted. On December 11th of 2019, Tammy was removed from her resting place to be examined. And it was determined by the Office of the Utah Medical Examiner that Tammy died at the hands of another and that the cause of her death was asphyxiation. You will hear how around the time of Tammy's exhumation, Alex Cox made a statement along the lines of, I hope I'm not their fall guy. What exactly Alex meant by this or what he knew, we may never know, because Alex Cox died the next day on December 12th of 2019. What we do know, though, is there were communications between Alex Cox, the defendant, and Chad Daybell. We know in those conversations there was discussions of people being light and dark, and we know the location of Alex's phone and Chad's phone on certain dates and times. We know that on October 9th of 2019, the day Tammy was confronted by a masked gunman, that Alex Cox's phone had been in the area earlier in the day, driving by where the Daybell residence is located. The only person Alex Cox knew in the Salem area was Chad Daybell. We know that on September 9th of 2019, the morning after the last day Tylee is seen, we know Alex Cox's phone is in Chad Daybell's backyard on his property close to where Tylee's remains are found. We also know around that same time, Chad Daybell's phone is there on his property close to where Tylee's body is found. We also know from other witnesses that Alex Cox would do whatever the defendant and Chad asked him to do. He was loyal to them to a fault. You have already heard from the state that we have the burden in this case, but I want to reiterate that. We as the state have the burden to prove each and every element beyond a reasonable doubt. You have heard that term and you will hear it again, reasonable doubt. The court is the judge of the law, and the judge will give you the definition of the law. And the judge will specifically provide a definition of reasonable doubt, and you follow his definition. But I will say reasonable doubt is commonly defined as a doubt that would cause a reasonable person to hesitate to act. And I would emphasize reasonable. The defendant is charged with multiple crimes, and you just heard him in the indictment. Conspiracy to commit first-degree murder and grand theft in relation to the death of Tylee Ryan, her daughter. First-degree murder in relation to the death of Tylee Ryan, her daughter. Conspiracy to commit first-degree murder and grand theft in relation to J.J. Vallow, her son. First-degree murder in relation to J.J. Vallow, her son. Conspiracy to commit first-degree murder in relation to Tammy Daybell, and grand theft for the taking of the Social Security monies. Again, the judge will advise you on the law, but keep in mind that when we talk about the term conspiracy, it is two or more persons combining or conspiring, so essentially a meeting of the minds to commit some crime. And then one of those actors, just one, has to do an overt act in furtherance of that conspiracy. Only one person has to do it, and there only has to be one overt act. What that means is the defendant doesn't have to be the one that physically ended anyone's life for her to be guilty of conspiracy. If you determine that there was a meeting of the minds and one actor did one overt act in furtherance of that. Similarly, in the state of Idaho, Idaho law allows for someone to be charged as a principal. When someone is charged as a principal to a crime, it can include them directly committing the act, aiding and abetting in its commission, or it can include them having advised and encouraged its commission, or commanding or coercing another to commit the crime. So similarly, when you're hearing about the first-degree murder, the defendant did not have to physically end someone's life for her to be guilty. First-degree murder is deliberate, willful, and premeditated actions causing someone to die. Remind you, and circling back, when Tylee was found, as we talked about, all that was found was charred remains. Tylee's hands are gone. When JJ was found, his hands were bound and duct taped in front of his body. When Tammy was found, those hands, she was described as a computer whiz, never going to do anything on a computer again. And the defendant and Chad Daybell getting married on a beach in Hawaii, starting their life together, all obstacles gone. Ladies and gentlemen of the jury, I thank you for being here today and your willingness to serve on the jury. We recognize that you do have a task here, and you are the judge of facts, and I would let you know that that is the most important job in this courtroom. This is set to be a long trial, and you're going to sit through a lot of evidence and a lot of testimony. What we ask you to do is be attentive to the testimony and evidence presented. Apply your common sense and reasonableness in weighing the evidence. Give every piece of evidence and testimony the weight you think it is due. Hold us to our burden, and we feel that if you apply your reason and common sense, I'm confident that you will return a verdict of guilty in this case. Thank you.
All right, thank you, Ms. Blake. That will conclude the opening statements for the state of Idaho. Will the defense be giving an opening statement now, or do you wish to defer until later?
I'll give one now, Your Honor.
All right, thank you, Mr. Archibald. You can present your opening now.
Like the state of Idaho, I also thank you for your service. This is a difficult case we have not been able to settle without you. That's why you've been called here to help us settle this case. If the court will allow a brief introduction, I know a lot about you with your 12-page or 20-page questionnaires. So I'd like to just make a brief introduction of the defense. I've been an attorney since 1991. I've been both a private attorney and a public defender. And in small county, Idaho, there's a lot of us lawyers who do both public defense work and private work. And so over the past 32 years, I've done a bit of both. I've been assigned to 27 murder cases over the course of my career, and they're difficult. They're difficult cases. I was assigned to this case. I'm paid by the taxpayers, and so thank you for paying your taxes. I've had a general practice where I do a little bit of everything, and then I get about one of these difficult cases a year assigned to me, and we do what we can. What does a defense lawyer do? We make sure that our clients' constitutional rights are protected. We make sure that the government does its job. We make sure that proof beyond a reasonable doubt is in place before there's a decision. So with these difficult cases, we resolve 99% of our cases. Less than 1% of cases actually make it to trial. And so I believe the state and the defense, we generally do a good job of resolving our disputes. And sometimes when we can't, then we call on you to resolve it for us. I'm being assisted in this case by John Thomas. He's been an attorney since 1999. He has also both experience in private law firms and public defender's offices, where he's handled many serious cases. He's received many accolades for his lawyering, and I appreciate him helping me. I also am being assisted by Brandon Hobbs. You've probably seen him, and he's an investigator, and so he's helped us investigate this case. Being a defense lawyer isn't always a popular job, and so I appreciate you being respectful towards me, and I'll do the same. I'll be respectful towards you. Some 8 years ago, my law office got bombed, and so some people are really upset by what I do for a living, and so I appreciate you and your ability to decide the facts of this case without emotion overriding your decision. So this case is about Lori Vallow Daybell. The prosecutor has just told you what the government hopes to prove throughout the next month. So what's this story about from our defense perspective, and how does this story include you? So the evidence will show that Lori was born and raised in California. She's lived in California, Texas, Arizona, and Hawaii. She lived in Idaho for less than a month before the event of what you're here to decide. She's one of 6 children. Her parents are still alive. They're retired. She's had an older sister and a brother die, and she also has a sister and a brother still living. She believes in life after death, and she believes she will see her deceased family, including her children, again. She's a beautician by trade. She's worked hard for years in that profession. She's a mother of 3, stepmother of 2, and is now a grandmother of 2 children. The evidence will show that people were attracted to her, as the state has told you. They've been attracted to her pretty smile, her vivacious personality, her fun-loving, happy-go-lucky personality. People wanted to be around her. Her oldest son is Colby Ryan. He was born in 1996 in Texas. He's a handsome young man, currently lives in Arizona. He has 2 children of his own, making Lori a grandma. Her oldest daughter, Tylee Ryan, was born in 2002 in Texas. She was a ray of sunshine. She had health problems, pancreatitis, painful and debilitating disease, but Tylee did the best she could. Her marriage to Joe Ryan ended, and a painful, long, drawn-out custody battle ensued. It was hard on all of them. The evidence will show that her next husband, Charles Vallow, was smitten with her, and she with him. He had 2 kids, she had 2 kids, and the blended family lasted over a decade. Lori was such a good, responsible mother to her 2 children that her husband's sister, Kay Woodcock, wanted her to adopt a special needs toddler newborn. Kay Woodcock was the grandma to a child born in Louisiana in 2012, a child with special needs. The child's parents couldn't take care of him because of their own personal problems. Apparently, Kay Woodcock couldn't take care of him either, so she asked her brother, Charles, and his wife, Lori, if they would adopt him, and they agreed. So the child born in Louisiana, the struggling parents, was adopted by Charles and Lori Vallow in 2014, and he became known as J.J. Vallow, Lori's 3rd child. The evidence will show that Lori was a dutiful wife to Charles Vallow. They both worked hard, he at the office and she at home. She was a kind and loving mother to her children. The evidence will show she had a particular interest in religion in the end of times. You will recognize the quote unquote end of times as something spoken of in the Holy Bible, the New Testament. Most of you will understand when I say that. Some people could care less about biblical prophecies. Some people care a lot about it. Thankfully, in this country, we get to worship how we choose. The evidence will show that once Lori and her friends met Chad Daybell, an author on religious subjects, her beliefs began to morph and to change. And that's where you come into this story, because the stories diverge. So we haven't been able to agree on what happened, and we need you to decide it. So what happened? How did these children die? Who was involved? When did it happen? Where did it happen? Why? Why did it happen? The judge has read to you the allegations, the charges. And so they were read to you 2 weeks ago when you showed up to fill out your questionnaire. They were read again today. And I'm going to read parts of them again because I think it's important to see what she's charged with. You don't have to write these down, by the way. The jury instructions will be with you in the jury room. Some of you are really good note takers, and some of you will let others take notes. But you don't need to memorize what I'm telling you, because these will be printed out and handed to you in the jury room. So the charge of conspiracy: Chad, Lori, Alex, deceased. Other co-conspirators, both known and unknown. So Chad Daybell is not on trial here. Alex Cox is not on trial here. He's deceased. Other co-conspirators, I don't know much about that, both known and unknown. So again, your focus will be on the actions of Lori, not on Chad, not on Alex, not on co-conspirators, both known and unknown. So that's the conspiracy. I think first-degree murder, the allegations contained in the charge that the judge read to you, was Lori Vallow concerned in the commission of first-degree murder? Did she aid and abet? Did she assist somehow? Or the language of the charge says, or not being present. Did she advise and encourage it to happen? Or by command compelled another? So this charge is, did she kill? Or did she assist? Or did she encourage? Or did she command? So in other words, this charge is saying they're not sure what happened, but yet they want you to be sure. The same with count 3 and count 4 with JJ. Count 5 with Tammy. Did she combine or conspire to commit murder? Did she do the murder? Or did she talk about it? Or did she do something about it? Or did she do an act in furtherance of it? So that's the challenge here for you, is you're going to be given all these alternatives, and you're going to have to be convinced beyond a reasonable doubt. I didn't make up the definition for reasonable doubt, neither did the judge, neither did the prosecutors, but that's our law. He read it to you 2 weeks ago and again this morning, and here it is. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. The state must prove the crime beyond a reasonable doubt. A reasonable doubt is not mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence, or from lack of evidence. So if you have a lack of evidence, sorry, all these papers in here. I lost my way.
Meet Litter Robot, the revolutionary self-cleaning litter box that eliminates the chore of scooping.
So there's something called an alibi that was filed as part of this response, part of these allegations. So here's the alibi that was filed on Lori's behalf. Lori Vallow was in her own apartment in Rexburg, Idaho, when J.J. Vallow died at the home of Chad Daybell in Salem, Idaho. Lori was with Melanie Bedreau and or Audrey Baratario in Hawaii. So that's the alibi filed in this case. And a lot of jurors were excused in this case. And start this trial with Lori with a clean slate. You're here to focus on what she did, not on what Chad Daybell did or what Alex Cox did. You're here to determine if there even was a conspiracy. Cases, again, can be solved with evidence. They can be solved with lack of evidence. And when there's lack of evidence, the law calls it not guilty. You said you would be fair and impartial. You said you would have an open mind to not judge her until you heard all the evidence in this courtroom. You said you would do your duty, and I believe you. If what the state has alleged here cannot be proven beyond a reasonable doubt, you said you would find her not guilty. Thank you for your attention.
Oh, wow. That ended. So, I'm not sure what to think now. We've still got Jim Archibald droning on. Let's see. We've got Archibald to say Lori is the killer because they found a piece of her hair on duct tape. That is simply not true. All you mothers, I would hope you know your hair is on your kids' clothes, blankets, etc. He's right about that point, but I think it's a little bit different when it's in, if he wanted to argue that, he should have done that presenting it as a on cross-examining witnesses or presenting the case to Lori himself, but instead he chose to forego. Says you heard her lie about where the kids were, so why was doing that? To protect Chad. He was her lover and her eternal companion. So how can someone have so much control over you? Sometimes when religious principles are involved, common sense goes out on the children. If Lori was planning on killing her kids, why wasn't there an insurance policy on them? Chad had one on Tammy. Well, because that's a little too obvious, and they wanted to collect the Social Security for years, and that would probably add up to more than the insurance would have. Let's see. Planning to kill her kids a week later. Why would she do this? Why would she enroll him in school? Because Lori didn't do that. The state wants you to believe that Lori planned to kill her kids. Look at Lori's rental application dated August 2014, 2 weeks before she moves to Rexburg. Exhibit 82A is a rental application where she lists that she had 2 kids, Tylee and JJ, that she is living on Social Security income. So if you're moving from Arizona to Idaho, why not just drop off the kids somewhere else? Why bring them and enroll them in school? Well, Jim Archibald, because she wants to get the Social Security monies, and dropping them off somewhere else like the Woodcocks would mean she wouldn't get Social Security for them. So, good try. Let's see, Archibald. You heard from Colby say that his mother would never do this. You heard her say completely changed after meeting Chad Daybell. So the call was so painful, Archibald tears up and his voice cracks. Such a painful call. Poor Colby. Yeah, Let's turn on the waterworks, Jim Archibald. Says, who was in the backyard? Chad and Alex, but not Lori. Summer herself said she supported Lori all her life. Chad lied to her. Chad deceived her, and that's why what Summer said to her sister. Well, I disagree, because she told them on the rental application in Hawaii that they were empty nesters. And, the too many kids, and she's done with JJ. I'm not buying it. So, you have to guilty, death penalty. Her kids didn't have a chance. No, they didn't. She should have the death penalty, but they were very clever in the strategy of not waiving the speedy trial. In the Dylan Rounds case, I've said it all along. That's why they didn't charge Jim Brenner sooner with the murder, because he could insist on a speedy trial. They don't have a body, and they don't have all the evidence in place. So, there are advantages to it. So, let's see. Let me look and see what we've got. If we've got any commentary going on. Let's see. We've got this.
Has obtained exclusive video in the case of so-called doomsday mom Lori Vallow. She's on trial in Idaho, accused of murdering her children.
The evidence is from January of 2020, when the former Arizona mom refused to cooperate with law enforcement in the search for her 2 kids who were missing. Authorities would later find her with her new husband vacationing in Hawaii. Fox 10 investigator Justin Lum reports on this exclusive video.
Flashback to January 25th, 2020, just a month before Lori Vallow was arrested on 2 counts of child abandonment. Looking at it now, it's bizarre to think JJ Vallow and Tylee Ryan had been dead for 4 months as their mother sat poolside with her new husband, Chad Daybell. Detective Colin Nesbitt and other Kauai police officers located them near the condo they rented in Princeville, Kauai. The newlyweds getting a tan.
Do you have any questions regarding that?
Back then, authorities in Idaho and the FBI wanted to know her kids JJ and Tylee were safe. Vallow was served with a court order from Madison County, Idaho, to physically produce the children to the Department of Health and Welfare in a week. In the video, Vallow shakes her head at the paperwork, and Daybell looks on.
Do you need something? Any questions? You have any questions for that?
Just a day later, the public would learn where the so-called doomsday couple was spending their time. And months later, authorities discovered the remains of JJ and Tylee on Daybell's property. For Vallow, child abandonment charges turned into 2 counts of first-degree murder and 3 other murder conspiracy charges in connection to the kids and Daybell's first wife, Tammy. Throughout trial, prosecutors have called witnesses testifying that Vallow identified the children as dark spirits or zombies. This video, just one of the state's exhibits to show Vallow was a suspect early on in the investigation with no sign of her own children. I'm Justin Lum for Fox 10 Investigates.
And that was more than 3 years ago. Tomorrow, the court.
Okay. Let's see. Oops, I need to. Let's look at. Let's see.
There's new witness testimony today in the Lori Vallow Daybell trial.
Prosecutors presenting new evidence to the jury, including a key phone call between Lori and her husband, Chad Daybell. Daniel Woodruff is live in Boise, Idaho, where he's been all week long with the very latest from the courtroom. Daniel.
That phone call between Chad and Lori Daybell zeroing in on the search for and eventual discovery of Lori's 2 children. Their remains found on Chad Daybell's property. Also today, new testimony about the investigation into the suspicious death of Chad Daybell's longtime wife.
Are you okay?
So they're searching the property.
This is the phone call jurors heard in court from June 9th, 2020 between Lori and Chad Daybell.
What? Yeah, sorry.
Not long after this call, investigators found the remains of JJ Vallow and Tylee Ryan on Chad Daybell's property. Both he and Lori are accused of killing them. Also today, Fremont County, Idaho Sheriff's Lieutenant Joe Powell testified about the investigation into the death of Tammy Daybell, Chad's longtime wife.
Because of all the suspicious circumstances.
Jurors saw photos of Tammy's body being exhumed in Utah and just before her autopsy. Prosecutors say she died by asphyxiation at the hands of another person. The defense, though, pushed back.
Are you aware of where Lori Vallow was when Tammy Daybell died on October 19th?
No.
Okay. Would it surprise you to know that she was in Hawaii?
No.
Inside the courtroom all week, Kay and Larry Woodcock, grandparents to JJ Vallow, Lori's son.
It's going very smoothly.
Outside the courthouse today, Larry spoke to reporters.
This is not about me. It's about those children and the 4 people that were murdered.
And after that witness testimony today, the judge here ended up sending everybody home early at the request of prosecutors. One of the prosecutors had a death in the family. Trial will resume here at the Ada County Courthouse tomorrow morning.
Okay, I thought that was going to be the full phone call. Let me see. Let's try this one instead.
Let's just take a moment here off the top. I mean, Right. People always say, just a preliminary hearing. This was a whole lot more in the course of the last 2 days. Absolutely shocking details and incredible information coming out of that courtroom.
Absolutely. It was something, 2 days of testimony, 12 witnesses to help the prosecution establish this probable cause. And likely, Vinny, not even all the prosecution has against Chad Daybell, because it still is a preliminary hearing, but enough it thought to meet this burden. And the judge agreed, saying that there was enough for Chad's case to move force from Melanie Gibb and her boyfriend David Warwick, who are key to the prosecution helping prove the conspiracy in those overt acts, the alleged deceptive actions on Chad Daybell and Lori Daybell's part to conceal the whereabouts and the remains of JJ and Tylee, jam-packed full of not just testimony, but also recordings from Lori Vallow on a body cam, phone calls recorded, jailhouse phone calls, like you mentioned. A lot learned over the last 2 days.
Well, let's get right to that, because today I was floored. I had no idea that they were going to put into evidence today a phone call between Chad Daybell and Lori Vallow Daybell. I mean, I don't think we've really heard them communicate. You know, they were talking with Melanie Gibb on that call from yesterday, but this is like in, you know, a moment that you wouldn't expect, because the search is taking place at Chad Daybell's home on his property. We now know what they're going to find, and I would think that Lori Vallow Daybell and Chad Daybell may have had an idea what they were going to find. Let's take a listen to that phone call.
Hey, Mom, age 9 to 13. It's the best time for you to communicate how wrong underage drinking is for their brains.
That's funny.
Hi, Dad.
Hello.
Are you okay?
So there's such a property.
The house right now?
Yeah. So Mark Mills will be talking to you.
Okay. What, are they in the house?
No, no property.
Are they seizing stuff again?
They're searching. There's a search warrant, and so we're gonna get on with the kids.
Okay.
Yeah. So you tried to set up a call, logic call.
Yeah.
So we'll see what transpires.
Okay.
You know,
What do you want me to do? Pray.
well,
What do you want me
yeah,
to do?
Yeah.
What can I do for you?
I'm doing pretty calm. I would call Marco maybe. Just talk with him.
Have you talked to Harding?
I'll then call him, yes.
So he knows what they're doing?
Yeah. It's okay. Call from somebody else I need to talk to. I love you so much.
Okay, I love you. Should I try to call you later?
I don't know. I don't know. I can try, yeah. I'll answer if I can.
Okay.
I love you, and we'll talk soon.
Okay, baby. I love you.
Okay, love you. Goodbye.
Ooh. I mean, I could hardly understand what Chad Daybell was saying in a lot of that, and it just sounded like he was really down and out. Chanley Painter, what are you taking away from that phone call? Because, knowing what we know, and I'm listening to him, it sounds like they're like these pauses where there's no conversation. It's like what they're not saying is so loud to me, like, oh boy, they're searching. Uh-oh. What'd you take away from that call?
Exactly. What stood out to me, while a lot of it is inaudible and they don't say a lot of details, it's the tone, the somberness of Chad Daybell's voice. We heard his voice yesterday in the phone call with Melanie Gibb, much more upbeat, normal type of voice that we would think of with Chad Daybell. This was quite different in this recording. And I think that makes a statement in and of itself. There are a lot of long pauses, but they know they're being recorded. So I'm sure that was in the back of their mind to be careful what they said.
Yeah, just a little bit of advice. If you know you're being recorded and you know the bodies are in the backyard, you should be like, I don't know, they're here, they're searching. I don't know what they're looking for. They're digging up the backyard. I don't know why they're digging up my backyard. This is crazy. I mean, but that didn't happen. That did not happen. This is unreal. So, Chanley, give me the big picture. This is a huge moment in a huge case. We've been following it here at Court TV for 7 months now. And now finally a lot of the information coming out through testimony. But we're in the middle of a shutdown and there's limited access, everything else. What was it like at the courthouse? Because I know what it would be like if we weren't in the midst of what we're in the middle of. So what was going on there at the courthouse as all this is taking place?
Well, the COVID-19 restrictions limited access to the courtroom. As you can see there, basically we have the grandparents of JJ, which is Larry and Kay Woodcock, sitting there with the victim's advocate of the prosecutor's office escorting them in and out. And then other court personnel, other than the media with permission, Court TV pool cameras. That was it allowed inside the courtroom. But outside this Fremont County courtroom was a buzz. There was media from all over the nation here, Vinny, out set up, staked out to try to catch people entering and exiting the courthouse throughout the day. We would even though the deputies here tried to block the walkway from the jail to the courthouse where Chad Daybell would make his entrance and exit a couple of times a day, they tried to block our view. There was still sometimes we could catch a glimpse of Chad Daybell. He would be escorted by sheriff's deputies wearing a bulletproof vest, which is the norm for high profile cases here, and carrying his notepad, which I did see him use today inside the courtroom. So definitely a presence here for this case. It's very high profile and a lot of precautions, not only for COVID-19, but because this is probably one of the biggest cases they've had here in Fremont County.
All right, another, and I don't know if it was bizarre or I just wasn't expecting it, and that was the cross-examination of Melanie Gibb. Melanie Gibb, to me, the star witness for prosecutors, because she can take us places that investigators can't go, which is inside the world of, and inside the house, literally, of Lori Vallow Daybell. But there was a part of the cross-examination I want you to take a listen to here, Chanley, where she's talking about the relationship between Melanie Gibb, not in Lori Vallow, not in Chad Daybell, but the relationship between Melanie Gibb and her best friend at the time's daughter, who is the victim, and one of the victims in this case, Tylee Ryan. Let's take a listen at how that went.
And obviously correct me if I'm wrong, but you had a poor relationship with Tylee, and isn't that correct?
I would say I had pretty much a no relationship with Tylee.
Right. She didn't care. Well, all right, I want to strike this because I don't want to misrepresent. Both of you weren't particularly fond of each other. Is that correct?
Objection asked and answered.
That hasn't been asked and answered, Judge.
Overruled. I'll allow the question.
You and Tylee were not particularly fond of each other. Is that correct?
I don't know how she felt about me, but I did not have a relationship with her. I would not say that.
Okay. Okay. But it's no surprise that she didn't necessarily want to be around you, did she?
Objection calls for speculation. Sustained.
You could really care less whether you were around her as well. Isn't that true, ma'am?
Not necessarily.
Okay, well, if it's not necessarily, does that mean yes, no, or you just don't want to answer?
Objection, argumentative.
Sustained.
How would you describe your relationship with Tylee, other than not at all? Did you care to be around her or not?
Very
Objection
little.
asked and answered.
Okay. I'm fine,
Sustained.
Judge. I'm going to move on.
Things getting a little dicey in there. Chanley, two things. One, the tone of the cross-examination seems to be very accusatory. And then you put on top of that, pointing out that there's a lack of a relationship or a bad relationship between Melanie and Tylee. I mean, do we think that the defense might actually go there and perhaps point a finger at Melanie Gibb, the state's star witness, Lori's former best friend?
Who knows what the defense, it could be just building blocks for something they want to bring up in the future, but it was intriguing as to why the defense attorney, John Pryor, would harp on this relationship between Tylee Ryan and Melanie Gibb. When Melanie Gibb visited Lori Vallow Daybell last September for the weekend with her boyfriend, David Warwick, they saw JJ Vallow, but they did not see Tylee Ryan, and they testified to that. Lori telling them that Tylee was a student at BYU, Idaho at the time, and no cause for concern there. They believed that. Maybe that was sort of a reason why Melanie Gibb wouldn't think twice about it. She maybe wasn't fond of Tylee. And as we've covered this case over the last several months, Vinny, we've heard from the Woodcocks, who also told me in an interview back in May that Lori and Tylee really didn't get along either. So it's interesting, not sure what trajectory the defense is going towards with this type of testimony, but overall the tone of that cross-examination this morning between John Pryor and Melanie Gibb on the witness stand, it was tense at times, argumentative. She was defensive, he was defensive, so much so the judge had to step in a couple of times to calm things down.
Yeah, it was fascinating to watch. Again, in a preliminary hearing, could you imagine what's going to happen in front of a jury? Because you ramp it up another 10 notches. Okay, folks, Chanley's going to stay with us. She's not going anywhere. She's out there in Idaho for us.
This is a recording on December 8th at 3:43 p.m. And I am calling Chad Daybell's phone number, and hopefully I will be talking to both of them, Chad and Lori. So here goes the phone call.
Hello, sweet Melanie.
Hi, Chad. Hey, Lori. How are
Hey,
you?
let me put on speaker.
Oh, okay.
All right.
We're enough with the phone.
How are you guys?
We're okay. How are you doing, babe?
I'm doing pretty good, thanks. I was wondering, where are you guys?
We're just hanging out.
Hanging out? Are you in Idaho?
We're doing all right, Idaho.
Oh, okay. I just wanted to ask you a question, if you don't mind, Lori.
Yeah, of course.
I want to know, you remember we talked about JJ going to Kay's house, and you told me they went there, and now he's not there? I was wondering what happened.
Well, I had to move him somewhere else because of her actions. So
Was she doing something? Like, was she trying to come get him or something? Or like trying to kidnap him?
well, she said that lots of times before, but
Okay. When I asked Chad the other day, I was like, hey, where is JJ? And he said, for my security, he didn't want me to know. So is there a reason I should be in danger to know where he is?
no, it's nobody. It's his danger. It's the danger that there's people after me.
Okay.
We just felt that if you knew, that puts you in a danger.
Well, just in a bad position.
Yeah, bad position.
Everybody, if they don't know anything, then they don't have to say they know.
Right. So you're just worried. Okay.
I'm just to keep him protected and
keep you protected.
keep everybody else good.
I appreciate that. Well, I was wondering why you told the police why he was with me.
I just needed to have somebody so I wouldn't have to tell them where he really was, because they were going to tell Kay where he is.
Oh, yeah. So do you think it's like your family, or, like your family, your dad, or, those
my
people?
family, well, not my whole family, but as you know, most of my family is working against me and with her, basically.
Yeah. Is JJ safe?
He is safe and happy.
Okay, well, that's good to hear. Are you afraid of anything? Like, are you afraid to tell me that you're just afraid that that I could be in danger? Like like I don't, like if I knew, like how could that hurt me? I don't understand how that could hurt me if I knew where he was.
Well, I'm just not telling anybody so that nobody has to say where he is or get questioned to where he is, so I can keep him as safe as possible.
Yeah. Okay, I hope that he's okay. I hope you guys are okay. I did have a question that I asked Al at one point, your brother, if I wanted to know, like where he was, and he said I did not want to know, and that he could not be found. So what does that mean?
I don't know why he would say that, but it's the same story. Like I don't even want Al to know. I don't want anybody to know, so that nobody has to be worried about it. I mean, nobody has to be questioned about it, so he can be safe.
Yeah. So how long are you gonna be away for? Like are you ever gonna be able to come out and come back to society again? Or are you gonna keep, come back? I mean, like, what does that look like?
I will do whatever the Lord needs me to do every day, so we'll see.
I just wondered if I was ever going to see you again.
Absolutely, you will.
Okay, so maybe when they're done chasing you, you'll be able to come out again, or?
Yeah, I mean, it's a ridiculous thing for them to be working with Kay to find me. There's nothing that's gone on that's, you know what I'm saying? Like, they're working with her in some dark capacity. The police are working with her in some dark capacity. There's no reason for them to be after me in the first place.
Yeah, has she threatened you at all?
Yes, lots of times.
Oh boy, like what did she say?
Well, it's in emails and everything.
So like she said she was going to come take him, or she was?
There's a lot of things.
Yeah.
Nellie.
I know it sounds like it. I'm just worried for you guys because, he's missing, and
I know exactly where he is. He's perfectly fine and happy.
Okay, well, I hope so. I have a scripture I wanted to share with you, if you don't mind.
I'd love it.
I was thinking about some of the things you guys have gone through, and I saw this scripture today, and I want you to
Let me ask you a question. About scripture. Okay. So, did Alma turn himself into King Noah, or what was he required to do?
Well, King Noah was incredibly wicked.
Yes.
And so he fled his evil ways, which was adultery and living riotously and breaking all the commandments.
Right. So what was he required to do, Alma?
He had to go and flee so that he would be safe, and then help other people realize how jacked up the system was and the government was.
What about Moroni? What was he required to do at the end?
To carry on those plates and bury them. That was his responsibility.
What did he have to do to do that? Did he hide?
He had to hide. He had to hide because they were so Everybody was killing everybody in this society. Everybody was dying. They were killing all the natives.
Felt in the scriptures had to hide in the cavity of a rock by day and go out by night.
The prophets did.
They did.
Yeah. Okay,
So
well, thank you for sharing that with me.
Scripture.
Okay, this scripture is just something that may be thoughtful for you. For behold, this is Doctrine and Covenants, section 3, verse 7 and 8. It says, for behold, you should not have feared man more than God. Although men set not the counsels of God and despise his words, yet you should have been faithful, and he would have extended his arm and supported you against all the fiery darts of the adversary. He would have been with you in every trouble. So when we work with the Lord and are obedient, He's going to protect us from adversarial darts and all kinds of negativity. But when we open the door to Satan, he comes in and then he attacks. And then he takes away to make it look like somebody else took it away. But that's not how God works. He doesn't work in darkness.
I agree with you 100%. And that's what the Lord is doing for me. Exactly what he's doing for me.
Oh, it just sounds weird.
Open the door for darkness now. Darkness is knocking on the door all the time because that's the way dark works with the light. And I promise you that I have done nothing wrong in this case, but sometimes you have to hide in the cavity of a rock for your own life safety. And that's what the Lord requires of you sometimes. And that's how it is. And I'm sorry that's how it is, because there is a lot of darkness on the earth.
I know.
It's been after me for zero reason besides the darkness of Kay, which you already know she's dark.
I haven't met her enough to know if she's dark or not. I've just met her slightly, and she seemed like a normal kind of person, but then I haven't engaged with her that much, so I don't know that personally.
So you don't know about her changing the thing for herself to be the beneficiary of the policy and all that stuff. None of that's dark, right?
Well, I haven't seen those documents, so I have no way of knowing.
You've seen them on my computer.
No, I have not. I haven't even looked in on your computer before. You haven't showed me anything.
I don't know why you're being controversial to me, or if you're recording this conversation for the police or whatever. I don't know what your intention is on this phone call.
Well,
but I love with all my heart, and I have forever, and I will always.
I appreciate those words, but if you really loved me, you wouldn't have told the police that I had JJ with me. That's not what a friend does. I mean, that just makes me look weird, and it's not safe for me. That doesn't look good. I mean, you had to think of my welfare if you love me.
I do, and I did exactly what I felt the Lord was instructing me to do. And I appreciate you, and I love you. And I never do anything.
I'm going to pause this. We've got a thing with Nate Eaton here. It says jury begins deliberations at Lori Vallow trial. So let's check that out.
There were so many witnesses talking about how she used to be a good mom. She was a good mom. She loved those kids. She was so symbolic that, even the Woodstocks wanted JJ to live with her and all of that, that's who she used to be prior to the new belief under Chad and the person that she became with Chad.
Tell me the question you was walking out, because I'm sure our viewers are asking too.
What happens next? How do they determine the jurors and who the 6 that leave? Are they going to do that in public, or they do that in private? And when does that happen?
So from what we understand, there's 18 jurors that are still in there. Not one has left. They assume that one might get sick or have a death in the family or something, but they've all been there, but only 12 will deliberate. And so the judge will at random pull numbers out of a hat, and these are the 12 that will stay and these that will go. And we understand they will do that after the rebuttal. And they will do it in open court. I believe we will know. So there's those 6 jurors that have been here for, 6 weeks. They won't get to give their thoughts. Did you want to say anything? Were you inside?
I was, yes.
What did you think?
I agree. The prosecution did great. The defense, I think honestly it was the worst closing I've ever seen, ever.
Why is that?
Well, I just didn't feel like he gave any facts. Where were all the texts from Lori about after? Where are my kids? Or why aren't my kids still here? Or where are they? Or I'm sad that they're dead. She never once said anything like that. If I was, obviously didn't happen, so he couldn't bring that up. But It was just, there was not a lot. And I didn't understand the crying. That seemed give me a little bit of sympathy.
You mean when Jim Archibald got emotional?
Yes.
You think it was a sympathy play?
I do, because he wasn't really talking about anything, you know, and it was.
What stuck out to you about the prosecutors, their opening or their closing argument? Was anything just hit you?
I really liked the timeline and going over all of the points, the important points. And I think it was very organized, very easy to understand. And it really painted a picture.
Well, we'll let you guys eat. I know we're on a time crunch and I have to eat too. Thank you. Did you want to, let me talk to you? You don't want to say anything?
I'll
okay.
say something.
No, you won't. No, just talk to me like the camera's out here. You've been here a few days.
A lot.
And what have you thought?
The closing in particular,
Yeah.
I'm going to ditto what they said, so nothing different. Prosecutors, I think, nailed it, really painted that really clear picture that summarized everything really well. Defense, I just don't think they have a defense. Yeah. And you could tell, at least my perception was, Lori looked angry. Like she looked maybe disappointed or maybe surprised by what he was saying, which I would think she would know what the defense is going to say, but she looked very annoyed.
One of the things that I just said, you all didn't hear because you were up here, is this seems to be kind of the one part in the trial where they kind of went after Chad. They haven't really done that. Have you noticed that?
I think the defense has brought that up in previous or when they were cross-examining or when they were bringing their case, but today for sure they were so focused on that. And I absolutely, I think Chad is guilty, and he had a big part of this.
Rex.
But Lori
Sorry.
knew what was going on. Totally is guilty of this crime.
Speaking of Lori, this is Lori's uncle.
Yes.
We're gonna chat with him. Hey, Rex, thank you, ladies. Can we come down here? Sure. Can I ask you a few questions? We're live right now. So let's have you right here, just so you look good. So you came back into town. For those people just watching, this is tell everybody who you are. This is Rex Connor.
Rex Connor, Lori Vallow. I like to say I'm JJ and Tylee's great uncle, but I'm Lori Vallow's uncle, her mother's brother.
You were here earlier in the trial. You came back today. What did you think of closing arguments?
I thought the defense did the best they could with what they had. I think the prosecution did an excellent job laying it out, summarizing, taking us all, well, they didn't do it for us, but taking the jury step by step through the evidence.
What about the defense?
I think they did the best with what they had, which was almost nothing.
Yeah, almost nothing. Were you watching Lori at all while they were?
I was.
And?
No change in her demeanor. Same way it's been the full trial, I believe.
Yeah. What's been your overall take? How do you think the jury's taking all of this in?
That's the big question, isn't it? We'll find out when they come back with a verdict. I don't have any insight to that. I hope it's like the rest of us, but you just don't know with the jury, do you? So I can't imagine. I've tried to imagine. I've really put effort into it. My whole family has. We talked about it. I can't imagine that they would see it any differently than the rest of us. And everyone I've talked to sees it pretty much the same. It's pretty clear what Lori and Chad did. Although we don't know all the details, we wish we did. We wish we'd get some more insight to that. We probably never will, but it's pretty clear how evil this is. We just don't know why they did things that evil.
Yeah, that's the question we'll probably never know the answer to. Any prediction on when the jury will have a verdict?
It would surprise me if they deliberated longer than it takes to drink a can of soda.
Wow, that quick.
Well, I just can't imagine. I know I've had the opportunity one time to do jury duty, nothing like this, but it was a real obvious case also. And we tried to deliberate. There's one person with some reservations. Well, I don't know. And so you go through the thought process, but even that person felt like it was pretty clear. Yeah, when you put it that way. And I think it's all put that way. So
you think we could have a verdict today by 5 or 6 o'clock?
Yeah, I don't know that. Sure. Well, of course, none of us know it, but I think that's entirely possible. just because the case I feel was so strong in the way they presented it and the context in which it was presented in the instructions. It's pretty clear.
Anything you want to say to people watching, Rex?
This is my theme. I'll never not say thank you to y'all in the media, to Kay and Larry in particular for getting this started. Who knows what would have happened had they not cared enough. But now the millions of us that have been touched, and I'm no different in this group because I'm family, all of us have been touched by it. We need to heal from it. It's scarring. See those pictures or to hear what happened, it offends our senses, our sensibility. My family doesn't think we'll find complete justice, no matter what the sentence is. You just can't find enough justice for people that have done what they did. When I was listening to a podcast last night, when you went over the affidavit again, and I noticed it said those 3 conspirators plus other known and unknown conspirators. We hope that everybody that is guilty of any part of this process of doing that to these 4 victims in particular, any other victims they may be, receive the brunt of the full extent of the law. But for all of us, the millions of people this case has touched, we're so grateful for all the law enforcement people, the thousands and thousands of hours, the media people that have kept this process or kept information flowing, that have taken an interest, have gone above and beyond the call, like you, Nate. We're just grateful for everyone that's been involved to bring justice to these people.
Thank you, Rex. Good seeing you. Go get some lunch. We'll see you back in there.
Thank you.
All righty. So there you have it. Let me just kind of paint the picture really quick, give you an idea. We'll scoot back, Kalama. Hi. Oh, hi. How are you? We're on live right now. Have you guys been inside the trial?
Yeah. Yeah. We went inside the building.
We brought Larry and Kay a picture of Tylee and JJ.
Oh, nice.
Give it to them today when they.
Oh, you did? Yeah, we gave it to them.
Good.
It's Scott, my little grandson.
Oh,
he died 19 years ago. And so for 30 years, I started doing it before. And then after he passed away, that was my way to honor him. So whenever a child is killed or died, then I find out where they live and I do a picture, a 3D picture. And then I take it to their home and leave it on their porch.
Oh, wow.
So they never know where it comes from. This is the first time they knew where it came from. So.
Well, that is very kind. I'm sure that they love that photo. I'll have to catch up with them upstairs and see if I can find it.
Yeah, she put it down on the 3rd floor. I think she left it down there. But yeah, we gave it to him. She kind of fell apart. I felt bad, but it did what I wanted to do. It was for
God bless you.
Yeah.
Good to meet you.
It's fun to watch you.
Well, thank you. I'm going to finish my live report and then we'll catch up. Let me show you really quick, just give you an idea. So media from all over the places here. You've got media on this side. We're going to do a 360. You've got media. This is quite an increase in the presence of reporters who are here. And I want to tell you, we're going to keep you updated today. The second that verdict comes out, we're going to send out a push alert. If you have downloaded our app, if you have not, download our app. It's free. It's on the App Store. We'll get a push alert out to you the minute the verdict comes in, and we'll have a heads up. I'm told we're going to get a news release that says the verdict is in. And right when we get that release, we'll have 1 hour to get back in the courtroom and get settled. And then we will broadcast that verdict to you live. Wherever you're watching from, we will have the verdict on that channel. So stay with us. We're going to go have lunch because we have to be back there in 10 minutes. So thank you for watching. I'm Nate Eaton. I'm going to tell the other Nate he can cut it now so that I don't stand here for the next 10 minutes looking foolish. So Nate, cut it off. Thank you. We'll be back soon.
Oh, let's see.
I've been waiting 5 months to talk to you, and you've been hard to find.
I know.
Would it be fair to say that you've been in hiding?
Yes.
Why?
When you realize.
Okay, we're going to switch back to the phone call here. Let's see.
To harm you, and And you can have all of this confirmed to you by the Lord.
I have. And my conscience is clear. I feel very understanding what's really going on, Lori. And I believe that you have been very deceived by Satan. I believe that he has tricked you. And I don't believe that what you're doing is correct. I just don't. I mean, Tammy dies, and then your husband died, and then he's missing. It just doesn't sound like God's plan to me. It just sounds. It gives me a gut feeling. Like in my gut, it feels weird. It doesn't feel right. I don't have peace about it. I never have felt 100% peace about it. I always felt like a little weird in my stomach about all these things.
You know me, Mel. You know me. This does not sound like you. This sounds like you've been influenced by somebody dark who wants you to believe dark things and have fear of the celestial world.
I don't have fear.
You obviously do.
No, I have a peace of conscience and I can see clearly.
Well, I'm sorry that you feel that way. I love you so much.
I know you do. I don't know what else to say.
Stand Christ when he comes again, and he's coming soon, and we will all stand there, and you will know at that point that he has supported me and has supported me the whole time, and I have not been deceived.
I just want to testify that
People actually mentioned they were worried about the verdict. My opinion is the same as Ray's. So we did not talk before, but that's what I'm feeling too. And I think it's what most people are feeling. I think that she'll be guilty on all counts or found guilty, but we will see. We will see if that's the case.
So briefly, ladies and gentlemen, class lady.
Oh.
We're all real lucky to be able to have you here to cover this, and we'll see you next year when Chad doesn't have his trial because he's going to plead.
Thank you. I'm sending this to my mom now. So thank you.
Okay, Mom. See ya.
Okay. Thanks, Ray. Thank you. Yeah, I agree with Ray. And I think it's pretty clear to me what the verdict's going to be, but we will see. We will see. The defense followed. And after the defense came, I will say that I felt they did a good job. Well, I've got another gem with me. Did you feel like the defense? I mean, look, I know that you're probably pro-prosecution. Here's Annalise, but do you feel the defense did a good job, or is that too hard for you to even say?
No, I feel like they did. I feel like there were moments where they said things that I was like, yeah, you're right. Like that's pretty accurate.
They made good points. Even
So
I rethought some things. I was like, true. Yeah.
considering the fact that it didn't feel like they had a defense, and they really don't, I do feel like he did a good job. I also think that I feel like Jim Archibald really did speak from his heart. I think some people may think, oh, that was kind of phony or that was not. But I want to believe that he really is a good person. This is his job.
I agree with you. So you can feel confident what you're saying.
Yeah.
There are times where people will hear today that he got emotional during audio. And we always wonder, right? That's what we do in the true crime world, is speculate, what tears are real, what are fake, what's a show. I actually also believe it was genuine, and it was a little unexpected, I think, when he got emotional.
Yeah.
I don't think it was a show.
I do have to say there were moments where I was bored.
Yeah.
I hate to say it, but I was like, oh, don't fall asleep.
That's okay. Honesty.
Yeah.
You're also a mother with a break right now.
Yes, yes.
So you probably need sleep.
Yes, exactly.
So, yeah, thank you. What else you want to share? Anything else you want to share that you felt was important to point out?
I do think it's going to really be hard for this jury when there are 6 of them that don't get to deliberate. I was observing them because from my seat today, I can't see Lori, I can see them. And there were some of them who I noticed things that almost seemed like a nervous tick, but I think it was because they were feeling so much emotion. And others who you could just tell they're listening. They're so intently focused on this, taking this completely serious. I think they're all taking it seriously, but I imagine if it was me, I would have a very hard time coming back, finding out, hey, sorry, thanks for staying with us all this time, and then not getting to deliberate and say, no, here's what I think and here's what I believe from the evidence. So that's hard.
Thank you for sharing that. Yeah, I see the jury. Like, again, I'm sitting really close to the jury. I can see the jury better than Lori, Vallow, Daybell, but I'm so busy live tweeting on my phone, and we have to keep our phones down. There's no keeping your phones up. And so I do rely on other eyes. So thank you for sharing that. It has been this jury has been intently listening and intently watching. I know that Gigi with Three Lies and Alibis agrees, and so it's interesting that that's what you've seen. Is they've been an emotional jury. They've cried at times. I can imagine, and today is a really emotional day. It's like going through like all the most. I mean, that's what they want to do in arguments and final arguments is bring emotion to the table, and both sides were definitely bringing emotion to the courtroom today. So it was overwhelming to say the least. So. Thank you. Thank you. How are you after seeing photos and everything? I know that those were kind of unexpected today.
I actually did expect them because I figured, how do you really get your point across without showing those again? And I read very explicit tweets about what was shown and wasn't in the courtroom originally.
Yeah.
Cried with that. Saw JJ and instantly started tearing up thinking about my baby. And then it was when I saw Tammy that I just tears down my face. Her aunt and cousin, I believe, are in the courtroom, and they broke down crying. And that was very, very emotional. I looked at the jury and I didn't notice any of them crying, but there was one woman who the frown never left her face. So it's heavy, like really heavy.
There was a moment when I tweeted, I heard tears and I couldn't see who they were from. And that actually was, Tammy's side of the family. It took a while, and I never shared that. So thank you for sharing that. Yeah,
but those were my takeaways.
Yeah, I also got emotional when they showed the photos, and to see Tylee. You saw Tylee too, and and could you see the marks or pelvis?
That was honestly really horrific, because when you read a tweet or even listening to the audio, you're not seeing it, but it was like.
Very clear, huh?
It was very clear, very, very clear. And it just made me, honestly, I said a little prayer that she was not alive when those things happened. Like, it was very horrific. And I don't know how a normal, sane person wouldn't feel something from seeing that.
Yeah. Thank you. Thank you for sharing.
Yeah. Thanks, Lori.
That helped me summarize what I'm feeling. So, and I know we all have to go back in. Everyone's going back in except for me. What time is it, by the way? How long do I have?
It's 1:18.
And what time is it? 1:20? Okay, so I have to go in. There are other things. So I'm going to do a little unroll me, and I'm going to put it on facebook.com/hidden true crime. I will say that the defense ended very poetically. They said that this isn't about zombies. This isn't about multiple probations. You're in the news? Yes. You're not yet. Yes, this is Idaho Falls, right?
Yeah. Linda Larson from KIFI and KIDK.
Yes.
In Idaho Falls. Yeah,
there you go.
News 3.
It was poetic.
It was poetic. It was one of the most unique closings I have ever heard in any trial. It was one of the most unique, and that's. I mean, if you want to listen to any part of the trial and the proceedings, listen to those closing arguments, because it was just very interesting. Some of the things that were said, and so it'll be interesting to see how the jury perceives this. And see how they, end up kind of talking about it. So,
I agree.
Yeah.
I agree. Thank you. Thank you for sharing. And this is Sarah. This is the reason I'm in the courtroom today. So this is Sarah. Thank you. Thank you. She gave me her mother's ticket. So I have to run back in, or else I'm not going to get back in the courtroom. But pretty much they said, this is not about multiple probations. This is the defense. Zombies, Archibald. This is a man who Lori believed was following Jesus, but he wasn't following Jesus. He was following the storm. And we stay away from the storm, and we shelter from the storm, and we fear the storm, but the storm came. And then he concluded. I have that on facebook.com/hidden true crime. Also do unroll me on twitter.com/hidden true crime. Thank you everyone for your support. I haven't been able to mention all the kindness that has been coming through on this live, and it means a lot. Thank you so much. Bye-bye.
Okay, let me pull up this video of JJ here. Let's see. Oops. Okay, I gotta share first, then enlarge.
They say that all good things must end. Call it a night. The party's over.
You need to go on American Idol.
Johnny as Papa.
But you got to do the coastal crew change.
And welcome to Coastal Crew Change. Welcome to the Coastal Crew Change.
Hey, and say the driver is Papa Larry Woodcock.
The driver is Papa Larry Woodcock.
Say thank you.
Thank you.
And come back.
Come back.
And pay your bill on time.
Yeah.
Pay your bill on time.
I'll be posting the closing arguments as soon as they come up on one of the bigger channels. Nate Eaton asked people not to stream theirs, so out of respect, I'm trying not to do theirs or Hidden True Crime. But yeah, that was a cute video of JJ. And for an autistic kid, I think he was doing pretty good because I've got autism running in my family, and my nephew, he will scarcely even leave the house, and he dropped out of his senior year of high school because he was refusing to go. And before that, my brother was getting calls from the school saying he's hiding under the table in the library and they can't get him to come out. And so my brother would have to leave work to go and collect him. So I'm glad to see that JJ was so functional. One of my cousins was so bad with his autism that he was made a ward of the state of Kansas. And another cousin, he's being raised at home with a very devoted mother. And cousin of mine, she had her youngest son who was autistic, and she opened a ranch in Arizona for teens and adults with autism. And sadly, she lost her son at age 20 due to a heart condition. But they're still going strong with the ranch. And so autism is something that's very close to my heart. So let's go back to finishing the Melanie Gibb video.
I know Tammy does have the conspiracy theories. My sister-in-law's right behind it all, and I hope that you're not being influenced by that dark team.
I don't know who she is. I'm sorry, you said your sister-in-law? I don't even know her.
Oh, I know, but she's coming up with the same type of theories. And it's just not true. My own children were there. They testified that Tammy had been getting weaker and sick, and I begged her to go to the doctor. Her heart was failing her. She was physically falling apart, and she hates doctors, and she just passed away. That's how it happened. My son Garth was right there with me the whole time. My kids were at the house within 20 minutes of her passing. There were 2 coroners. They checked her out right there on the bed. All these conspiracy theories just make me sick to my stomach. Just absolutely sick. I know it's been told for years that Tammy would pass away at a young age. And I had no idea that Lori would even be a part of my life. I just knew that my life had 2 segments. And that I know Tammy's on a special mission and she's with my kids. She's visited them. There's so much, Melanie, that you just have to have faith. And this is not some sort of master plan. There's no way Lori and I should ever come up with this. It's just...
You can understand my concern, correct?
I can from an outside perspective, but from
someone who knows as much as you know, no, not really. But we can feel Dave's influence on you. I can feel that for sure.
He's a very good man, and he has a very strong foundation, that I know.
I know, but he seems to be the one that's putting the doubts in your mind.
No, you know what? I have come to understand that my gut feeling, I was not listening to it. And I always felt uncomfortable with many things.
Okay.
Well, I'm sorry that I included you in those teachings then for your own sake, because I wish that you didn't have as much knowledge as you have, because you will be accountable for the knowledge that you do have, Mom.
So are you.
I agree 100%.
Yeah.
100%. I have no fear.
Yeah.
I have no fear of that.
But I really, you know, as I was reading the story of Chloroform, and it is so very similar to this, you just can't see it. But he did it because he was trying to reclaim a people, and he thought at the very end, because of his carnal and natural desires, that's what influenced him. And he was very deceiving.
Carnal natural desires?
Well, honey, you got a lot of natural desires. We all know that.
That's what you think is me, Cora? Are you kidding me right now?
I think both of you have similarities. It's in the scriptures. It's in the scriptures. And the scriptures are very powerful.
Yes, they are. I live by the scriptures, as you know.
I know, but we can rest the scriptures for our own vain glory.
I rested the scriptures?
We can do that. And I feel that you have to see our belief systems.
Do I rest the scriptures? Is that what you're accusing me of at this point?
I feel that you have.
Why do you feel that way? I need an explanation on this.
Because if you look, like the scripture just shared. Okay,
the scriptures every single day, you know?
I know you read them. I know about that. But this scripture right here says that you will be supported by all against the fiery darts of the adversary. You would have been supported if you had not opened dark portals and dark junk. You would have been safe if you would have obeyed God. He would have had your back. But you have been chased and tortured.
Whether you do this or not,
I'm sorry?
he has your back. So,
well, if he has your back, you would not be able to tell me where you are, and we couldn't find JJ. Like, where is he? I've been asking, where is he? And you know what I mean? Like, that's
I can tell everything where JJ is right now, and that would not be good for JJ. So I'm sorry that you don't want me to protect my children, but I would never ask you to not protect your children.
Of course you wouldn't.
So I can tell that you're just adversarial, Mel. I love you. I'm sorry that you feel this way.
Because I actually do care. I'm sharing what I feel for you because I know your salvation's in trouble for what you've done.
If my salvation is not in trouble at all, and I think you should check that with the Lord again.
Well, I felt a lot of things from the Lord, and this doesn't feel right.
Well, I'm sorry that you feel that way, sweetheart. I'm sorry that you're friends with all those who are against me. Joseph Smith's friends turned against me.
I'm not a friend. I'm not friends with people that are against you.
Apparently you are.
I am not. I don't know Kay. I don't know who you're talking about. Your sister, I don't even know what her name or who she is. I don't know any of those people. Why would they contact me anyway? How would I even know about that?
Well, you're friends with Dave, and he's apparently, you know.
Well, David is a very righteous man, and I've always known that grounding about him. And he has a lot of beautiful experiences with the Lord, and these are not the same. You know, when you get the priesthood, that's Peter, James, and John shows up, and then he confirms all of those in the circle that are to get it, and everybody's a witness of that. Everybody's a witness that the pattern is in the scriptures. There's no witness that you ever receive what you think you received. Nobody has seen that but you. There's no witness. The witness, Joseph Smith, Oliver Calvary, Martin Harris, the 8 witnesses, they all showed up.
Is there a witness when Jesus, Heavenly Father, gave that to Joseph Smith by himself in the grove? Was there a witness?
No, but they had it later with other people. That was one experience, but others joined in later. When he brought other people into it, they had experiences.
Scriptures, yes or no?
I'm sorry?
Is that in the scriptures, yes or no?
That Joseph was alone when he saw God the Father and Jesus Christ? Yes, he was alone.
He was alone.
But he had to open it up first.
That's not a pattern at all.
Honey, what I'm saying is that after he saw that and other people joined in, they saw the things with him. He wasn't alone. There was a witness for them. There was no witness. Anybody's never seen what you've seen or experienced what you've seen. That's your own witness, but nobody said that.
No, God knows it, and I will never deny it. For my soul would be at stake if I did. So you can say it didn't happen to me, Mel, but if I say it, then I am accountable. You didn't witness it, but I did.
But your behaviors is not, okay, I understand that's what you believe you saw, but this is the thing, as I see, is that your behavior is not one of somebody that's in Christ. Your behavior. What?
Never had any idea that you would be the person of all people to turn me. I cannot believe
I am asking questions, and I am concerned for you. That is what somebody does when they care.
You don't sound like you're concerned. You sound like you're accusatory. You do not sound concerned. You sound pissed off.
I'm not. I am troubled. Maybe that's the better word. Troubled. Because these things, like you being with Chad before he's even divorced, is unusual behavior for a person that's seen Jesus Christ.
I was never with him, and he was never divorced.
Honey, I've seen you guys together. So I haven't ever seen you with, I've never seen you with Chad kiss him and walk around the track at BYU with him. I never saw that. You
say you're the one that's just feeling guilty about being with someone before they were divorced.
Oh, honey. I think that's not what we're talking about here.
Wait, it's not what we're talking about here. That's what I'm saying. You are going off the deep end.
Well, I'm just saying this is not a behavior of someone that sees Jesus Christ. It's not the behavior.
Really? Have you ever seen Jesus Christ? So do you know what the future behavior would be if you had seen Jesus Christ?
I know that when I pray.
He to do every day, and he does protect me, and he is protecting me, and he will protect me against this accusation as well. And we will both stand there with him, and you tell me if I was lying or not, but we're both standing there with Jesus Christ.
Okay. Yeah, and I bet she's been in her jail cell during breaks and in the evenings doing her castings, trying to do voodoo on the judge and the jury the whole time, probably the prosecution as well. So, yes, we get all perspectives at times like this. So, okay, let's find that video of JJ here. Let's see. Oops. Oh, where's the audio?
Guys, today is the day. That song was JJ's song. He played it, he sang it, he loved it. And I can't think of a better day to play that song in memory of JJ. And I am ready for this. The gloves are off. It's time to get this show on. JJ would sit outside of our house under the oak trees. He'd set up his pots, his pans, and his 5-gallon bucket. He would set all of his little buddies in chairs, and that was his song. He would sing it and play it. And he played it, and he played it, and he played it. I can't think of a better song to come in here today with his memory than that song. So I am ready for this. We are all ready for it. I think that it's going to be, I think it's going to be, I think it's going to be a great day. I really do. And hopefully we have a fair, righteous verdict. This is swift. and Lori gets loaded in a van and taken to Pocatello, where she belongs for the rest of her life. And then it's on to Chad. The next trial, I hope it's quick. And by quick, I mean it doesn't take a year to go to court to prove the guilt of Chad. With all the evidence that's been presented, everybody has heard it. It's time to go to the next one. And then once that one is completed, it is time to go to Arizona. And let's get on Charles's case. And let's close this out. I hope it all happens in the next year. We've been here every day, as y'all know, for this. We will be in Chad's trial every day here in Boise. And then I hope he's found guilty quick and he's sent wherever he needs to go. And then we go to Chandler, Arizona, and we go to court there, and that's done. Fair, honest, righteous, and Lori is found guilty again for the murder of Charles. Chad is found guilty of the murder of 4 people. And Lori is found guilty of 3 people. Good day. Good day.
Thanks, guys. Just come back to this. Well, Paul, I wanted to get in on closing arguments. It's just a different experience being here. I found out last time when I was here than it is catching the highlights later.
And yeah, a gentleman already.
No, I'm by myself. Unfortunately, life prevented other people from coming on such short notice.
And I know it's like a lot of extra effort to come and do this. Why did you think it was worth it to come in person and see this instead of like hear about it later?
2 reasons. One, you always hope to find out more, and sometimes you find that out live. But also just to thank people like yourselves. I want to thank Kay and Larry again. People that are involved in this, that brought attention to it, that helps us all heal.
And do you expect to return when Chad's on trial? And
I don't.
You don't.
I don't.
Okay. So this is your main concern is this trial.
Yes, it is.
All right. Anything else you'd like to say?
Just thank you to y'all in the media, to everyone that's involved, participating, however they are, through Facebook, just through listening, through being involved in it. Good wishes, thoughts, anything. Just thank you.
Thank you very much. You can say one thing.
Wow, so many lines, so little time. Get a grip. So the one that comes to mind that's clean enough to say. Everyone that's been touched by this and offers support just by participating in the process, or just listening to the process and being touched by this.
So the time that you've been gone now, and now that you're back, what are your impressions? The things you've heard, all the text messages, Agent Hart.
We just get more and more angry. It's just so senseless, and so we're all hurt. We're all looking for healing. I think, including y'all, your listeners, your watchers. We all want healing. We all want to make some sense out of this, but anger is the probably predominant emotion right now. All right. Thank you. Thank you.
Welcome back. I'm Anjanette Levy, and thanks for joining us this hour for our live Q&A lunch show about the trial of Lori Vallow Daybell. We're expecting closing arguments in the case tomorrow, but first, before that, at 3 o'clock Eastern time today, 1 o'clock, I should say, Mountain time, Judge Boyce and the attorneys for the prosecution and the defense will be going on the record to discuss what they've been talking about behind closed doors with regard to jury instructions. That, of course, the judges hammer out, give to jury. And this is basically for them to follow instructions when considering each charge and to follow the law. And sometimes there can be little additions made to these, sometimes not. Sometimes they just use a boilerplate jury instruction form, but we'll learn more about that later today. Kathy and Gigi will be in the courtroom for that at 3 Eastern, 1 Mountain Time. And of course, we'll keep you up to date on what's in those jury instructions here on Law and Crime, on our YouTube channel, and on lawandcrime.com, our website. We want to get to more of your questions now. This one is from Facebook. It's from Patty Thiel Baker, and she asks, and I'll clean up the language here a little bit. Why the heck wasn't her niece, Melanie, also charged? She had full knowledge that Charles was about to be killed the night before he was fatally shot, but she did nothing. That's criminal. She was aware the kids were more than missing, but never alerted the police. Also criminal. She made a deal with the prosecution to testify so she wouldn't be charged, but weaseled out of it. So deal should be off the table. I call for her to be charged. So Kathy, that was a really long question, and more, you can tell Patty's upset about this. So do you have any idea why possibly Melanie was not charged?
People are really fired up about both Melanies, quite frankly, but Melanie Pulaski especially, because we see in text messages and all their communication, Melanie believed her kids were zombies. So she was okay that their bodies were going to die at some point. I mean, it's ridiculous what some of these women around Lori believed. And Melanie knew. Lori said it's coming to a head this week when it talks about Charles and the demon coming out of his body. Now, these women, Zulema and Melanie, they participated in these castings where they, stand in a circle and they try to cast out the evil spirits. So could be that Melanie just believed God was going to help them do that. But yeah, and she was here. She was here for several days to testify, and they weren't getting to her, and then the prosecution sent her home. I think she's a wild card. I think in the end they decided it was not worth putting her on the stand. Also, I don't know that she has any deal, so I'm not sure that's true, that she has any deal. I don't know. I mean, conspiracy charges. It's crazy when you read a text, and Melanie was so close to Lori that, I don't know. I understand why everybody's fired up about her, though.
Yeah, most definitely. And I think, all four of us are mothers, and all four of us can maybe see at some point in time where our kids drive us crazy. That's part of being a mom, but these children, as far as we know, they were just children, like poor little sweet JJ. I look at that little face and I just can't even imagine. Gigi, you've been in that courtroom. I'm sure there are parents on that jury. Your thoughts on Melanie and her involvement or potential involvement?
We didn't really see kind of the depths of her involvement until after she was sent home. We had that FBI agent on the stand who read the text messages where Melanie acknowledges that her children are dark and she knows this is part of the Lord's plan. So I was really shocked that, they let her go home. But I agree with Kathy. I think she was a wild card. I think she was very much under Lori's spell, thought Lori hung the moon. And so they haven't seen each other in over 3 years. And what happens when she gets on that stand? Does she clamor up and feel like she has to defend Lori? So I'm with Kathy. I think it was an emotional wild card. They didn't want to risk. They've got enough in there. And as far as charges, it could be one of those things where all signs point to yes, but can you get a conviction? And that's why Chad wasn't charged in conspiracy with Charles Vallow's murder, is because even though he was aware, there was nothing that they felt they could prosecute where they would get a successful conviction. So he had no charges. It could be the same with both Melanies in this case.
Yeah, we just don't know at this point, but it's a good question to ask, no doubt. We're going to take a quick break, so stay with us. We'll be right back.
We help you.
Let me look and see what else we've got now. Let's look at Twitter. Oh, we need to refresh, I think. It says here, the prosecution's closing arguments in the trial. I haven't had a chance to look at this. Let's see if this is legit. It says only 5 5 minutes, 21 seconds, but let's give it a listen. That's a commercial, not. Let's give it a minute.
Instead of smoking.
Staying away from alcohol when I was first quitting was key.
I kept on trying, learned something each time.
Do whatever it takes.
No matter how many times it takes.
We did it, so can you.
For free and confidential help, call 1-800-QUIT-NOW or visit
I haven't vetted
waytoquit.org.
this.
Developed by CDC.
When you download the Smiths app, you have easy access to savings every day. Shop weekly sales and get personalized coupons to get the most value out of every trip every time, whether you shop in-store or online. Download the Smiths app now to save big. Smiths, fresh for everyone. Must have a digital account to redeem offers. Restrictions may apply. See site for details.
Save big on your favorites with the Buy 5 or
Killers Podcast.
Hey, it's Tony Bursky. All this weekend, we are taking a look back at some of the most compelling testimony from the trial of Lori Vallow Daybell.
Okay, this isn't what it's purported to be. So let me do another look down Twitter to see what we've got. Says Lori Vallow's defense team, which didn't call a single witness during the murder case, tries to pin the murders of her child entirely on husband Chad Daybell, arguing that she was under the sway of his religious fanaticism and lied to protect him. No, I don't think so. Let's see. Says it will give us some relief. Relatives of Lori Vallow's murdered children and husband's ex-wife Tammy Daybell say they are praying for cult mom to be convicted ahead of closing arguments in blockbuster trial. And that comes from the Daily Mail out of the UK. She lied and she lied and she lied. Prosecutor gives closing arguments in the Lori Vallow Daybell trial. Let's see. Says that awkward moment during the closing arguments when Lori Daybell Vallow's attorney says Chad Daybell's penis, the storm, was responsible for everything. I think I missed that one. I'm going to have to listen again. Let's see. Oh, here, we got to show this here. Oh, nope. We've got to share it first. Okay, let's see. I closed the one screen, so I can't just switch tabs, so... This is the crowd outside of the courthouse. So just look at all the media and the people waiting to go back into the courthouse. That's quite the crowd. Yeah, and understandably so, because this is one of the wildest cases that I've seen in I don't know how long. Let's see. Let's go back. See what else we can find. Here is beauty queen Lori in her royal carriage, smiling, and I'm surprised she's not doing the royal wave like she's Queen Elizabeth riding in a carriage at Ascot. Let's see. Looks like there's... Okay, here we go. Oh, this is a lunch live. We could go back and catch the rest of Lauren's lunch spot. Let's see. Let me pull that up on another tab. Okay, let's see. Okay, we're going to have some overlap here.
Delicious multivitamins inspired by nature. Nature's way.
Hey everyone, got a bit of a late start. I'm going to flip you guys around and show you lunch at the court. We have concluded both the state's and the defense's final arguments. They both finished, and then we had a lunch break. So let me flip you guys around to show you what's going on here. Okay, see, there's Justin talking to his phone just like me. There's there's my friend Karen there. I just got to hold her new baby. There's Doug filming Roland, two old coworkers of mine. Over here we've got Law and Crime. There's Kathy, executive producer of Law and Crime. Gigi's over there. I don't know why I'm showing you guys this. I just figured you might be interested. Oh, this is Lori Vallow's uncle. Lori Vallow, Daybell's uncle. Rex doing an interview with, who is that? East Idaho News. Is that Nate? That's Nate there. And these two, this was touching. They came all the way from Salt Lake City, and they had a gift for Larry and Kay that they gave them. They had, it was a very touching moment. They had created a photo of JJ and Tylee surrounded by Christ. Who else is here? I'm not sure. I know 2020 is here. Over here, I'm unsure. Anyway, that's a bit about what's going on out here. Here's the entrance. So this is where I am right at the beginning. So I will flip around now. Let's see here. Okay, I'll go ahead and sit down so I'm not shaking as much anymore. Thank you again to Sarah and Kelly for allowing me to be here today. Really, it was almost the first day I was not able to be here. So again, I just want to thank our gems for that. I was able to give Sarah a big hug today. Wow, what a morning. The prosecution nailed it. It was profound. It was moving. I cried. They showed photos again of JJ. It was a really hard morning, and the prosecution showed excellent evidence. We saw photos of, again, the children. We saw photos of Tylee's pelvis, and saw again all of those marks that had nothing to do with dismemberment, as they pointed out. And we saw, thank you so much, Salty Cowgirl, thank you. We saw, again, photos of JJ, and I think we were all a little unprepared, or I should speak for me, I was a little unprepared, and it was just as awful. The first time we went through texts showing what the prosecution or the state said was evidence of conspiring. We saw evidence of There's Brian Entin walking in there too. Who else do we have? Okay. Oh, and is that Ray over there? Ray. I'll get Ray in a little bit too to come over. He's had his eye on Lori Vallow Daybell the whole time. He can share what she was. Ray. Okay, and I'll get him over here too. He will be able to report on Lori Vallow Daybell. He was watching her the whole time. And we saw JJ and, hold that thought because I need to give this a little bit of time. I'm going to have Ray discuss what the defendant, Lori Vallow Daybell, was doing. Thank you for joining. So you had your eye on Lori Daybell the whole time. Can you share what she was doing, especially during the state? I want to know what she's doing. Right now we're talking about the state's final argument.
Yeah. It was 70 minutes of time that Wood was on there, and I could see her probably 63 minutes of it. The 7 minutes is when he was at the lectern, and I couldn't see through them. She demonstrated to me that she had two facial expressions. One of them was it's not my kids, I don't need to worry about it. And then it was my kids, and then there was, again, a definite facial expression that wasn't, they're different. They're just different. She would be taking some notes, but not nearly to the degree or frequency that she was on other occasions. She seemed pretty engaged with what the prosecutor was laying down. There were times, I'd probably say 8 or 9 times, it was like, no. The eyebrows was up a little bit. No. It wasn't a big, oh, no, that's not it.
But surprised that they were saying that.
Yeah, it's like, they're not, they're barking up the wrong tree on that one.
Flat affect, you mentioned?
Yeah, pretty much. So, yeah, she's either worrying about what they're talking about, her kids, talking about Tammy or anybody else, and then just deadpan, or she didn't show any expressions whatsoever.
Right. Okay. And when it came to the photos, we were just discussing these photos. Did she look at her children's photos?
Her head was up, but it was averted away from the screen. But when Tammy's pictures came up, she was looking at the defense monitor.
Interesting.
Yeah.
Wow.
She was real good about writing notes and wanted to get Matthew's attention. And since Matthews is on her right and he's left-handed, it was real easy for him to scribe back to her. It wasn't a long sentence, and mostly she wasn't writing a lot.
Okay. I'm about to give them my opinion on a verdict. So right now, just I've only been really discussing the prosecution's argument. I thought they both did an excellent job. But before I jump in with my opinions, what are your opinions on today's arguments and your thoughts on a verdict?
Well, we still have the second part of the bite of the apple for the prosecutor.
Right.
It's not going to make any difference to the jury. I think their mind was made up quite some time ago. The totality of the evidence was frequent. I think the avalanche is coming down the mountain, and it's going to be over for her. I wouldn't be. I was a little on the fence on whether they'd be able to get her on the murder charges.
Sure.
I mean, the conspiracy is a slam dunk. The financial charges, that's nothing.
Slam dunk. Right.
Slam
I agree.
dunk. But I think the murders, I think based on what was laid down by the court, they can get her on that too. I think at the end of the day, it's not going to matter whether she gets out of prison any earlier because she won't. Maybe this is the last day that she ever gets to wear some civilian clothing.
Okay.
That would be good.
Yeah. So I didn't ask his opinion before, and I know a lot of people, what are you thinking? We did a poll yesterday where a lot of people actually mentioned they were worried about the verdict. My opinion is the same as Ray's. So we did not talk before, but that's what I'm feeling too. And I think it's what most people are feeling. I think that she'll be guilty on all counts or found guilty, but we will see. We will see if that's the case.
So briefly, ladies and gentlemen, class lady.
Oh.
We're all real lucky to be able to have you here to cover this, and we'll see you next year when Chad doesn't have his trial because he's going to plead.
Thank you. I'm sending this to my mom now, so thank you.
Okay, Mom. See ya.
Okay. Thanks, Ray. Thank you. Yeah, I agree with Ray, and I think it's pretty clear to me what the verdict's going to be, but we will see. We will see. The defense followed, and after the defense came, I will say that I felt they did a good job. Well, I've got another gem with me. Did you feel like the defense? I mean, look, I know that you're probably pro prosecution. But do you feel the defense did a good job, or is that too hard for you to even say?
No, I feel like they did. I feel like there were moments where they said things that I was like, yeah, you're right. Like that's pretty accurate.
They made good points. Even
so
I rethought some things. I was like, true. Yeah.
Considering the fact that it didn't feel like they had a defense, and they really don't, I do feel like he did a good job. I also think that I feel like Jim Archibald really did speak from his heart. I think some people may think, oh, that was kind of phony or that was not. But I want to believe that he really is a good person. This is his job.
I agree with you. So you can feel confident what you're saying.
Yeah.
There are times where people will hear today that he got emotional during audio. And we always wonder, right? That's what we do in the true crime world, is speculate, what tears are real, what are fake, what's a show. I actually also believe it was genuine, and it was a little unexpected, I think, when he got emotional.
Yeah.
I don't think it was a show.
I do have to say there were moments where I was bored.
Yeah.
I hate to say it, but I was like, oh, don't fall asleep.
That's okay. Honesty.
Yeah.
You're also a mother with a break right now.
Yes, yes.
So you probably need sleep.
Yes, exactly.
So, yeah, thank you. What else do you want to share? Anything else you want to share that you felt was important to point out?
I do think it's going to really be hard for this jury when there are 6 of them that don't get to deliberate. I was observing them because from my seat today, I can't see Lori, I can see them. And there were some of them who I noticed things that almost seemed like a nervous tick, but I think it was because they were feeling so much emotion. And others who you could just tell they're listening. They're so intently focused on this, taking this completely serious. I think they're all taking it seriously, but I imagine if it was me, I would have a very hard time coming back, finding out, hey, sorry, thanks for staying with us all this time, and then not to deliberate and say, no, here's what I think and here's what I believe from the evidence. So that's hard.
Thank you for sharing that. I see the jury. Like, again, I'm sitting really close to the jury. I can see the jury better than Lori Vallow Daybell, but I'm so busy live tweeting on my phone, and we have to keep our phones down. There's no keeping your phones up. And so I do rely on other eyes. So thank you for sharing that. It has been this jury has been intently listening and intently watching. I know that Gigi with Pretty Lies and Alibis agrees. And so it's interesting that that's what you've seen is, they've been an emotional jury. They've cried at times, I can imagine. And today is a really emotional day. It's like going through like all the most, that's what they want to do in arguments, and final arguments is bring emotion to the table. And both sides were definitely bringing emotion to the courtroom today. So it was overwhelming, to say the least. So thank you. Thank you. How are you after seeing photos and everything? I know that those were kind of unexpected today.
I actually did expect them because I figured, how do you really get your point across without showing those again? And I read very explicit tweets about what was shown and wasn't in the courtroom originally.
Yeah.
Cried with that. Saw JJ and instantly started tearing up thinking about my baby. And then it was when I saw Tammy that I just tears down my face. Her aunt and cousin, I believe, are in the courtroom, and they broke down crying. And that was very, very emotional. I looked at the jury and I didn't notice any of them crying, but there was one woman who the frown never left her face. So it's heavy, like really heavy.
There was a moment when I tweeted, I heard tears and I couldn't see who they were from. And that actually was, Tammy's side of the family. It took a while and I never shared that. So thank you for sharing that. Yeah.
But those were my takeaways.
Yeah. I also got emotional when they showed the photos, and to see Tylee, you saw Tylee too. And could you see the marks on her pelvis?
That was honestly really horrific, because when you read a tweet or even listen to the audio, you're not seeing it, but it was like
very clear.
It was very clear, very, very clear. And it just made me, honestly, I said a little prayer that she was not alive when those things happened. Like, it was very horrific. And I don't know how a normal, sane person wouldn't feel something from seeing that. Yeah.
Thank you. Thank you for sharing.
Yeah. Thanks, Lauren.
That helped me summarize what I'm feeling. So, and I know we all have to go back in. Everyone's going back in except for me. What time is it, by the way? How long do I have?
It's 1:18.
And what time is it? 1:20? Okay, so I have to go in. There are other things. So I'm going to do a little unroll me, and I'm going to put it on facebook.com/hidden true crime. I will say that the defense ended very poetically. They said that this isn't about zombies. This isn't about multiple probations. You're in the news. Yes. You're not. Yeah. Yes. This Idaho Falls, right?
Yeah. Linda Larson from KIFI and KIDK.
Yes.
In Idaho Falls. Yeah.
There you go.
Eyewitness News 3.
It was poetic.
It was poetic. It was one of the most unique closings I have ever heard in any trial. It was one of the most unique, and that's. I mean, if you want to listen to any part of the trial and the proceedings, listen to those closing arguments, because it was just very interesting, some of the things that were said, and so it'll be interesting to see how the jury perceives this and see how they end up kind of talking about it. So
I agree.
yeah
I agree. Thank you. Thank you for sharing.
Yes.
And this is Sarah. This is the reason I'm in the courtroom today. So
Hi,
this is
guys.
Sarah. Thank you. Thank you. She gave me her it's her mother's ticket. So I have to run back in, or else I'm not going to get back in the courtroom. But yeah, pretty much they said this is not about multiple probations. This is the defense. Zombies, Archibald. This is a man who Lori believed was following Jesus, but he wasn't following Jesus. He was following the storm. And we stay away from the storm, and we shelter from the storm, and we fear the storm, but the storm came. And then he concluded. I have that on facebook.com/hidden true crime. Also do enroll me on twitter.com/hidden true crime. Thank you everyone for your support. I haven't been able to mention all the kindness that has been coming through on this live, and it means a lot. Thank you so much. Bye-bye.
Yes, Lauren didn't get a ticket, and a viewer kindly offered one, and so that was the daughter of the person who gave up her ticket so that Lauren could be present. Let's go over to the summary by Law and Crime. Here we go.
Welcome back to Law and Crime. I'm Michelle Yu with a special update. Closing arguments are underway out in Boise, Idaho for the Doomsday Cult Mom murder trial. The state and defense both completed their initial closing, and we are still waiting for the state rebuttal. As you know, the 49-year-old Doomsday Cult Mom, Lori Vallow Daybell, is charged in the deaths of her two children, 7-year-old JJ Vallow and 16-year-old Tylee Ryan. She also faces charges in connection to the death of her husband's first wife, that's 49-year-old Tammy Daybell. Her husband, Chad, will be tried at a later date. The state had a total of 60 witnesses testifying against Vallow Daybell, and her team called a grand total of 0 people in her defense. Vallow Daybell faces a life sentence if the jury comes back with a guilty verdict. And to bring us up to speed, we have our eyes and ears. That's the one and only Gigi McKelvey, who has been in that courtroom since the beginning. Welcome, Gigi. So tell us, what were your main takeaways from the state closing?
Well, the state really just brought it home, I think. They outlined the affair as being the motivation, the money, the power, and showed some very graphic photos, again, to just drive home why we're here and the 3 lives that were lost. And so I thought the state did a really good job of condensing everything down in about an hour, maybe a little less. So it was very powerful. The jury was all ears. Lori was looking down a lot. Sometimes she would shake her head no at things that was said, write down things, have her attorney look at what she wrote down. So it was interesting to watch how she reacted to closings.
What about the defense?
You know, I have to say, considering the defense really hasn't had much to work with, I thought the closings were as good as they could have been. Archibald got emotional, actually, a couple of times talking about things, but we've been waiting and wondering, why hasn't she thrown Chad or her brother Alex under the bus? Well, they waited till closings to do that. Their closings have centered around, show me one text where she says, let's kill the kids. Seems to be Chad and Alex together all the time when the kids were dead the next day being buried. Lori was nowhere around when Tammy Daybell was murdered. And he kind of made fun of Chad and pretty much called him a loser who sold books, so little books that his wife had to go get a job that made $15,000 a year to support him, and essentially just made it to where Chad was persuasive. Brought in the fact also that Colby Ryan, who is Lori's oldest and only surviving child, and her sister Summer both said until Chad Daybell, Lori Vallow was a great mom.
Gigi, how is the jury reacting to all this? Was there a lot of note taking?
A lot of note taking at times, but mainly they listened. I think at this point they've sat for 5 weeks. They know the facts. They know what they've heard. There were a few moments where they did write down things, watched Lori a good bit too to see her reaction, which during the state's closings was just a couple of times she looked a little sad, but I mean, grinning and talking to her attorneys and things like that. So it's just kind of been all over the board with her emotionally. Now, when her attorney Archibald was up, she watched every single move he made. She didn't take her eyes off of him the entire time he was up.
Correct me if I'm wrong. I was reading your tweets today, Gigi, and you were saying that the duct tape images with JJ Vallow, they were presented once again. Lori Vallow still emotionless. Is that something that courtroom is all looking at her, all eyes being on her, that even now, you've seen this a few times now, there's still no emotion coming at her?
Yeah, I saw a lot of glances in her direction from the jury and the public when those photos were on the screen. There was no emotion. I think she glanced up maybe once, but just 30 seconds after, she's grinning and talking to her attorney. So it's just not there. The emotion is blank.
What is the overall atmosphere like out there today? Because we all know that this is wrapping up. How are people feeling? What is it like?
People are ready for justice. This has gone on for 3.5 years. There are 3 bodies, just in this case, a 4th if you include Charles Vallow down in Arizona. People here want justice for these victims. And from what everybody that I've talked to, their opinion, what they've seen over the past 5 weeks, the ones that have been here regularly say the state proved their case above and beyond, that she was right in the middle of it, wanted Chad, and the obstacles being Tylee, JJ, and Tammy were taken out. And that's why we're here.
I saw the footage of the packed courthouse, and of course, leading the way was JJ Vallow's grandfather, Larry Woodcock, who was very interesting this morning, played Queen, We Will Rock You, which was JJ Vallow's favorite song. How was he, what was his aura like when he entered the courthouse?
I think he's hopeful. I think that this is a day where a lot of years of waiting and going through some very painful times of not knowing and then knowing, and then the legal process. I think there's relief that maybe this jury has heard the evidence and does believe she is responsible, and maybe they'll get some resolution, in the next few days with this aspect of the legal process. We still have Chad's trial to go at some point next year, but at least, hopefully with this verdict, they can sit back and digest what they've learned in the course of this trial, because a lot of it has been very painful and unknown to them up until this trial.
Well, speaking of Chad, I read that Chad Daybell's attorney was there for closings today. Is that right?
I did not see him upstairs. Sometimes he will go in the media overflow room. He's been here on a very regular basis, watching people's reactions as things about Chad are mentioned. So I have no doubt he's here. I personally have not seen him.
What do you expect to hear out of the state rebuttal now?
They just got to drive it home. They've got to go back and reiterate that Lori was not a puppet on a string. And we see in the text messages at times she is asking Chad, what level is JJ at? Which means, what's his death percentage? That shows that she was interested in knowing if he was close. And in 1, not a 0 yet. I think things like that may be brought up on rebuttal to remind that jury Lori was active in texting about the status of how close her son and her daughter were to death.
So, Gigi, before we let you go, just take us through a quick timeline of what may happen, in the next few hours there in Idaho. You guys are now on a break. How long is that going to last? And then the state rebuttal happens, and then what do we expect?
Yep, 45-minute break for lunch, and we have rebuttal coming up, and then we've already had the jury instructions read, so I guess it'll be a matter of how long that rebuttal takes. Do they give them the case today, or do they let them go home and get a good night's rest and start fresh in the morning? That's the big question we're all asking right now.
All right. Well, I'm sure you'll have a lot of answers for us later as well. Gigi McKelvey, you've done a fantastic job covering this trial. We hope to hear from you soon with more updates in Idaho. Thank you so much as you get back into that courtroom. And of course, if you want more from Gigi, you follow her Twitter handle at Pretty Lies and Alibis. And don't forget, we will bring you the verdict live whenever that does come in. And that will do it for me for right now. Keep it here on Law and Crime because we will have much more trial coverage ahead right after this break.
Okay, let's take another look over at Twitter here and see what the latest is. Says the jury has the case and has begun deliberating in the Lori Vallow Daybell case. So we are officially on jury watch. That's 14 seconds ago. So, says Lori Vallow groomed and manipulated Chad Daybell and Alex Cox to kill, prosecutors say in closing arguments. Prosecutor Rob Wood argued that Lori Vallow was driven by money, power, and sex, and that she used all those, all those things, and for some reason the rest of it was cut off. That's not very helpful. So, yep. Oh, it says the KSL is saying that 12 jurors begin deliberations, and that's 7 minutes ago. So it seems that that tweet was not the most timely. Let's see what else we have. Let's take a look here. Not sure if this is... we've got a news story from says CBS 2 News. Says the fate of Lori Vallow Daybell is now in the hands of the jury. Boise, Idaho. The jury began deliberating after the defense and prosecution finished closing statements. The jury, which is made up of 18 individuals who sat through the entire trial, have been whittled down to 12 members who will serve as a jury. The remaining 6 people are considered alternates and will not have a vote in the final verdict. The jury will begin deliberating on 5 weeks of evidence and testimony given by dozens of witnesses. Law enforcement personnel from multiple states and jurisdictions, including the FBI, testified along with doctors, coroners, DNA experts, and former friends and family members all testified. Several key pieces of evidence the jury will be considering include text and cell phone data, which shows communications between Lori and Chad planning to live a life together without children or dependents in the very near future, while Tammy Daybell was alive. And JJ and Tylee were still alive. Text messages between Chad and Lori show discussions around how much percentage of life people had left, even indicating that JJ and Tammy's percentages were very low in the days leading up to their deaths. Physical evidence was also recovered from where JJ remains were recovered. A plastic bag was wrapped around JJ and secured with duct tape, and revealing 2 pieces of physical evidence. The first was a finger and palm print matching Alex Cox, Lori's brother. The second is a strand of hair which was stuck to the duct tape, which is a DNA match to Lori. While the defense's presentation was sparse in comparison to the state's case, just an editorial, their presentation wasn't just sparse, it was non-existent. Okay, the jury will have to make a unanimous decision on a verdict of guilty or innocent. again, an editorial. It's not innocent. It's not guilty. There's a difference. Okay. The death penalty has been taken off the table for this case, but multiple life sentence is within realm of sentencing guidelines, and should she be convicted. CBS 2 is covering the trial and will break in on broadcast and across social media platforms once a verdict has been announced, and follow them. So let's see. Portals are probably outside the cage. Well, somebody was calling them portal potties, which I thought was extremely clever, but obviously they need to get some Drano to get their portal potties to work properly. Yes, if people were wondering about Galadriel and Eowyn, they're my two cats, and unfortunately, I never intended to be a two-cat household because Eowyn is very not into other cats, and she ran away. And so after 5 weeks of being gone, I got a kitten. And then after 1 week, Eowyn turned up in the neighbor's driveway. And so I suddenly found I was a two-cat household. And now that Galadriel is mature, she started fighting back. And so it's been rather not very fun. And so I decided to rehome Galadriel with my niece because my niece lost her cat. She went missing, no signs of what happened, and she's known Galadriel since kittenhood. So it's with the jury now, criminal med connections. So yes, Karen, stupid people, they could divorce but wouldn't have the money without them. And also the fact that the LDS Church discourages divorce and says that you get some restrictions placed on you if you're divorced in terms of getting advancing in the priesthood, and Chad thought that he should be made LDS Church first president or president of the church. And so that was with the part of the reason. I understand that they've changed the stance on divorce and not being able to become a bishop or general authority. Yes, Lori had 5 husbands. Hi, Sea Star. Good to see you. And so the murder was that was part of it, but I think that Lori and Chad wanted to be empty nesters and they wanted the money. And so it was purely selfish motivations. So Lori could have been on probation with the church, and I guarantee you that as soon as the verdict is announced, Lori will get excommunicated. There is no way that she can stay a member with what we've heard in the trial. So where the wind blows. I think the Daybells ate too many Tide Pods. I think you are right. Lori wanted to have 30 good-looking teen husbands, like a female Joseph Smith, but Chad wasn't going to be alive by then. Yeah, I can see that. And I feel quite sure that Lori will seduce every prison guard in sight, or at least try to, so that she can have special privileges. Maybe they'll smuggle in real cosmetics and hair dye for her. I don't know. Let's see what we can find. I guess we can start looking for the audio to come up. Let's see. Oh, no, that's not the closing arguments yet. Let me... Let's see what has posted in the... Let's see, we only caught a little bit of Nate Eaton. So let's... Oh, here, this sounds good. This is former AG David Leroy gives his thoughts on the final days of the trial. So let's
In the trial of Lori Vallow Daybell get underway tomorrow, this after 5 weeks of testimony and 60 witnesses. Vallow is facing charges of first-degree murder, conspiracy to commit murder, and felony grand theft. Anchor Roland Barris has been following this week's testimony and joins us at the Ada County Courthouse with where the case stands now.
Don, not much going on in court today. The jury is out and both sides are meeting with the judge in preparation for tomorrow. I talked with local attorney David Leroy, who says the defense's request for acquittal on grounds that the prosecution just didn't make its case is a common tactic, but it rarely works and likely will not in this case. We are expecting closing arguments tomorrow, and Leroy says that the prosecution laid out a pretty solid circumstantial case. David Leroy sees this murder case pretty clearly.
Have you seen people convicted on less?
I've convicted people on less.
The defense didn't put on a case, and Lori finished off their inaction with a short statement yesterday.
Is it your decision to continue to maintain that right and not testify in this matter?
Yes, Your Honor.
I think Lori is indefendable, and I look forward to this going to the case. And whatever the verdict is, that'll be what the verdict is. And it'll be 12 honest men and women on that court that has absolutely paid attention to everything and every word that has been said in there.
Leroy says the fact that Lori didn't testify is typical, but may have missed some key opportunities.
A bit surprising given the opportunities that might have been present to present evidence of an expert nature about indoctrination or the other kinds of things that might have made Lori less culpable than other people involved in this case.
Leroy says considering the sheer amount of evidence presented in this case, as well as the number of charges against Lori, deliberations could take several days.
Well, I sure hope it's not several days. It's possible. But from the reactions that I've been hearing all along, whenever they would bring up a new body, the jury was just jaw in their lap time. When they mentioned that Charles was killed by Alex, they were in shock. And then they hear that Joe Ryan is also dead. And oh, by the way, she tried to shoot Brandon Boudreaux. And oh, you've got bodies falling all over the place. So I don't know if Alex was in Arizona. I think that I haven't figured that out. Zulema seems so sweet. It's hard to believe she would do that, but I think that was kind of the whole reason that they got them married off, was so that Zulema could take care of Alex. So, okay, let me take a look and see what else is new on YouTube since the jury rested. Let's see, still scrolling down. Okay. Not a lot has come up so far. Let's take another look. Oh, we were going to look at the Nate Eaton piece because we only caught a tiny bit.
Prosecutor Rob Wood stood in front of the jurors, just like I'm speaking to you. He held a handheld mic rather than a lectern. He had a presentation being shown on the screen, and he forced or reiterated the words that we heard from opening statements, that this case is about sex, money, and power. And he went through and he showed how he believed Lori used money and sex and power in the deaths of her children and in the death of Tammy Daybell. Prosecutor Wood spoke for about an hour. If you want to go to our website, you can read the minute-by-minute account of what he said. He talked about the horrific manner in which her kids were found buried on Chad Daybell's property. He spoke about the Tammy Daybell's death and how she went to Chad for guidance and inspiration, and how not one time when all of this was being discussed did she ever say, well, what about the safety or the concern of my kids? We also heard from Jim Archibald, Lori's attorney. So the prosecution gave their closing argument. Then Jim Archibald gave his closing argument. He got emotional at times. He got emotional at times. He got emotional when he referenced the phone call that Colby Ryan made to his mother, where it was an emotional call. And Jim got emotional talking about it. He also got emotional talking about he basically made the comparison that everything that the Jesus Lori thought she was following came from Chad Daybell. All of the beliefs changed when she met Chad. Lori assumed Chad was following Jesus. And because of that, she may have made some mistakes. He said there is no proof, not one bit of proof in all of the text messages and any of the evidence that Lori killed her children, and that there is no proof that Lori killed Tammy Daybell. And he addressed these point by point by point. And he said that Chad was being led by the storm. And if you've been paying attention to this trial, the storm is a reference to Chad's private parts. And he was saying Chad was being led by that and Lori was following. And that the Jesus Lori believes in is not all of this crazy, he kept saying, weird religious stuff. He called Chad Daybell's book stupid, his books that he couldn't sell. He said if Lori was really after money, why would she kill her Charles Vallow, who was making $400,000 to $500,000 a year, and chase Chad Daybell, who was making $30,000 a year and had declared bankruptcy? So it was an interesting point. So where we are at right now is we are at a lunch break until about 1:30. The prosecution will then get a chance for rebuttal. They will go in, they'll be able to rebuttal whatever Jim Archibald said, and then it's up to the jury. They'll get a few more instructions and they will go deliberate. And we could have a verdict today, we could have a verdict tomorrow, we could have a verdict next week. The judge encouraged them to be careful when they deliberate, to take their time, it has to be, there has to be no reasonable doubt if found guilty. If there is any reasonable doubt on any of the charges, then they must find Lori Vallow not guilty. After her attorney spoke, gave his closing arguments, Lori was up there. She stood up. We all left the courtroom. I hung around for a minute just to see her reaction, and she had her back to the crowd, and she was aggressively speaking with both of her attorneys. So I don't know if she was pleased with the closing or upset with the closing. But this is the first time in the trial that her attorneys have really kind of gone after Chad or really tried to place any of the blame on him. So I want to try to maybe talk to somebody who was in the courtroom to get their thoughts. Can you walk with me? Walk with me. We're going to go up here just for a minute. These ladies have been here at the courthouse for a few days. Can I do a quick interview with you? We're live right now. Or with you, one of you? Yeah. You were in the courtroom, weren't you?
Yeah, so was she.
Yeah. So, would you stand up?
Yeah, sure.
So tell me, what did you think? What did you think of the closing arguments?
I thought the prosecution was wonderful, very succinct and to the point, and took us on a timeline. I felt really bad for the defense.
Why is that?
They were struggling to come up with something, and they really didn't.
Did any of their points resonate with you? Did you think, ooh, that's the point?
Not one.
Not one.
Not one.
What resonated with you most out of Rob Wood's closing argument?
Most, let me think. Understanding that she used to be a different person. I think that was interesting when there were so many witnesses talking about how she used to be a good mom. She was a good mom. She loved those kids. She was so symbolic that, even the Woodstocks wanted JJ to live with her and all of that, that's who she used to be prior to the new belief under Chad and the person that she became with Chad.
Tell me the question you was walking out, because I'm sure our viewers are asking too.
What happens next? How do they determine the jurors and who the 6 that leave? Are they going to do that in public or they do that in private? And when does that happen?
So from what we understand, there's 18 jurors that are still in there. Not one has left. They assume that one might get sick or have a death in the family or something, but they've all been there, but only 12 will deliberate. And so the judge will at random pull numbers out of a hat, and these are the 12 that will stay and these that will go. And we understand they will do that after the rebuttal. And they will do it in open court. I believe we will know. So there's those 6 jurors that have been here for 6 weeks. They won't get to give their thoughts. Did you want to say anything? Were you inside?
I was.
What did you think?
I agree. The prosecution did great. The defense, I think honestly it was the worst closing I've ever seen, ever.
Why is that?
Well, I just didn't feel like he gave any facts. Where were all the texts from Lori about after? Where are my kids? Or why aren't my kids still here? Or where are they? Or I'm sad that they're dead. She never once said anything like that. If I was, obviously didn't, so he couldn't bring that up, but it was just, there was not a lot. And I didn't understand the crying. That seemed give me a little bit of sympathy.
You mean when Jim Archibald got emotional?
Yes.
You think it was a sympathy play?
I do, because he wasn't really talking about anything, and it was.
What stuck out to you about the prosecutors? Their opening or their closing argument was anything just hit you?
I really liked the timeline and going over all of the points, the important points, and I think it was very organized, very easy to understand, and it really painted a picture.
Well, we'll let you guys eat. I know we're on a time crunch, and I have to eat too. Thank you. Did you want to let me talk to you? You don't want to say anything?
I'll
okay.
say something.
No, you won't. No, just talk to me like the camera's out here. You've been here a few days.
A lot.
And what have you thought?
The closing in particular,
Yeah.
I'm going to ditto what they said, so nothing different. Prosecutors, I think, nailed it, really painted that really clear picture that summarized everything really well. Defense, I just don't think they have a defense.
Yeah.
And you could tell, at least my perception was, Lori looked angry. Like she looked maybe disappointed or maybe surprised by what he was saying, which I would think she would know what the defense is going to say, but she looked very annoyed.
One of the things that I just said, you all didn't hear because you were up here, is this seems to be kind of the one part in the trial where they kind of went after Chad. They haven't really done that. Have you noticed that?
I think the defense has brought that up in previous or when they were cross-examining or when they were bringing their case, but today for sure they were so focused on that. And I absolutely, I think Chad is guilty, and he had a big part of this.
Rex.
But Lori
Sorry.
knew what was going on. Totally is guilty of
of this crime.
Speaking of Lori, this is Lori's uncle.
Yes.
We're gonna chat with him. Hey, Rex, thank you, ladies. Can we come down here? Can I ask you a few questions? We're live right now. So let's have you right here, just so you look good. So you came back into town. For those people just watching, this is tell everybody who you are. This is Rex Connor.
Rex Connor, Lori Vallow. I like to say I'm JJ and Tylee's great uncle, but I'm Lori Vallow's uncle, her mother's brother.
You were here earlier in the trial. You came back today. What did you think of closing arguments?
I thought the defense did the best they could with what they had. I think the prosecution did an excellent job laying it out, summarizing, taking us all, well, they didn't do it for us, but taking the jury step by step through the evidence.
What about the defense?
I think they did the best with what they had,
Sorry,
which was almost nothing.
Yeah, almost nothing. Were you watching Lori at all while they were?
I was.
And?
No change in her demeanor. Same way it's been the full trial, I believe.
Yeah. What's been your overall take? How do you think the jury's taking all of this in?
That's the big question, isn't it? We'll find out when they come back with a verdict. I don't have any insight to that. I hope it's like the rest of us, but you just don't know with the jury, do you? So I can't imagine. I've tried to imagine. I've really put effort into it. My whole family has. We talked about it. I can't imagine that they would see it any differently than the rest of us. And everyone I've talked to sees it pretty much the same. It's pretty clear what Lori and Chad did. Although we don't know all the details, we wish we did. We wish we'd get some more insight to that. We probably never will, but it's pretty clear how evil this is. We just don't know why they did things that evil.
Yeah, that's the question we'll probably never know the answer to. Any prediction on when the jury will have a verdict?
It would surprise me if they deliberated longer than it takes to drink a can of soda.
Wow, that quick.
Well, I just can't imagine. I know they'll feel. I've had the opportunity one time to do jury duty, nothing like this, but it was a real obvious case also. And we tried to deliberate. There's one person with some reservations. Well, I don't know. And so you go through the thought process, but even that person felt like it was pretty clear. Yeah, when you put it that way. And I think it's all put that way. So
you think we could have a verdict today by 5 or 6 o'clock?
Yeah, I don't know that.
Sure.
Well, of course, none of us know it, but I think that's entirely possible.
Yeah.
Just because the case, I feel, was so strong and the way they presented it and the context in which it was presented in the instructions, it's pretty clear.
Anything you want to say to people watching, Rex?
This is my theme. I'll never not say thank you to y'all in the media, to Kay and Larry in particular for getting this started. Who knows what would have happened had they not cared enough. But now the millions of us that have been touched, and I'm no different in this group because I'm family, all of us have been touched by it. We need to heal from it. It's scarring. See those pictures or to hear what happened, it offends our senses, our sensibility. My family doesn't think we'll find complete justice, no matter what the sentence is. You just can't find enough justice for people that have done what they did to those children. And I was listening to your broadcast last night when you went over the affidavit.
Yeah.
Okay, let's see. I'm thinking play the, oops, I'm just messed up the tab here. We have texts, which Law and Crime has called out. So I think let's go to that. I mean, we're on jury watch, so there's time to kill, right? Oh, we just saw this commercial.
Now, earlier you talked about reviewing the Lori for Style and the Lolly Time accounts and viewing that data set through Cellbrite. Do you remember that?
Yes.
Okay. And you've previously recognized States Exhibit 29C and D, which are the Lolly Time accounts. If you could look at your screen, Mr. Wood is loading it. It's taken just a minute. We need it. It's hooked up through the projector, the HDMI. Share screen.
So it'll be published on the.
Yes, Judge.
Very well.
Okay. All right. Agent Hart, what are we looking at on the projector? It's displaying states 29, C and D, but what view is it for the record?
So this is the Cellbrite software. Essentially what you're seeing here is the Lori for Style at iCloud.com iCloud account. You can see Cellbrite up here, and then on the side where you see all of the different compartments, different types of data that exists in the iCloud. With each of these types of data, cookies for instance, they will show the number of records that exist in the iCloud. So you have device locations, journeys, locations, emails, MMS messages, notes, and it goes on. SMS messages, I spent a substantial amount of time here, and you get an idea of the volume, over 13,000 text messages, voicemails, images, so on and so forth. So this is what it looks like when you first, this is essentially the opening page of the Lori for Style at iCloud.com, and then Lolly Time would be a mirror of this. It's just simply a different account.
Can we show them the Lolly Time page, please? Okay. And that's pulling from the States Exhibit, correct?
Yes.
Okay.
So this is the, you can see it says Lolly Time at iCloud.com, and it has the same compartments as the other iCloud. You'll see that the number of records in Lolly Time is substantially less than Lori for Style, and that's because Lolly Time was created in April of 2019 and then goes through November of 2019. So this particular account is much smaller.
Okay. So Lori for Styles was much longer because it wasn't used for a longer time.
Lori for Style, the earliest record in Lori for Style is December of 2000, so close to 19 years.
Okay. And then Lolly Time, I apologize, it started in what month?
April of 2019.
And it ceased to be used according to what you could find?
Correct. Both accounts ceased to be used in November of 2000, towards the end of November of 2019.
Okay. Now, in analyzing the records in states 29, C, and D, what process did you follow?
A very methodical one. I would go into each of these compartments, which also exist where it says device content. It'll say phone data, and then it will have all of these records. So Bluetooth devices, call logs, contacts, and as you scroll down, you'll see all of the different compartments. And so my process was to open up one of those compartments and then examine the data that was in there. If there was something that was pertinent or relevant, then I would make a document of that.
In Lori Vallow's iCloud accounts, approximately how many records of data were there?
I don't have an exact count, and that gets to be a little bit difficult. For instance, there's a section for chats. Well, one chat may contain 3,000 messages within that chat, but my best estimate from kind of tallying these is between 130 and 150,000 records.
And if we could just turn to, just so that jury can see one of those, let's look at Lori for Style, the SMS section, if we could.
Can we please identify which exhibit we're looking at?
Yes, absolutely. Is this the Lori for Style, States Exhibit 29? I think it's D.
Thank you.
And turning to Lori for Style in the SMS section, let's look at line 1842. So Agent, while Mr. Wood helps locate that and display that, is that the process you had to go through for looking, the process he's going through, is that the process you had to go through to look at every one of these texts?
Yes, so in Lori for Style, I applied a date filter starting October 26th of 2018. When I applied that filter, there were approximately 4,500 text messages, and I started at that date and then read every single text message down to the last.
Okay. And that's just the text messages?
Yes, and so I followed that same process for all of the various compartments that you can see that are displayed on this screen.
So I want to make a clarification here. I think you may be looking at 29C, not D.
Oh, I apologize if I misspoke, Your Honor.
Okay, thank you, Counsel.
Yeah.
Well, I think we need to be clear if it is 29C or if it is 29D.
If you could, yeah, let's confirm.
This is Lori for Style at iCloud.com. (29C).
Okay.
Is that what the court shows?
Yes.
Okay, good. And so turning to line 1842, is that what's displayed up there, Agent?
Yes.
Could you show us sort of how you would figure out what that record was and what it revealed?
Certainly. So you can see a timestamp. So it would show the date that this message was sent on March 20th of 2019. Under the parties, it would show the owner, that's Lori Vallow, and it was sent to her brother Alex Cox. And then under the body, it contains the text message that was sent. In this case, it says, "I'm finding out some great stuff about you. I'm going to do some sealings. Can't wait to share all the things I learned about you. Wow, you're going to like it. It explains a lot."
And so when you looked at those texts, were you also aware of what was happening around in that case to determine whether a text is relevant?
Absolutely. As I was a participant in this case in its totality from essentially day two. And so having that knowledge as the investigation progressed helped me to understand which text messages or other types of communications or records that might exist in the iClouds, whether they were relevant or pertinent to the investigation. If they were, I would make a note of that, and that's how I proceeded as far as my analysis is concerned.
So when you were determining whether a particular, well, let me ask you, was every single text that Lori Vallow sent relevant to the investigation into what happened to J.J. Vallow, Tylee Ryan, and Tammy Daybell?
Not at all.
Okay, why do you say that?
Well, there were hundreds, thousands of texts between Lori Vallow and friends and associates, between car rental companies, hotels, insurance. There was a lot of communications regarding appointments and medications for JJ and things that Tylee was doing. So there were the normal everyday type of communications that most individuals have. And so those, I examined those, but they certainly really didn't have any bearing on the case.
So how did you determine what was relevant?
Based on the investigation, the totality of the investigation, what we had uncovered from witness interviews, and from the various searches and other efforts that we were engaging in, we had developed a pretty good idea of what may have occurred, and I was looking for communications that were indicative of participation in the disappearance of JJ, Tylee, and Tammy Daybell.
And when you started looking at the records on the iCloud account, was it still actively a search for JJ and Tylee?
When I began, yes, it was. But I have looked at this over the course of several weeks and months, and certainly reviewed it as the case has gone on. So the initial review started prior to the children being found, and that review continued.
Even after they were recovered but not alive?
Correct.
And any idea how many hours it has taken you to go through all of these records?
Well over 200 hours.
Okay. And so in those excess of 200 hours, did you also, as you were reviewing it, sort of find investigative leads or concepts that merited following up?
Yes.
What were some of those investigative leads or concepts that merited following up?
First and foremost, it was the relationship between Lori Vallow and Chad Daybell.
Why is that? Why is that relevant?
Well, it was apparent that they were very quickly after meeting involved in an illicit affair with one another, and that they shared plans to be married and have a life together.
Were there any other investigative leads or concepts that needed follow-up?
Yes, as part of the plans between Chad Daybell and Lori Vallow, they had obstacles that were in the way of them achieving.
Your Honor, I want to object that this is argumentative.
Sustained.
When you say they had, understand the court's ruling, so you identified leads that followed up. Did you find information or discussion that there were barriers to their efforts to be together?
I'm going to object this to argumentative. The question is argumentative.
Judge, it's an investigative process, and if it had significance to him, the jury is entitled to hear that, especially if it factored into his creation of a summary.
It's overruled.
Thank you, Judge.
There were several communications regarding Tylee and JJ that were relevant to their deaths.
Okay. How so?
They discussed their deaths.
Okay. And what did that have to do with the concept that they had begun an affair or planned a future together?
After the affair began, there then began to be communications regarding the deaths of Charles Vallow, Tammy Daybell, JJ Vallow, and Tylee Ryan.
Okay. Any conversations about Tammy Daybell?
Yes.
Okay. And was there communication that law enforcement had to follow up on that suggested that those individuals were considered barriers to the by the defendant to her future with Chad Daybell.
I'm going to object as to argumentative, Judge.
Overruled.
The exact word they used in the communications was obstacles.
Okay. And just to be clear, the communications between who?
Chad Daybell and Lori Vallow.
Okay. And they characterize JJ, Tylee, Tammy, Charles as obstacles.
Correct.
Your Honor, I'm going to object as this misstates the actual evidence.
Were there any other investigative leads or information that merited following up?
Yes, there was financial information that was deemed to be relevant. There was information regarding the relationship between Alex Cox, Lori Vallow's brother, and Lori Vallow and Chad Daybell that were relevant.
And was there, in terms of the financial information, why would that be relevant in analyzing the iCloud account in context of this investigation?
Well, during the course of the investigation, one of the elements that we examined was a potential financial motive for the crimes. And so that was part of our process in being thorough as it relates to looking at all the information that was available to us as we conducted the case.
And in the review of the evidence of the case, in particular the information contained in the iCloud accounts, was there information that suggested there was evidence of financial motive for these individuals?
I'm going to object, Your Honor. That's argumentative.
Overruled.
Yes.
What evidence did you find that merited following up as an investigative tool or investigative avenue?
In the iCloud specifically,
Representative of investigative concepts or communications by the defendant?
yes, I chose those pieces of data. So there are text messages, there are multimedia messages, there are videos, there are emails, there are notes, and those things that I deemed to be pertinent, to be directly relevant to this case. I would, in terms of preparing my summary, I would cut and paste directly from the iCloud and put it into a PowerPoint presentation. So that was my method, was to cut and paste exactly what is displayed in the iCloud account into the summary exhibit.
Okay. Can you just use the pointer again and show us what you would cut and paste, just so that we're clear that you literally took from the iCloud and put it into your summary exhibit?
Certainly. So again, there's a timestamp which shows a date and time, the parties, and then the communication. So I would note the date and the time, the parties, and then I would cut and paste. I didn't cut the specific phone numbers, I just noted the parties, but I would cut and paste in its entirety each message or piece of data.
Okay. So you didn't hand type it, you cut and paste from the original into your summary?
Correct.
Okay. And that summary was prepared in anticipation of explaining your investigative findings to the jury?
As an aid, yes.
Okay. And that summary was an effort to sort of show the representative ideas and evidence found in the iCloud?
Correct.
Okay. You're going to ask that the witness be handed States Exhibit 183 and 183A. A courtesy copy of which has been given defense counsel. Agent, did you get a chance to look at States 183 and 183A?
Yes.
What are they?
This is 183A is a hard copy of the PowerPoint presentation that I prepared for a summary exhibit. 183 is an electronic copy of that with my initials on the thumb drive.
Okay. So you prepared that thumb drive?
Yes.
Okay. And 183A is a physical hard copy for use in court or by the jury?
Correct.
Okay. I move for the admission of States Exhibit 183 and 183A.
Any objection?
Yes, Your Honor, we stated on the record prior to or outside the presence of the jury what that objection was, and we just stand by that objection.
All right. The court heard argument on an objection earlier this morning outside the presence of the jury. I made a ruling with no new substance to the objection. The court will stand by its prior ruling and allow for the exhibits 183 and 183A to be admitted.
Thank you, Your Honor.
And you're making sure the court has their courtesy copy of 183A, correct?
Thank you. I do.
Thank you. I request permission to display States Exhibit 183A.
You can publish it.
Thank you.
And actually, I think what you're publishing is 183, not A.
I apologize. Yes. Thanks, Judge.
You're welcome.
All right. Agent, if you could look at the screen, I see displayed an initial slide and states Exhibit 183. What are we seeing here?
This is a line that I located in the contact section of Lori for Style at iCloud.com. And it was saved under the name of Bishop Shumway. It was created on October 28th, 2018. What stands out about this particular contact is that the telephone
Objection,
number.
Your Honor. He's now giving a narrative explanation.
Oh, sustained.
Okay. So what is it that it stands out about the slide we're looking at?
What stands out is that the phone number 208-690-9374 is the known cellular telephone number for Chad Daybell.
And what was the date this contact is reflected in the cell phone data or the iCloud account of Lori Vallow?
It was created on October 28th, 2018.
And just so that we're clear, that date had significance because why?
Chad Daybell and Lori Vallow met at a Preparing a People conference in St. George, Utah on October 26th, and that conference spanned the 26th, 27th, and 28th of October.
Is this the first known electronic evidence of contact between Chad Daybell and Lori Vallow?
It is.
So turning to the next, which is labeled the SMS section, Lori for Style at iCloud.com, what are we seeing here?
This is a text string between Lori. Lori Vallow and Audrey Baratario that took place on January 23rd of 2019.
Okay. If you could read to us into the record what that text string was.
Yes. Line 2585. Hi, Audrey. This is Lori. I would love to talk to you sometime. Text me or call me. I'm excited to be able to talk to you about what we both know. Line 2584. Oh, hi, Lori. Guess you talked to Chad. Ha ha. Line 2580. Did he tell you I have a crazy work schedule? I might be able to talk tonight. I'll have to play it by ear, but it wouldn't until ABT 9:30 p.m. or after. The same for tomorrow. Line 2578. Lori Vallow to Audrey Baratario. He did. That's okay. Just let me know when you are available. No pressure. I just think it's fun to talk to someone who knows what's really going on. Line 2576. Reply from Audrey Baratario to Lori Vallow. So what times usually work for you? I usually talk to him on my lunch breaks in Mondays or Tuesdays. Sunday afternoons, I can talk.
Agent, my question is, this communication by the defendant with Audrey Baratario, what, if any, significance did it have to you?
The significance that it had to me is the reference to what Lori Vallow and Audrey Baratario both knew.
Why is that significant?
It's significant because Chad Daybell had disclosed to Audrey Baratario his plans to marry Lori Vallow.
Okay. And did it also indicate anything about an establishment of a friendship or a relationship between Audrey and Lori?
Yes, Chad had told Audrey Baratario that his wife, Tammy Daybell, was going to die and that he and Lori were to be married, but he wanted Audrey to act as a buffer between he and Lori during the ensuing time period until Tammy Daybell died.
And does it indicate that Audrey Bartari was willing to engage in that friendship with Lori?
Based on the text string, yes.
Now, turning to an SMS text section in Lori for Style at iCloud.com from March 20th, 2019. Can you explain to us what we're seeing here?
These are some texts that took place on March 20th of 2019 between Lori Vallow and Alex Cox.
Could you read those into the record, please?
Line 1842 from Lori Vallow to Alex Cox. I'm finding out some great stuff about you. I'm going to go do some ceilings. Can't wait to share all the things I learned about you. Wow, you're going to like it. It explains a lot. Line 1840, text from Alex Cox to Lori Vallow. Okay, hurry up, please. Line 1837, reply text from Lori Vallow to Alex Cox. I'm going to check everything with my source tonight to make sure I got this all right, but it's really good. We can talk about it tomorrow, hopefully.
Now, Agent, why did you include this in your summary?
During the course of the investigation, it became apparent that Chad Daybell acted as a quasi-religious leader and that Alex Cox was involved in the alleged conspiracy as it related to the deaths of the children and Tammy Daybell. And this is an instance where Lori Vallow is communicating to her brother Alex Cox regarding the things that she is learning about him. The reference to going to check with my source tonight, I believe, is a reference to Chad Daybell.
Objection calls for speculation.
That's overruled, but obviously you can go into that on cross.
Very good. Thank you.
Now, looking at this text, you indicated that Chad became a quasi-leader. Was there evidence to suggest why Lori Vallow would be communicating that to Alex Cox rather than just Chad?
There were occasions where Lori Vallow made direct communications regarding religious matters or religious concepts, but it was frequent and repetitive that Alex Cox, Melanie Boudreau, others would solicit Lori to check or inquire with Chad Daybell and then would return answers back to those individuals.
In context of the evidence from the iCloud and the other evidence in totality of the case, was there evidence on Lori Vallow's sort of position power with regard to those people in religious concepts?
Yes.
What was that position power and what evidence was there of that?
Her position was right next to Chad Daybell. The two of them were in an elevated position, and others would seek their counsel and advice as it related to alleged revelations and visions and so forth.
And in seeking that counsel or information, was there any evidence at times that Alex Cox or others would seek direction or instruction from Lori Vallow?
Yes.
And is that reflected in some of the text that you've provided in summary?
It is.
Was it is it reflected throughout both iCloud accounts and the overall account of Lori Vallow?
Yes, it is.
Now, turning towards an SMS text from Lori for Style at iCloud.com, can you tell us what we're looking at, from line 1763 through 1761?
This is another short text string between Alex Cox and Lori Vallow that took place on March 26th of 2019.
And could you read those lines into the record, please?
Yes. Line 1763, text from Alex Cox to Lori Vallow. Correct. Charles's body is alive. Line 1762 from Alex Cox to Lori Vallow. What did you learn? Line 1761 from Lori Vallow to Alex Cox. A lot. Still working on it. We'll call you later.
Why was this series of the SMS included in your summary?
These short texts actually contain a lot of information regarding what was taking place in the investigation.
How so?
Chad Daybell had identified Charles Vallow as somebody who was a dark entity whose body had been possessed by any number of spirits, which were named with various names. And so this first text, when Alex Cox is reaching out to Lori Vallow, he's affirming that Charles Vallow's body, his physical body, is still alive, and inquiring what Lori Vallow had learned about that, which she replied she had learned a lot and would contact him later.
And so learned a lot. What does still working on it mean in context of the iCloud account and the overall investigation?
We see, or I saw, very frequent usage of that particular term. We are working on things, and that is a direct reference to this belief that they were in a battle against zombies and dark entities, and so when they would talk about working on something, they were making a reference to their efforts
I'm going to object.
related to that.
This is misstating the evidence that's actually been put in.
I think it's beyond the scope of what's been entered, so I'll sustain that.
Okay. When you say they said working on it, was it often Lori Vallow herself saying working on it?
Yes.
Okay. And in your review of the text section in the MMS and the various iCloud accounts reflecting Lori Vallow's statements or state of mind, did you see evidence that her brother believed what she was saying?
Frequently.
Okay. Did you see evidence reflected that would show that Alex Cox was seeking input or direction from his sister with regard to the various potential bad spirits or people's physical body?
Yes.
Turning to the SMS section of LollyTime at iCloud.com, and I see a group of text from July 9th of 2019. Is that accurate?
Yes.
Okay. And I noticed that each of these slides have appeared chronological, and forgive me if I didn't ask, in preparing your summary, how did you put the various text into your summary?
I did that chronologically. So in the summary, you'll see we may move back and forth between Lori for Style at iCloud.com and LollyTime at iCloud.com. For the most part, it's Lori for Style in the beginning and the ending of this summary exhibit, and most of the middle of it is taken from LollyTime at iCloud.com. But I placed all of the data chronologically.
Why?
I think that paints the most accurate picture of what was taking place as it relates to the communications. If you separate them out into various sections, then it becomes very fragmented. And I believe that chronologically, these events took place chronologically, so it made sense to arrange the exhibit chronologically.
Okay. And so we're seeing a text communication July 9th, 2019, between Lori Vallow and Melanie Boudreau. Is that correct?
Yes.
Could you read those into the record, please?
Yes. Line 3135 from Lori Vallow to Melanie Boudreau. They have an elaborate plan. I'll call you soon. Line 3134 from Melanie Boudreau to Lori Vallow. I could take all the babies with and drive and take our stuff. Line 3133 from Lori Vallow to Melanie Boudreau. You can't go at all. We both need to stay here to defend ourselves. Line 3132 from Lori Vallow to Melanie Boudreau. It's coming to a head. This week will change everything.
Why did you include that particular series of text from Lori Vallow in your summary?
Your Honor, the only way he can answer that is through hearsay evidence.
I'll sustain that objection.
I'm sorry, Your Honor. I guess I don't understand the objection.
Your Honor, would the court like me to clarify?
May we approach sidebar? Because I really don't understand.
Well, I'd like to have the question reread, please.
Okay.
All right, upon rehearing the question, I misheard that. I'll overrule that objection.
Thank you. Thank you. Did you hear the question?
Do I have it repeated? I'm sorry. Okay. The timeline in this case is important. So this text string took place in the evening of July 9th, 2019, which is approximately 36 hours before Charles Vallow was killed. These texts are a reference to events surrounding that.
Okay.
And again, Judge, I'm going to object just for the record that the only way he could have gotten that information was specifically to Melanie Boudreau is through hearsay evidence from Melanie Boudreau.
All right, well, he's testified it's through information obtained through these iCloud accounts. So for that, and because they've been admitted, I'll overrule the objection.
Thank you.
All right. And so the timing of this communication by Lori Vallow was significant to you in relation to the death of Charles Vallow.
Correct.
Okay. And in the text, it was a text from Lori Vallow. In her own words, it's coming to a head. This week will change everything.
Yes.
Okay. And when in context of the investigation and the overall review of the iCloud, what does it's coming to a head mean to you?
It's a reference to the marriage between Charles Vallow and Lori Vallow. Their marriage from the communications and the totality of the investigation had deteriorated substantially.
And I'll object to speculation that she's calling for him to speculate as to what these texts mean.
I'll sustain that.
And ask to strike that from the record.
All right, the final part of that answer will be stricken from the record based on the objection. The jury's instructed not to please consider that particular response.
So in your review of the evidence, in your review of the iCloud, did you learn from the defendant's own words that her marriage to Charles Vallow was deteriorated?
Yes.
Okay. In fact, I believe you earlier talked about that she characterized Charles Vallow as an obstacle. Is that correct?
Objection, that's argumentative, Judge.
Overruled.
It was actually Chad Daybell who used the phrase obstacles relating or in connection with these individuals.
Okay. And so it's coming to a head, that statement from the defendant. Was there evidence within the iCloud that you reviewed, the defendant's own words, that reflected whether or not she wanted Charles Vallow out of her life as her husband?
Yes.
Okay. Let's turn to some additional text from Lolly Time on July 9th, 2019. reflected in the next slide. Could you please look at lines 3120 and 3072? Do you see those?
I do.
Could you read those into the record, please?
Yes. Line 3120 from Lori Vallow to Alex Cox. Getting sleepy, so I'm going to need you to stay close to me the next couple days. Mel too. She can't go to Utah. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. Line 3072, text from Lori Vallow to Melanie Boudreau. Al is here. Charles says he will come over in the morning.
Why did you include these particular texts from Lori Vallow to Alex Cox and Melanie Boudreau in your summary?
Your Honor, I'll object that these takes things out of context. He specifically stated that he is going in line by line, and it looks like there's almost 100 lines between these two texts.
I'll overrule the objection, and I think it's appropriate for cross-examination.
Very good. Thank you.
I'm sorry, the question was, why did you include these particular text communications from Lori Vallow to Alex Cox and Melanie Boudreau in your summary?
During the course of the investigation, we found out that Adam Cox, another brother of Lori Vallow, had flown in conjunction with Charles Vallow to try to approach Lori regarding the things that were taking place. And so that's why I included these communications.
Okay. And turning to line 3120, I will be like Nephi, I am told, and so will you. In your review of the evidence and your research on the items of relevance in the iCloud account, what is Nephi?
Nephi is the name of an ancient prophet whose life is documented or chronicled in a book of scripture called the Book of Mormon. And so he is one of that book of scripture spans from 600 BC to roughly 400 AD, and Nephi is one of the first prophets that is documented in that particular book.
Okay. And the phrase, I will be like Nephi, other than an ancient prophet, was there significance to the investigation that merited review in the use of the word Nephi as applied to Lori Vallow and Alex Cox?
Objection. Calls for speculation. He's already indicated that Nephi is found throughout the Book of Mormon, which is hundreds of pages long.
I'll sustain the objection.
Thank you.
In terms of Lori's use and her own words identifying herself as Nephi, what were the situations involving Nephi that were relevant to the investigations?
Objection. Calls for speculation.
I think there need to be some additional foundation. You're going to go into that term and what it means in the context of these communications.
Okay. So in terms of foundation, are you aware of historical attributes or story significance to the prophet Nephi?
I am.
Okay. What were the historic accounts related to the prophet Nephi?
Okay, objection vague. There are hundreds of stories about Nephi.
That's overruled.
Thank you.
If the witness knows, the witness can answer.
The primary one relates to an incident where Nephi was commanded by God to slay an individual named Laban.
Your Honor, I'm going to object as this is speculative.
Overruled.
I'm sorry, you can keep going. You said it was about Nephi was commanded to slay Laban.
Yes.
And what was the rest of that particular historic accounting of the prophet Nephi?
Simply put, Laban was in possession of records that Nephi and his family wanted to possess before they left Jerusalem. and Nephi was commanded by God to slay Laban to obtain those records.
And so Laban was Laban considered a good guy or a bad guy?
Bad guy.
Again, Your Honor, based on his response to the question, I believe it's irrelevant, and it specifically doesn't have anything to do with the crime that's charged here, and it doesn't even correlate.
Well, there's a reference to the term in the text, and I'll allow a little more on this, but it's getting outside the scope of, I think, what's relevant. Pretty quick here, Ms. Smith.
The defendant herself likened herself to Nephi, correct?
Yes.
And the defendant likened Alex Cox to Nephi, correct?
Yes.
Okay. And if I understand correctly, Nephi was commanded to kill Laban.
That's correct.
I'm going to object as to vague. Nephi was commanded to do lots of things.
Overruled.
And the date that the defendant likens herself to Nephi was July 9th, 2019?
Yes.
She also told Alex he was like Nephi, correct?
Yes.
Okay. And in the text communication from Lori Vallow to Melanie Boudreau, did Lori Vallow indicate on July 10th, 2019, that Alex Cox was with her?
Yes.
Okay. Now, defense counsel pointed out, and we're going to chat about this in a minute, I noticed that there's a line number and a date, and then it appears to have a different line number and a different date in your summary. Why didn't you include every text between those two?
If I included every text between the two accounts, we would be at well over 8,000 text messages. And so I chose those texts that I felt were in context and were relevant. But oftentimes there would be 3 or 4 people texting with Lori Vallow at the same time, and some of those texts in between have no relevance whatsoever to this case. Other texts were very redundant. We see the same type of communication over and over and over again. And so I chose those text messages that I believed were relevant to this case and was cautious not to prepare this summary exhibit where I'm taking things out of context.
And if you included every text, it really wouldn't be a summary, would it?
No, it wouldn't.
Okay. Now, turning towards some chats that were in Lori for Style, can you tell us what we're seeing next on slide 7?
Yes, this is a chat in the iCloud account generally was amongst multiple individuals, and the chat would contain could contain numerous texts. This is a chat between Lori Vallow, Cole Vallow, and Zach Vallow. Cole Vallow and Zach Vallow are Charles Vallow's sons.
Okay. And this is communication from Lori Vallow in that chat?
Correct.
Okay. Could you please read into the records the communications that Lori Vallow had and to whom?
Certainly. So July 12th, 2019. Hi, boys. I have very sad news. Your dad passed away yesterday. I'm working on making arrangements, and I'll keep you informed with what's going on. I'm still not sure how to handle things. Just want you to know that I love you, and so did your dad. 3:41 p.m. on the same date. Lori, what happened? 3:43 p.m. We are still waiting for the ME report. I'll let you know more when I can. 5:54 p.m. Lori, what the fuck happened? You can't just tell us out dad died and disappeared. You're not too busy to just let us know he died and disappear.
Why did you include this particular series of chats in your summary?
For timeline purposes, this series of communications took place the day following Charles Vallow's death, and it is indicative of the communication from Lori Vallow to Charles Vallow's sons regarding their father's death, but excludes the manner of death.
Now, let's move ahead. In terms of within a few hours of that on July 13th, could you tell us what we're seeing in the SMS section of Lolly Time at iCloud.com?
Yes, this is a series of texts between Chad Daybell, Lori Vallow, and ultimately Melanie Boudreau. Subsequent to Charles Vallow's death, Brandon Boudreau, Melanie Boudreau's husband, brought an individual to the house to talk with Melanie, and this series of texts is in regards to that person.
And Lori Vallow was a part of this text communication, correct?
Yes.
Okay. And it was a text communication between Lori and Chad and included Melanie Boudreau.
Correct.
Okay. Could you please read those into the record?
Yes. Line 3002 from Chad Daybell to Lori Vallow. I will check all bloomer and husband. Line 3001 from Lori Vallow to Chad Daybell. Good idea. Line 3000 from Chad Daybell to Lori Vallow. Allie Bloomer is 4.1 dark. Her cop husband is 3 dark. I suppose Brandon doesn't know yet about the discovered Charles's texts. Line 2996 from Lori Vallow to Melanie Boudreau. Allie Bloomer's husband, 3, and then a dark emoji.
And so these texts, involving Chad, Lori, and then ultimately Melanie Boudreau were between 9:30 p.m. and around 10:05 p.m. on the 13th, correct?
Yes.
Okay. And why did you include these texts between that time in your summary?
I included them because they demonstrate that anyone who tried to intercede was identified as dark.
I don't understand how.
I don't want to object. That's speculative, and we're now getting into the weeds.
I'll sustain that, and we should have the answer stricken, I presume.
Thank you, Your Honor.
All right, the previous answer will be stricken, not to be considered by the jurors.
Okay. So, did you have in context of the iCloud, did it reflect who Allie Bloomer was?
Allie Bloomer was a friend of Melanie Boudreau.
Okay. And
Brandon Boudreau.
Okay. And did you learn whether or not Allie Bloomer had approached Melanie Boudreau about her situation with Lori Vallow?
It was Brandon
Objection,
Boudreau.
hearsay, Judge.
Overruled.
It was Brandon Boudreau who brought Allie Bloomer and her husband, who was a police officer, over to the house to talk to Melanie Boudreau.
Okay. And then this text communication reflects reaching out by Lori Vallow and Chad Vallow, and ultimately to Melanie Boudreau about the sort of status of Allie Bloomer and her husband.
Correct. Those two individuals visited the Boudreau residence, and they were identified as dark.
Now, sticking within this same time frame, within a day and a half of Charles Vallow's death, there were other text or SMS that you considered relevant?
Yes.
Can you tell us what we're seeing as reflected in line 2967 from July 13th?
Yes, this is a text between Chad Daybell or a text from Chad Daybell to Lori Vallow regarding plans for the two of them to get together.
Can you please read that?
Yes. Line 2967. Concerning the 2 weeks, BYU Idaho's graduation is July 23rd. Adam is getting his bachelor's, and Leah and Joe are getting their associates. They are all walking in the same commencement ceremony. I feel she will be gone by then, but I will still have that hoopla to deal with because a lot of my and Adam's family are coming and will stay for July 24th. So I believe that's why the Lord hinted I might not get to be with you until that is over. Please ask about that.
I can get used to this.
Me too.
Experience more with a $100 credit at hundreds of hotels from Chase Sapphire Reserve. Chase, make more of what's yours.
Good morning, Audrey.
Good morning.
Would you please state your name and spell your last name for the record?
My name is Audrey Baratero, Audrey Barattiero.
And what city and state do you reside in?
Gallatin, Missouri.
Okay. Have you heard the name Lori Vallow?
Yes.
How do you know Lori Vallow?
She was a friend.
And how did you first meet her?
I attended a conference, the end of a conference in November 2018, and her home was offered as a place where people could stay.
So that conference, I think you said, was approximately when?
November 2018.
Okay. And you stayed in her home during the conference?
At the end of the conference, yes.
Do you recall who else stayed at Lori's house?
I think Zulema, Melanie Gibb, and there was others, and Chad Daybell was there.
Okay. Do you recall where Chad Daybell slept while he was at the residence?
He slept on the other side of the home.
Okay. Were you able to observe Lori and Chad together during that time?
Yes and no. I observed that every once in a while they looked at each other, or there was like just a, kind of a vibe.
A vibe. So your observations with how they interacted, can you expound a little bit more on that vibe? Did they seem flirtatious? Did they seem like they knew each other? Did they seem...
They didn't seem flirtatious, but it seemed like maybe they knew each other a little bit or something.
Okay. And were you aware if they had met previously?
I think that they met in St. George.
Okay. When did you next have contact with Lori?
I believe in February, so about 3 months later or so. And Chad asked me to be her friend.
Okay. So I was going to ask you how that occurred. Can you just explain a little bit how Chad asked you?
He asked me to be her friend,
okay.
And that she needed a friend, and I said, okay.
Did he say why she needed a friend?
He said that he couldn't talk to her all the time, and that maybe I could be someone to like uplift her or, be a friend.
Okay. And you mentioned this occurred in February. Would that have been the February of the next year?
Yes, 2019.
Okay. And when you talked with Chad, how were you talking with Chad?
I was talking with him on the phone.
Okay. So he asked you this over the phone about
Yes.
Okay. And how often would you say that you talked with Lori on the phone after that?
Usually it was every few weeks, but there was times that it was every couple weeks or a week, but for the most part, every few weeks.
Did you get to know each other over the phone?
Somewhat. We talked about more so spiritual things, not as much things going on in personal life stuff.
Okay. And when did you next see Lori in person?
In the summertime.
Okay.
Of 2019.
Summertime in 2019. What kind of event were you attending at that time?
There was a event that was scriptural based and somewhere in Utah. Utah Valley, and I went to that.
And I just want to back up a little bit. I think you said that Chad asked you to be Lori's friend because he couldn't talk to her all the time. Do you know what that meant?
My impression was that he was trying to keep propriety because he was married.
And this conference that you saw Lori at next, you said it was in the summertime. Where was that conference held?
I'm sorry, can you say that again?
Where the conference that you attended in the summertime, where was it held?
It was held in Utah somewhere in the Salt Lake Valley.
Okay. And where were you living at the time of that conference in the summer? Do you remember what month it was?
I don't, but I would guess that it was in June or July.
Okay. And where were you living at that time?
I was living in Utah.
Okay. So you lived in Utah and you attended a conference in the same state. Is that
Yes.
right? Okay.
Yes.
And do you know where Lori stayed when she attended that conference?
In a hotel.
Okay. Did you spend any time with Lori?
Yes.
Do you recall who else visited with her and you?
Zulema was there, and Melanie Gibb, and there was some other women that I didn't know.
And what did Lori talk about at that time?
I don't remember what was talked about, but at the end of being there, she brought up wanting to work on her husband at the time.
Okay. And do you know who her husband at the time was?
Charles.
At some point, did you go back to her hotel room?
Yes, that's where she brought it up.
Okay. So when you say that she wanted to work on her husband, Charles, what does that mean?
Do you want me to back up a little bit?
Sure.
So at some time close to that time, when I had seen her again after not seeing her for a long time, she all of a sudden, out of the blue, brought up all of this stuff about zombies and people being possessed is kind of the idea of that. And I hadn't heard of that before and had no basis for that. And that's why she brought that up in the hotel room, because that was something she was doing herself.
Okay. So let's just break that down a little bit to make it a little more clear. So you mentioned that sometime before this, she was talking about zombies and people being possessed.
Yes.
How was she talking to you about that?
On the phone.
Okay.
I hadn't talked to her in like 3 weeks. And all of a sudden she brought up all of this things she had learned. And it came out of the middle of nowhere. And then she asked my thoughts about it, and I said I didn't have a basis for it, and that it made me feel uncomfortable. But she was basically alluding to people, the term, I guess, that eventually she called it was zombies, and that it was people being possessed or having a spirit like connected to them or something.
Okay. And was the spirit good or bad or light or dark?
It was supposed to be bad.
Okay. So you first heard about this on the phone.
Mm-hmm.
And then when you were at the conference in the summer, she brought it up again?
She brought it up again, yes, in the hotel when the women were there.
Okay. And so when you're at the hotel and you're talking about this, what else happened in the hotel room?
People were just like kind of chatting and, just small talk kind of a thing. And then she brought up saying that she wanted to like work on trying to get a negative spirit out of Charles.
Okay.
And, but actually I should say at first it was just like everyone started holding hands and I didn't know what they were doing. And I thought maybe there was going to be like a group prayer or something. And so they all held hands, and I joined hands as well, thinking it was going to be a prayer. And then she started talking, basically to say that she was going to try to get a spirit out of Charles. And each woman would say something. And then.
So what do you recall Lori saying?
I don't remember exact words, but things like knives and fire and like weapons that you would try to use to, that kind of an idea.
Okay. And when you were holding hands with this woman, were you standing, sitting? How were you guys?
Sitting.
Sitting in the room. Okay. And that was the first interaction that you had with this circle or this casting or this work?
Yes, and I didn't know that term of castings. And when it got to me, I didn't feel comfortable and didn't say anything. And then as soon as that was over, I left.
Okay.
Because I didn't want to stay.
Okay. After this interaction in person with Lori, did your acquaintance or friendship with Lori continue?
Yes, it did.
How did you communicate?
On the phone.
Okay. And were you communicating with Chad Daybell during this time as well?
Yes.
Now, how did you meet Chad?
I met him in a event in St. George. I had never heard of him before. And he was a speaker and wrote books. And someone said, oh, you should go and hear him speak. So I did. And then I bought a couple books.
Okay. And do you know what Chad did for a living?
He was a speaker and an author. He wrote books.
How many books of his have you read?
3.
Okay. At some point, did you have contact with him about his books?
Yes. About 2 months after I had seen him at that time in St. George in 2018, he reached out to me on Facebook to open up communication. And at that time, I asked him some questions I had about his books.
Okay. So who initiated the contact?
He did.
And that was on
Facebook.
Facebook, okay. How would you communicate with him after that?
On the phone.
On the phone. Did you continue to communicate on Facebook or was it just on the phone?
Just on the phone.
Okay. And what kinds of things would you talk about with Chad?
Religious things.
Okay. And you were continuing to talk with Lori?
Yes, about a month and a half or so after he started a conversation, and then he asked me to be friends with her.
Okay. Once you started talking with Lori, I think you said February 2019?
Yes.
What would you talk about with her?
About like religious things or spiritual experiences.
Okay. Do you recall talking to Lori about her move to Rexburg?
Yes.
And do you know where Chad was living at the time?
He was living in Rexburg.
Do you recall talking to Lori in late August or September 2019 about her daughter, Tylee?
Yes, there was a few times in the fall that I asked her how her daughter was doing. When I stayed at her house in November 2018, I met her daughter for a few minutes. Okay. And so in the fall of 2019, I asked every once in a while, like, how's Tylee doing? Because she was at college. And towards the end of the friendship, when I asked her how's she doing at BYU, she said that she doesn't talk to me very much these days.
Okay. So I think you mentioned you had met Tylee initially at that Arizona conference.
Yes.
Okay. Did you ever meet JJ?
Yes, for about 5 minutes, yeah.
Okay. Did you ever have the opportunity to meet Tammy Daybell?
Yes, I did once.
And how did that occur?
I happened to just be going to Idaho, and Tammy and Garth and Chad wanted to go to dinner. And Garth is one of Chad's sons. And so we went to dinner, and I liked her very much.
And do you know who Tammy was married to at the time that you met her?
She was married to Chad.
Did Chad ever say anything to you about Tammy?
Yes, during the course of the friendship, he said that he had had a near-death experience years before, and that he had been told by a deceased relative that Tammy would pass away before she turned 50.
Do you recall when he told you this?
I would say around the end of January 2019 or in February 2019.
Okay. And at some point, did he indicate to you that he felt he would get married again?
Yes, he did.
Did he tell you who he would marry?
He didn't tell me for a while, but then eventually he said Lori.
Okay. And did he discuss this with you prior to Tammy's death?
Yes.
What were your observations regarding that?
What do you mean?
What did you say to him? What did you
I asked him if he had talked to Tammy or his children about it, and he indicated that he had talked to Tammy for sure, and I don't remember about the children.
Okay. Now, you mentioned when you talked on the phone with Chad and Lori, you talked about religious stuff, spiritual stuff. Did they talk about other spiritual or religious teachings with you? Besides what we've already kind of covered?
Yes.
Did they talk to you about prior lives or probations that Lori and he had?
Yes.
What do you remember about that?
He said that he had been Methuselah, and he said that he had been an apostle at the time of Jesus Christ, James.
Okay. And do you recall if Lori and Chad indicated a belief that they had been married in previous lives?
Yes.
Do you know what names they claimed to have in that prior life?
I don't remember about the time when he said he was Methuselah. I remember that she was somehow around, according to them at that time. But I remember that he indicated that they'd been married at that time when he said that he was an apostle.
And he said he was who?
James.
And do you recall who he said Lori was?
His wife. And he said her name was Elena.
Elena or Elena?
Elena.
Okay. At some point, did you move away from Utah?
Yes, I did.
Where did you move to?
I moved to Missouri.
Okay. Did Lori come and visit you in Missouri?
She did. She and her niece, Melanie Boudreau, said they didn't have anything else to do and asked if they could come and see the church historical sites in Missouri. They had never seen them.
Okay. Do you remember when that was?
October 2019.
Do you remember if it was the first part of October or later?
The first part.
Okay. And you mentioned that Melanie, her niece, was with her. Is that right?
Yes.
Okay. Was anyone else with her?
No.
Did you ever see Tylee with her in Missouri?
I did not.
You mentioned that the reason for their visit was to see some of the church sites.
Yes, they said that they had some free time and wanted to go see the church sites. They'd never seen them before.
Did you visit with them at that time?
I did.
Where did you guys visit?
We went to a place called Adamadiaman and to the temple, and they went to Liberty Jail.
Okay. At some point, did you also go back to their hotel room?
I did.
Did you stay there with them?
I did stay there one night, yes.
Okay. Now I want to talk to you a little bit more about this experience that you had in the conference in the summer in the hotel room.
Mm-hmm.
That was, I think, the first time you'd heard about this idea of zombies and people being possessed. Is that right?
Yes.
And do you remember when you first heard Lori use the term zombie?
I don't, but it would have been in the summertime.
Okay. And do you know what it meant when she was explaining this, if someone was a zombie?
Yes. The idea was like the person was possessed and that there was a spirit in them that needed to be taken out.
Did you ever discuss with Lori or Chad whether someone was light or dark?
Yes.
What did that mean?
Chad had this idea that, I guess, like he would say if someone was light or dark, depending on if like they were predominantly a good person or if he predominantly thought that they were a negative person.
Okay. Did you discuss with Lori people that she believed were dark or were zombies?
Yes.
And who were those people?
She said her husband Charles was, and then later at the end of the friendship, she said that her children were.
Anyone else?
And Tammy.
Okay. Yes. And so her children, can you just give me their names again?
Tylee and JJ.
So these included Charles, Tylee, JJ, and Tammy. Is that right? Was there anyone else that she talked about being dark?
Yes. Melanie Boudreau, one or two of her children.
Okay. Now I'm going to go back to when you visited with her and Lori at the hotel room in Missouri. What happened there?
They invited me to stay in their hotel room instead of driving back to my house, which was a distance away. And it was going great. And then basically she brought up the idea of working on Tammy.
Okay. And again, when you say working on, what did you guys do?
She said that Tammy had a spirit that was in her and needed to be taken out. And I told her I did not want to help and that I did not want to participate. And she
Sorry. It's okay. If you need to get some water.
She highly pressured me, saying, "You're supposed to be my friend. You're supposed to help me. Like Chad asked you to be my friend." And I reiterated that I didn't want to. And she kept on. And this was later in the night. And I didn't know, I didn't do those things in my own life. And I said that I would say a prayer. And basically, I said a prayer to Heavenly Father saying, okay, I don't know what's going on. If there is something going on with Tammy and it needs to be taken out, I ask for thee to help her. For thine angels to help her. And I ask that she would be able to feel the love of God. And I did the prayer.
Okay. And were you holding hands with Lori and Melanie during this circle? No? Okay. Do you remember what other people were doing besides you during this circle?
They were standing or sitting.
Okay. Did Lori say anything about what needed to happen to this spirit that was in Tammy?
That it needed to be out.
Okay.
At that time, I'd never heard it before. It was, again, at the end of the friendship because I dissolved the friendship. But basically at that time, Chad brought up an idea that, according to him, that if the spirit was in someone's body, that they were somehow being held prisoner. And like an idea of a cage or something, like jail.
And so the first time you participated in something like this was in the summertime in Utah. Is that right?
Yes.
And who was that for?
That was for Charles.
And do you recall when Charles died?
I was traveling in Europe for about a month, and That was in July, so it would have been July 2019.
And after doing this other work in Missouri on Tammy, do you recall ever hearing Lori express frustration or have an explanation for why someone might have remained dark or why they were doing this multiple times?
Yes, it's like if it didn't work, at least to me, it seemed like if it didn't work, it's like she came up with a new idea. Like, it didn't work because of this. Or it just seemed like it was like, oh, it's because of this. And then, oh, there's this other thing. And then, it was another spirit that got in. And it just seemed like it, I don't know, would just keep going and going and going.
Okay. Do you recall receiving a text from Lori saying something along the lines of, well, we did a lot of work today, we got her out, but a new one got in. We're still working on it. Audrey, any ideas you have would be greatly appreciated.
I didn't remember it, but I do know, yes.
Do you know what that was referencing?
I believe it would have been referencing Tammy and the idea that she was saying there were spirits that kept, like I mentioned a minute ago, like, oh, it didn't work. So then she would say, oh, another one got in. And
okay.
With what they were doing.
Yeah. Why would Lori have been asking you for ideas or guidance?
I don't know.
Did you have any special knowledge or insight?
No.
When Lori and Melanie visited you in Missouri, did you do any other work other than on Tammy?
No.
And where did Lori say Tammy's spirit was?
She was saying that she was in a cage or a jail or something like this. And it was the idea like she needs to be freed and helped because some person's overtaken her body.
Okay. And so she wasn't in her body anymore. Sorry.
According to them.
According to Lori. And do you know what would happen if this dark spirit was pushed out?
At the end of the friendship, when I heard Chad Daybell say, something to the effect of, why is the body still alive or something like that?
Okay.
I realized that they must have a different idea.
Okay.
Even further.
Even further. And what did that mean?
That they didn't intend for the person to be helped, I would think. That they didn't want the person to live.
And after you visited with Lori and Melanie in Missouri, did you take a trip later in October?
Yes.
Where did you go?
To Hawaii.
And do you recall about when that was?
Toward the latter end of October 2019.
Okay. Do you recall who picked you up at the airport?
Melanie and Lori.
And where did you stay?
In a hotel.
Who was at the hotel with you?
Lori and Melanie.
What do you recall about your stay in Hawaii?
It was very uncomfortable. Basically, they invited me saying that Melanie was going through a hard time and that she needed a friend. And I said, I could be a friend. And when I got there, shortly after getting there, Lori told me that Tammy had passed away And I didn't know. I asked her when, and she said I'd been about a week. I asked her, how did she pass away? And she said in her sleep.
Okay. Do you recall what other kinds of things you were doing in Hawaii while you were there?
We went on a bike ride and most of the time spent time at the beach.
And what did you observe about Lori's behavior while you were in Hawaii?
She seemed agitated and snippy toward Melanie and just different emotions. Other times she would like swing and be like happy, but overall her behavior seemed different. I had not seen her behavior like that. I hadn't seen her much in person, but she had been nice and very, I don't know, but at that time, she seemed agitated or, like I said, snippy.
Okay. And now when Chad had asked you to be friends with her because he couldn't talk to her all the time, did you notice anything about her behavior that was related to Chad?
There was times that she would get phone calls and she would leave and go talk and be gone for a long time. And I would just be sitting with Melanie, trying to keep her company. And times when she was happy, it seemed like she was thinking about him, or I think had talked to him on the phone.
Okay. And did you personally talk to Chad while you were in Hawaii?
Yes.
Okay. And you mentioned that you heard about Tammy's death while you were there.
Yes.
And you heard that from Lori.
Yes.
When did Lori leave Hawaii?
She left Hawaii on Wednesday. I had said that I was going to go home. I didn't tell them this, but I didn't feel comfortable. And I was going to go home. And when I said that I was going to go home, they said, but you just got here. And then Lori said that she was going to leave. And Melanie said that she wasn't ready to go home yet, but that she didn't want to be alone. So when Lori said that she was going to be leaving, then I said, well, I could stay with Melanie so she won't be alone.
And so did Lori leave before you and Melanie did?
She did.
Okay. And do you know if that was planned?
My impression is that the ticket was bought like the same day.
Okay. Do you know where she left, where she went when she left Hawaii?
She said she was going back to Idaho.
Okay. When did you leave Hawaii?
On Sunday that week.
Okay. And where did you decide to go when you left?
Again, I wanted to ideally go home, but I didn't want Melanie to be alone because she was going.
Crunchy.
Ooh, tasty.
Oh.
Sweet or savory.
Always satisfying. Gimme Blue Diamond Almonds.
Going through a hard time. So I told her that I would fly with her there.
And when you say there?
Sorry, Idaho.
Okay.
And because I was going there so that she wasn't alone, that I would pay my condolences in person to Garth. Because I knew that he'd been very close to his mom. And then also to pay my condolences to Chad.
And so that's why you decided to visit Idaho?
Yes.
Where did you stay while you were in Idaho?
In Lori's condo.
And when you were there, did you observe Lori and Chad together?
I did.
How did they act towards each other?
Very romantic.
Did they physically touch each other?
Yes.
What did you observe?
They were kissing and hugging.
And was that just in the residence, or was there anywhere else that you observed this?
I observed it in the residence.
Okay. And do you recall who else was in Lori's residence in Rexburg when you stayed there?
Melanie stayed in one of the rooms.
Okay.
Yes.
Was there anyone else there?
No.
Did you see Chad in the residence?
At times, yes.
Okay. Do you know if he slept in the residence?
Sometimes he came back later at night, and so I didn't see him come back. But other times I did, and yes, he did stay.
Okay. And while you were in Rexburg, did you go anywhere?
Yes, we went to the temple.
Okay. Who was with you when you went to the Rexburg temple?
Chad and Lori and Melanie.
Your Honor, may I have just one moment?
Yes.
Your Honor, I don't have any questions at this time.
All right. Thank you, Ms. Rawlings.
Thank you.
Who?
Okay, I'm going to switch over to the, what is it? I think it was Law and Crime that had a live stream. So let's take a look at that. The Q&A.
Choosing him for sex, and it was like that. She was not happy at all with his closing. She does not want to throw Chad under the bus or Alex under the bus. I don't know what she wants. I don't know what she wants her defense to do. But he got up there and said, how do you know that Lori knew her kids were dead? Did the prosecution ever show you anything that she knew her kids were dead? All they ever showed you was she knew JJ was safe. So it was a very interesting closing argument. But for me, she was completely tense and started to get a little red face. I have kind of a side view of her, but I'm very close. I was just on the second row. And she was not happy with that at all. I could tell.
Which is so interesting, because if we talk about, does she really understand? I mean, she's competent to stand trial, but does she understand the nature of the showing no kind of emotion? She seemed to show emotion when it came to Chad, so that's pretty interesting to think about. All right, Terry, I got a question for you. This is from Ava Smith from YouTube. Let's talk about Lori Vallow Daybell's defense. Why didn't her defense go the brainwashing route? Since religion played into the relationship, and I use that term loosely, why no brainwashing defense?
I think that's an excellent question. Maybe they didn't think of it. And as we talk more about Lori, and Kathy mentioned the fact that she was upset when Archibald was talking about, look at Chad compared to Charles, and what did Lori know? She was just being led on. I do think, since she was very upset about those issues, that maybe it was she who didn't want to seem as though she were brainwashed. I think she controlled much of that defense, not talking anything about any mental issues, obviously no insanity defense, but not talking about mental issues, not talking about Chad and talking about Alex. I definitely think that she limited her defense, and that could, at the end of the day, have hurt her. Now, on appeal, maybe she could talk about the incompetency of her attorneys, but I think that's going to be a difficult task for her to try to prove that happened. But yeah, I definitely think that coercion or, persuasion or some sort of brainwashing could have been some issue that could have been raised that might have helped her defense.
All right. Well, again, maybe she didn't.
I can add to that.
Yeah, Kathy, add to it, because I think she wouldn't want to make
let me
Chad
add to
look
that.
negative. Yeah.
I hear that she would not allow her attorneys to bring up anything in mental health. We know that because that has been said in court, but that she would not cooperate in throwing Chad or Alex under the bus. Yep. She doesn't want any part of that at all. And their hands were tied. So I don't think they could have brought on a brainwashing expert or whatever, but that's what he did in closing. In his whole closing was she was under Chad's spell. That this guy found her at a vulnerable time in her life, and she believed, she was duped by him. And he said, He told her she was a goddess and she was going to lead 144,000 people, and he just raised her up. And how many followers did she get to the religion? He said 0. He said Chad got about 6, which is interesting because the only people were the people in Lori's life. Zulema, Melanie, Audrey, right? But he called them Chad's followers, and that Lori failed. She couldn't even get one person to follow her. So he really did do that in his closing for the most part.
Yeah, a little bit of about face. All right, so I'm going to answer the last question. It's Medak from YouTube. How can we get alerted when a verdict is reached? By following us here on Law and Crime and our Twitter page. You're going to get an hour's advance notice. We will bring that verdict to you live. And of course, we will do extended coverage and analysis of it as well. Kathy, thank you so much. Great reporting from out there. And I know you're going to be eagerly anticipating a verdict. Terry, thank you so much for taking the time to break down all these questions. And everyone out there, thank you so much for submitting your questions here on Facebook and YouTube and Twitter. It's always a pleasure to do that for you. That's all we have for you right now, but stay tuned to Law and Crime because, as I said, we will bring you the verdict live later tonight if that does come in. I'm Jesse Weber. We'll see you in a little bit.
Oops. Okay, well, I guess that seems like a natural place to we'll piggyback off of Hidden True Crime for a bit. Let me set this up. Oops. Did it in the wrong order. Share first, then full screen. Now we'll hit play.
Okay, we're on the record this morning, case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. Continuing jury trial in the case. The court would note the prosecution's present, the defense and the defendant are here present as well. The court will continue to remind everyone that these proceedings are subject to the court's conduct order, which, among other things, prohibits the transmission of any signal, audio, or video from these proceedings, and also requires you to have your cell phones silenced. This morning, we're scheduled to have closing arguments. The court will first go through its jury instructions with the jurors before the closings. I'll also indicate that there's been a pending motion that was filed. The defense brought a motion under Idaho Criminal Rule 29 at the conclusion of the evidence in this case, and that's a motion for a judgment of acquittal under Rule 29. The court took that under advisement, and I'm prepared to make a ruling today on the motion for judgment of acquittal. So just looking at the dates here. On a judgment of acquittal, first I'll start with the, well, let me just inquire and make sure. Here's the state ready to proceed this morning with all of this.
Yes, Your Honor.
All right, thank you, Ms. Blake. Is the defense ready to proceed as well?
Yes.
Okay, thanks, counsel. All right, the court will note that I did take that under advisement. It was a motion made yesterday on Wednesday on the 10th of May. And in the motion, the defense requests a judgment of acquittal under Rule 29. The state argued against the motion. Some case law that governs the court on a ruling on a motion such as this. The trial court must deny the motion if there is some evidence of guilt produced at trial. That's State versus Gradio. to the state of Idaho to the Pioneer Road apartment. There were multiple witnesses of her in the Rexburg area. There was body cam footage admitted through law enforcement officers. Also other testimony from other individuals about her moving to Idaho, including Kay Woodcock. Also on identifying the defendant for this count and others, she was identified by multiple individuals, including Kay Woodcock, Colby Ryan, and Summer Shiflett, identified in court, and that would be an element on each of the offenses. So the court finds there's sufficient evidence on those elements. And then going into the conspiracy itself, there was allegations that there was an agreement and there was a criminal conspiracy agreement leading to the allegations of first-degree murder and grand theft by deception. There was a summarizing witness towards the end of the trial, Douglas Hart, from, I believe it was an FBI agent, who went through a lot of the summary of the evidence that's been submitted through trial. Some of the overt acts, there was an allegation that there was an endorsement or espousal of religious beliefs for the purpose of encouraging or justifying the homicide of Tylee Ryan. Those religious beliefs were put in through evidence, through witnesses such as Zulema Pastenes, Melanie Gibbs, David Warwick, Andre Baratario. There's an allegation that there was a change in the deposit of Tylee Ryan's Social Security benefits as an overt act. Mark Sari, Social Security investigator, testified about that. Agent Hart testified about that as well. And I believe Colby Ryan also offered some testimony on that point. The allegation of moving from Chandler, Arizona to Rexburg with Alex Cox, Tylee Ryan, and JJ Vallow was evidence through testimony that came in. There was a lease agreement again, evidencing change of residence. There was an overt act allegation of Chad Daybell Googling south-southwest wind and visiting a website. To define that, the Google search history of Chad Daybell was admitted as an exhibit in evidence and supports that allegation. There's an allegation and an overt act about September 9th, 2019, Alex Cox going to Pioneer Road in Rexburg, and law enforcement officers presented evidence of that fact, including Nick Valance. Then an overt act alleged about the defendant failing or refusing to contact Social Security Administration as required by law to inform them about Tylee Ryan's death. That was testified to again by Mark Sari, a Social Security investigator, and also continuing allegation of the defendant continuing to receive monthly Social Security payments on behalf of Tylee Ryan. Evidence there again from the Social Security investigator Mark Sari, and also Detective Chuck Considas testified to some of those bank records as well. So as to the allegations and overt acts in count one, the conspiracy, the court finds there is sufficient evidence in considering all reasonable inferences in favor of the prosecution to deny the Rule 29 motion on that count. On count two, the count of first-degree murder with malice aforethought, evidence came in supporting the allegation of the date range of on or about September 8th, 2019 to September 9th, 2019. As it relates to the death of Tylee Ryan, photographs were admitted through more than one of the witnesses about the last known proof of life date. Nicholas Edwards provided testimony on that issue. There were text messages brought in purporting to show communications between the defendant and Chad Daybell about light and dark ratings, death percentage ratings, and other information that would support the malice of forethought element included in that. And going back to the analysis and evidence that I went through on count one of the conspiracy, the court finds on balance that there is sufficient evidence to deny the criminal rule 29 motion as it relates to count two of the amended indictment. On count three, the conspiracy to commit first degree murder and grand theft by deception, the court also considered the evidence. Much of it overlaps with the evidence I've already indicated relating to count one. In addition, there was a date range of on or about September 23rd, 2019, about Alex Cox taking possession of J.J. Vallow. That was established through some testimony of Melanie Gibb and David Warwick, who were there at the residence in Rexburg, also establishing the defendant's presence there. And then information on the overt acts about providing false information about the location of J.J. Vallow during a law enforcement investigation. There was body cam footage of Officer Dave Stubbs talking about a welfare check in Idaho, and other law enforcement officers presented evidence to support that overt act allegation. And finally, the allegation in an overt act that on or between September 9th, 2019 and February 1st, 2020, the defendant continued to wrongfully collect Social Security payments. Going back again to Social Security investigator Mark Sari, evidence was provided as well as bank records that came in to support that particular allegation. So on count three, the court will deny the motion under Criminal Rule 29. Count four is the first degree murder with malice aforethought. And again, incorporating the evidence I've already reviewed and considered in light of counts 1 through 3, find that many of those dates and elements were established. There was evidence brought in on the date ranges, the malice aforethought, again, going back to the text messages and communications that came in evidence, could support the state's theory that there was malice aforethought with the planning of, or allegations of planning of, the murder as alleged as to J.J. Jackson. Incorporating all of those prior findings, the court finds there's sufficient evidence under count four for the matter to go forward to the jury. Count five is the conspiracy to commit first degree murder as it relates to Tammy Daybell. This alleges that on or about October 1st, 2018 through January 15, 2020 are the dates in the conspiracy for that charge. And much of the conspiracy evidence again overlaps with counts 1 and 3. Looking at that evidence as well as on the dates in here specifically as it relates to the death of Tamara Daybell, the court would note that Detective Bruce Mattingly established the dates through testimony. There were 911 calls that were admitted, establishing dates made by Chad Daybell and Garth Daybell. There were records of those from the dispatchers. The dates of her death were established through testimony of the Fremont County Coroner Brenda Dye and Deputy Coroner Cammie Wilmore. There were, again, text messages entered into evidence between the defendant and Chad Daybell about Tamara Daybell being dark, and a text that Chad Daybell said, "I feel she will be gone soon." Doug Hart, also an FBI agent, testified about those text messages and locations of Alex Cox in and around the Daybell residence at the time of a purported attempted shooting. There was evidence by Detective Chuck Considis about the burner phone overt act allegations that are contained in that count. In regards to allegations in the overt acts about an application to increase life insurance to the maximum amount allowed, there was testimony from Taylor Ballard from an insurance company and a school employee, Angela Yancey, talking about insurance. Also admitted into the evidence in the case were internet searches relating to the rifle recovered in a storage unit, the Grendel rifle, which is also an exhibit in the case, and those Google searches came in as evidence as well to support those overt acts relating to that count of the case. And with all the cell phone data and messages admitted, there is sufficient evidence the court finds to establish the overt acts that were alleged in count 5 of the amended indictment. So the Rule 29 motion's denied on that count. Finally, on grand theft count 7, the court looked at the elements of that offense as alleged. Mark Sari from the Social Security Administration established dates of these payments and benefits, and also importantly established through testimony that there was a legal requirement for certain things to be notified, required notifications if there was a death of a beneficiary or a change of residence or a remarriage, and all of those events, it was testified, occurred and were not reported to the Social Security Administration. And there were evidence submitted through law enforcement officers and records also of continued and receipt of payments through the Social Security benefits that were assigned to deceased persons, which is sufficient to establish the theory of theft by deception as alleged by the state relating to that grand theft count, which in this case is count 7 of the amended indictment. So again, when construing all the reasonable inferences in favor of the state, the court does find, and without any specific argument on any particular element or any charge, that the state's presented enough evidence for this matter to move forward and be considered by the jury. So the court is going to deny the Rule 29 motion and allow for the matter to go forward to the jury on all counts. That'll be the court's ruling on the Rule 29 motion. Does the defense have any questions on that ruling?
No, Your Honor.
All right, thank you, Mr. Archibald. Any questions from the state?
No, Your Honor. Thank you.
Okay, with that in mind then, the next matter we will bring up is we'll have the jurors brought in to read them final instructions. While we're waiting for the jurors to be brought in, I'll just note on the record that yesterday we did go through jury instructions with counsel. The court did finalize those jury instructions. I provided a courtesy copy to the attorneys as well as each juror will receive a courtesy copy of the jury instructions as permitted through Criminal Rule 24.1b. And so the court will go through the reading of those final instructions once the jurors come in, and then we'll start with the closing arguments after that.
All right. Here's our President Counsel, Your Honor.
All right, thank you, Mr. Bailiff. Please be seated. All right, thank you, Mr. Bailiff. The court will note the jurors are all present and accounted for, properly seated. I believe they've all signed their juror affirmation as well. Is that correct?
Yes, Your Honor.
Okay, thank you, Mr. Bailiff. Ladies and gentlemen of the jury, you've now been provided copies of the jury instructions in this case. The court's going to read through those instructions. The court will note that there are a total of 39 instructions. Instructions 1 through 10 have already been read to you. Those were read at the beginning of the trial. There are a few of those that I would like to read again as we start, and then we'll read through instructions 11 onward. So a few of the preliminary instructions that I would like to go back over with you. We'll start with jury instruction number 4. So jury instruction number 4, under our law and system of justice, the defendant is presumed to be innocent. The presumption of innocence means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Next, read instruction number 5. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant may not testify, nor should this fact be discussed by you or enter into your deliberations in any way. All right, I'll next move up now to jury instruction number 11. You have now heard all the evidence in the case. My duty is to instruct you as to the law. You must follow all the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree or don't understand the reasons for some of the rules, you are bound to follow them. If anyone states a rule of law different from any I tell you, it is my instruction that you must follow. Instruction number 12. As members of the jury, it is your duty to decide what the facts are and to apply those facts to the law that I have given you. You are to decide the facts from all the evidence presented in the case. The evidence you are to consider consists of 1. Sworn testimony of witnesses, 2. Exhibits which have been admitted into evidence, and 3. Any facts to which the parties have stipulated. Certain things you have heard or seen are not evidence, including 1. Arguments and statements by lawyers. The lawyers are not witnesses. What they say in their opening statements, closing arguments, and at other times is included to help you interpret the evidence, but is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, follow your memory. 2. Testimony that has been excluded or stricken or which you have been instructed to disregard. 3. Anything you may have seen or heard when the court was not in session. Instruction number 13. Each count charges a separate and distinct offense. You must decide each count separately on the evidence and the law that applies to it, uninfluenced by your decision as to any other count. The defendant may be found guilty or not guilty on any or all of the offenses charged. Jury instruction number 14. Evidence has been introduced for the purpose of showing that the defendant committed acts other than that for which the defendant is on trial. At the time this evidence was introduced, you were advised of its limited purpose. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Such evidence may be considered by you only for the limited purpose of proving the defendant's motive, intent, preparation, plan, knowledge, or absence of mistake or accident. Instruction number 15. Certain evidence was admitted for a limited purpose. At the time this evidence was admitted, you were admonished that it could not be considered by you for any purpose other than the limited purpose for which it was admitted. This includes those exhibits admitted for demonstrative or illustrative purposes only. Do not consider such evidence for any purpose except the limited purpose for which it was admitted. The following exhibits were admitted only as demonstrative or illustrative exhibits: 6, 10A, 30, 31A, 31B, 69, 76, 84, 85, 86, 111, 112, 113, 114, 115, 116, 117, 107B, 179A, 179B, 184C, 184D, 184E, 185A, 182A, 182B. These exhibits are available for your review during your deliberations upon your request. Please advise the bailiff by written note of any such request. Jury instruction number 16. The law makes no distinction between a person who directly participates in the acts constituting a crime and a person who, either before or during its commission, intentionally aids, assists, facilitates, promotes, encourages, counsels, solicits, invites, helps, or hires another to commit a crime with intent to promote or assist in its commission. Both can be found guilty of the crime. Mere presence at, acquiescence in, or silent consent to the planning or commission of a crime is not sufficient to make one an accomplice. Instruction number 17. An act is willful or done willfully when done on purpose. One can act willfully without intending to violate the law, to injure another, or to acquire any advantage. Jury instruction number 18. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Jury instruction 19. The crime of conspiracy, as alleged in counts 1 and 3 of the amended indictment, involves an agreement by 2 or more persons to commit the crimes of first-degree murder and grand theft by deception. The crime of conspiracy, as alleged in count 5 of the amended indictment, involves an agreement by 2 or more persons to commit the crime of first-degree murder. They need not agree upon every detail. The agreement may be established in any manner sufficient to show an understanding of the parties to the agreement. It may be shown by evidence of an oral or written agreement, or may be implied from the conduct of the parties. Jury instruction number 20. All of the parties to a conspiracy need not enter the agreement at the same time. A person who later joins an already formed conspiracy with knowledge of its unlawful purpose is a party to the conspiracy. Instruction number 21. Murder is the killing of a human being with malice aforethought. Instruction number 22. Malice may be express or implied. Malice is express when there is manifested a deliberate intention unlawfully to kill a human being. Malice is implied when 1. The killing resulted from an intentional act. 2. The natural consequences of the act are dangerous to human life. And 3. The act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of time. It only means that the malice must precede rather than follow the act. Jury instruction number 23. To obtain property means to bring about a transfer of an interest in or the possession of the property. Jury instruction number 24. An owner of property is any person who has the right to possession of such property superior to that of the defendant. Jury instruction number 25. Person means an individual, corporation, association, public or private corporation, city or other municipality, county, state agency, the state of Idaho, federal agency, or United States of America. Jury instruction number 26. Property means anything of value, including labor or services. Jury instruction number 27. A person steals property and commits theft when, with intent to deprive another of property or appropriate the same to the person or to a third party, such person wrongfully takes, obtains, or withholds such property from an owner thereof. Jury instruction number 28. In order for the defendant to be guilty of conspiracy to commit first-degree murder and grand theft by deception as alleged in count 1 of the amended indictment, the state must prove each of the following. 1. On or about October 26, 2018 to January 15, 2020. 2. In the state of Idaho. 3. The defendant, Lori Noreen Vallow, with Chad Daybell and or Alex Cox agreed. 4. To commit the crimes of murder in the first degree of Tylee Ryan and grand theft by deception. 5. The defendant intended that the crimes would be committed. 6. One of the parties to the agreement performed at least one of the following acts. A. On or between October 26, 2018 and June 9, 2020, Chad Guy Daybell and Lori Noreen Vallow did endorse and espouse religious beliefs for the purpose of encouraging and or justifying the homicide of Tylee Ryan. B. On or about August 16, 2019, Lori Noreen Vallow Daybell did change the deposit of Tylee Ryan's Social Security benefits from Tylee Ryan's JP Morgan Chase account to deposit money directly into Lori Noreen Vallow's personal BBVA account. C. On or about September 1, 2019, Lori Noreen Vallow Daybell did move from Chandler, Arizona to Rexburg, Idaho with Alex Cox, Tylee Ryan, and Joshua Jackson, JJ Vallow. D. On or about September 8, 2019, Chad Guy Daybell Googled SSW wind and visited a website entitled, "What is the definition of SSW wind direction?" E. On or about September 9, 2019, Alex Cox did go to 565 Pioneer Road, apartment 175, Rexburg, Idaho. F. On or between September 9, 2019 and February 1, 2020, Lori Noreen Vallow Daybell failed or refused to contact the Social Security Administration as required by law to inform the Social Security Administration of Tylee Ryan's death. G. On or between September 25, 2019 and January 22, 2020, Lori Noreen Vallow Daybell did wrongfully continue to collect 5 monthly Social Security survivor benefits on behalf of Tylee Ryan. 7. And such act was done for the purpose of carrying out the agreement. If any of the above has not been proven beyond a reasonable doubt, then you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, you must find the defendant guilty. Jury instruction number 29. In order for the defendant to be guilty of first-degree murder, as alleged in count 2 of the amended indictment, the state must prove each of the following. 1. On or about September 8, 2019 to September 9, 2019. 2. In the state of Idaho. 3. The defendant, Lori Noreen Vallow Daybell, engaged in conduct or did aid, abet, advise, or counsel another to engage in conduct which caused the death of Tylee Ryan. 4. With malice aforethought. And 5. The murder was a willful, deliberate, and premeditated killing. Premeditation means to consider beforehand whether to kill or not to kill, and then to decide to kill. There does not have to be any appreciable period of time during which the decision to kill was considered, as long as it was reflected upon before the decision was made. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not premeditation. Aiding and abetting is defined as follows. All persons who participate in a crime either before or during its commission by intentionally aiding, abetting, advising, or counseling another to commit the crime with intent to promote or assist in its commission are guilty of the crime. All such participants are considered principals in the commission of the crime. The participation of each defendant in the crime must be proved beyond a reasonable doubt. If you find the state has failed to prove beyond a reasonable doubt any of the elements of 1 through 4 above, or failed to prove any of the circumstances listed in element 5, you must find the defendant not guilty of first-degree murder. If you find that elements 1 through 4 above have been proven beyond a reasonable doubt, and you unanimously agree that the state has proven any of the above circumstances under element 5 beyond a reasonable doubt, you must find the defendant guilty of first-degree murder. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first-degree murder. If you find that all of the above have been proven beyond a reasonable doubt, then you must find the defendant guilty of first-degree murder. Jury instruction number 30. In order for the defendant to be guilty of conspiracy to commit first-degree murder and grand theft by deception, as alleged in count 3 of the amended indictment, the state must prove each of the following. 1. On or about October 26, 2018 to January 15, 2020. 2. In the state of Idaho. 3. The defendant, Lori Noreen Vallow, Chad Daybell, and or Alex Cox agreed. 4. To commit the crimes of murder in the first degree of Joshua Jackson Vallow and grand theft by deception. 5, the defendant intended that the crimes would be committed. 6, one of the parties to the agreement performed at least one of the following acts. A, on or about October 26, 2018 and June 9, 2020, Chad Guy Daybell and Lori Noreen Vallow did endorse and espouse religious beliefs for the purpose of encouraging and or justifying the homicide of J.J. Vallow. B, on or about September 1, 2019, Lori Noreen Vallow Daybell did move from Chandler, Arizona to Rexburg, Idaho with Alex Cox, Tylee Ryan, and Joshua Jackson, J.J. Vallow. C, on or about September 23, 2019, Alex Cox did take possession of J.J. Vallow. D, on or about November 26, 2019, Lori Noreen Vallow Daybell provided a false and or misleading physical location of J.J. Vallow to law enforcement during a lawful investigation. E, on or between September 23, 2019 and February 1, 2020, Lori Noreen Vallow Daybell failed or refused to contact the Social Security Administration as required by law to inform the Social Security Administration of J.J. Vallow's death. F, on or between September 9, 2019 and February 1, 2020, Lori Noreen Vallow Daybell did wrongfully continue to collect 4 monthly Social Security survivor benefits on behalf of J.J. Vallow and 4 monthly Social Security child and care payments. 7, and such act was done for the purpose of carrying out the agreement. If any of the above has not been proven guilty or has not been proven beyond a reasonable doubt, then you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, you must find the defendant guilty. Jury instruction number 31. In order for the defendant to be guilty of first-degree murder, as alleged in count 4 of the amended indictment, the state must prove each of the following. 1, on or about September 22, 2019 to September 23, 2019. 2, in the state of Idaho. 3, the defendant, Lori Noreen Vallow Daybell, engaged in conduct or did aid, abet, advise, or counsel another to engage in conduct which caused the death of Joshua Jackson J.J. Vallow. 4, with malice aforethought. And 5, the murder was a willful, deliberate, and premeditated killing. Premeditation means to consider beforehand whether to kill or not to kill, and then to decide to kill. There does not have to be any appreciable period of time during which the decision to kill was considered, as long as it was reflected upon before the decision was made. A mere unconsidered and rash impulse, even though it includes an intent to kill, is not premeditation. Aiding and abetting is defined as follows. All persons who participate in a crime either before or during its commission by intentionally aiding, abetting, advising, or counseling another to commit the crime with intent to promote or assist in its commission are guilty of the crime. All such participants are considered principals in the commission of the crime. The participation of each defendant in the crime must be proved beyond a reasonable doubt. If you find the state has failed to prove beyond a reasonable doubt any of the elements 1 through 4 above, or failed to prove any of the circumstances listed in element 5, you must find the defendant not guilty of first-degree murder. If you find that elements 1 through 4 above have been proven beyond a reasonable doubt, and you unanimously agree that the state has proven any of the above circumstances under element 5 beyond a reasonable doubt, you must find the defendant guilty of first-degree murder. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first-degree murder. If you find that all of the above have been proven beyond a reasonable doubt, then you must find the defendant guilty of first-degree murder. Jury instruction number 32. In order for the defendant to be guilty of conspiracy to commit first-degree murder, as alleged in count 5 of the amended indictment, the state must prove each of the following. 1, on or about October 26, 2018 to January 15, 2020. 2, in the state of Idaho. 3, the defendant, Lori Noreen Vallow, Chad Daybell, and or Alex Cox agreed. 4, to commit the crime of murder in the first degree of Tammy Daybell. 5, the defendant intended that the crime would be committed. 6, one of the parties to the agreement performed at least one of the following acts. A, on or about or between the dates of October 26, 2018 and June 9, 2020, Chad Guy Daybell and Lori Noreen Vallow Daybell did encourage and espouse religious beliefs for the purpose of justifying and or encouraging the homicide of Tammy Daybell. B, on or about September 1, 2019, Lori Noreen Vallow Daybell did move to Rexburg, Idaho with Alex Cox, Tylee Ryan, and Joshua Jackson, hereinafter JJ Vallow. C, on or about July 30, 2019, Chad and Lori sent text messages to each other regarding death percentages for Tammy and JJ. D, Chad Daybell obtained a burner phone on September 18, 2019. E, Alex Cox obtained a burner phone on October 9, 2019. F, Chad Guy Daybell and Lori Noreen Vallow Daybell sent text messages to each other about Tammy Daybell being in limbo and Tammy being possessed by a spirit named Viola. G, September 8, 2019, Chad Guy Daybell signed an application along with Tammy Daybell to increase her life map insurance to the maximum allowed under her policy. H, Alex Cox attempted to shoot Tammy Daybell on October 9, 2019. I, Alex Cox conducted multiple internet searches between the dates of October 8, 2019 and October 12, 2019, included searches related to Grendel drop and shooting through a Dodge Dakota. J, Alex Cox went to a gun range in the month before October 9, 2019, when the attempted shooting of Tammy Daybell takes place. K, Alex traveled from Sportsman's Warehouse to the vicinity of the Daybell residence on October 9, 2019. L, Alex was in the church parking lot approximately 2.5 miles from the Daybell residence on the night of October 18, 2019. 7, and such act was done for the purpose of carrying out the agreement. If any of the above has not been proven beyond a reasonable doubt, then you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, you must find the defendant guilty. Jury instruction number 33. There are different forms of theft depending on the manner in which the theft was committed. The defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, is charged in count 7 with the theft of Social Security benefits, Social Security funds. The state alleges that such theft was committed either by taking, withholding, or detaining said property, or by deception. If you are satisfied beyond a reasonable doubt and unanimously agree that the defendant committed the crime of theft, you should find the defendant guilty. You are not required to agree as to which particular form of theft the defendant committed. Jury instruction number 34. In order for the defendant to be guilty of grand theft as alleged in count 7 of the amended indictment, the state must prove each of the following. 1, on or about the dates of October 1, 2019 to January 22, 2020. 2, in the state of Idaho. 3, the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, obtained or exerted control over Social Security survivor benefits allocated for Tylee Ryan and JJ Vallow, and Social Security child and care benefits allocated for Lori Noreen Vallow in an amount exceeding $1,000 US dollars, to which funds Lori Noreen Vallow, aka Lori Noreen Daybell, was not entitled. 4, another person was the owner of such property. 5, the defendant did so by knowingly doing one or more of the following. A, creating or confirming another's impression, which is false and which the defendant did not believe to be true. B, failing to correct a false impression which the defendant previously had created or confirmed. Or C, preventing another person from acquiring information relevant to the disposition of the property. Or 6, the defendant had the intent to deprive the owner of the property or to appropriate the property to the defendant or to some person other than the owner. If any of the above has not been proven beyond a reasonable doubt, you must find the defendant not guilty of grand theft. If each of the above has been proven beyond a reasonable doubt, then you must find the defendant guilty of grand theft. Jury instruction number 35. In this case, you will return a verdict consisting of a series of questions. Although the explanations on the verdict form are self-explanatory, they are part of my instructions to you. I will now read the verdict form to you. It states, we, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Then there's a space for not guilty or guilty. Question number 2, in regards to count 2 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of first-degree murder of Tylee Ryan, not guilty or guilty? Question number 3, in regards to count 3 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception? Not guilty, guilty. Question number 4, in regards to count 4 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of first-degree murder of Joshua Jackson Vallow? Not guilty, guilty. Question number 5, in regards to count 5 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tammy Daybell? Not guilty, guilty. Question number 6, in regards to count 7 of the indictment, is Lori Noreen Vallow not guilty or guilty of grand theft? Not guilty, guilty. And then there is a date line and a line for the presiding officer. And I'll note that is just a form in your instructions. There will be one actual verdict form. So this is just for instruction purposes. Jury instruction number 36. You have been instructed as to all the rules of law that may be necessary for you to reach a verdict. Whether some of the instructions will apply will depend upon your determination of the facts. You will disregard any instruction which applies to a state of facts which you determine does not exist. You must not conclude from the fact that an instruction has been given that the court is expressing any opinion as to the facts. Instruction 37. The original instructions and the exhibits will be with you in the jury room, with the exception of exhibits 280, Alexander Arms Grendel 6.5 firearm, 278 and 279 firearm baffles, and illustrative or demonstrative exhibits. For safety and security reasons, the firearm exhibits may be viewed with the assistance of the bailiff if requested by the jury. The demonstrative or illustrative exhibits may be available as explained in jury instruction number 15. They are part of the official court record. For this reason, please do not alter them or write or mark on them in any way. Some of the exhibits have been sealed in bags or containers that allow you to view them. Do not open or remove the contents of those exhibits. If you have any questions about the handling or use of the exhibits, submit those questions in writing to me through the bailiff. The instructions are numbered for convenience in referring to specific instructions. There may, there may or may not be a gap in the numbering of the instructions. If there is, you should not concern yourselves about such a gap. Instruction 38. Upon retiring to the jury room, select one of you as a presiding officer who will preside over your deliberations. It is that person's duty to see that the discussion is orderly, that the issues submitted for your decision are fully and fairly discussed, and that every juror has a chance to express himself or herself upon each question. In this case, your verdict must be unanimous. When you all arrive at a verdict, the presiding officer will sign it and you will return it into open court. Your verdict in this case cannot be arrived at by chance, by lot, or by compromise. If after considering all the instructions in their entirety and after having fully discussed the evidence before you, the jury determines that it is necessary to communicate with me, you may send a note by the bailiff. You are not to reveal to me or anyone else how the jury stands until you have reached a verdict or unless you are instructed by me to do so. A verdict form suitable to any conclusion you may reach will be submitted to you with these instructions. Pardon me. Instruction 39, I have outlined for you the rules of law applicable to this case and have told you of some of the matters which you may consider in weighing the evidence to determine the facts. In a few minutes, counsel will present their closing remarks to you, and then you will retire to the jury room for your deliberations. The arguments and statements of the attorneys are not evidence. If you remember the facts differently from the way the attorneys have stated them, you should base your decision on what you remember. The attitude and conduct of jurors at the beginning of your deliberations are important. It is rarely productive at the outset for you to make an emphatic expression of your opinion on the case or to state how you intend to vote. When you do that at the beginning, your sense of pride may be aroused and you may hesitate to change your position even if shown it is wrong. Remember that you are not partisans or advocates, but you are judges. For you, as for me, there can be no triumph except in the ascertainment and declaration of the truth. As jurors, you have a duty to consult with one another and to deliberate before making your individual decisions. You may fully and fairly discuss among yourselves all the evidence you have seen and heard in this courtroom about the case, together with the law that relates to this case is contained in these instructions. During your deliberations, you each have a right to re-examine your own views and change your opinion. You should only do so if you are convinced by fair and honest discussion that your original opinion was incorrect based upon the evidence the jury saw and heard during the trial and the law as given you in these instructions. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. However, none of you should surrender your honest opinion as to the weight or effect of the evidence, or as to the innocence or guilt of the defendant because the majority of the jury feels otherwise, or for the purpose of returning a unanimous verdict. All right, having concluded then the reading of the instructions, this will be the time for closing arguments. Is the state ready to proceed with its closing?
Yes, Your Honor.
And who will be presenting closing?
I will.
All right, Mr. Wood, then you can commence with your closing.
Your Honor, may we just have a very brief sidebar before we start?
Yes. All right, council, we had a sidebar to discuss scheduling quickly. We are going to go ahead and take a brief recess before we start with the closing arguments. So we'll let the jurors have a break as well.
All right, please.
Okay, folks, we'll be back in about. Thank you. Please be seated. All right, let's have the jurors brought in, please.
Jurors all present, count for Your Honor.
Thank you. Please be seated. All right, at this time, we'll have closing arguments. Mr. Wood for the state.
Money, power, and sex. Beginning in October of 2018, Lori Vallow and Chad Daybell set in motion a series of events that led to 3 horrific murders in the state of Idaho. Along their way, they quickly recruited and groomed her brother Alex Cox to participate in their multiple conspiracies. Each of these conspiracies is part of a larger plan for Chad and Lori to be together, unencumbered and free of obstacles. This plan was driven by Lori Vallow's desire for and use of money, power, and sex. And this plan that she set in motion must end today in the verdicts you render in this trial. Idaho murder number 1, Tylee Ryan. Tylee was Lori Vallow's 16-year-old vibrant daughter. She had a whole life ahead of her. Tylee was murdered between September 8th and September 9th, 2019. Lori Vallow was responsible for Tylee's health and safety, but instead of protecting her, Lori Vallow, Chad Daybell, and Alex Cox conspired to murder her. Acting together, they caused her death. Tylee's body was burned beyond recognition. Her body was dismembered in such a grotesque and extreme manner that the medical examiner had to determine the cause of death as homicide by unspecified or unknown means. She was burned and buried in Chad Daybell's backyard on September 9th, 2019. What was left of her body, they dumped in a green bucket and buried in a pet cemetery on top of a piece of her skull. Tylee was gone and buried and out of the way, but Lori Vallow kept collecting Tylee's money. Tylee Ryan had been receiving Social Security benefits from the death of her father, and Lori personally took steps to make sure that she kept receiving that money after Tylee was murdered. Lori never reported that Tylee was missing or dead. Not only did she not report it, she lied to multiple people about Tylee's location and whereabouts, including to the police. She had to keep her body hidden so she could keep getting the money. Idaho murder number 2. Between September 22nd and 23rd, 2019, J.J. Vallow's voice was silenced forever by a strip of duct tape placed across his mouth. A white plastic bag was placed over his head, where it was secured tightly with duct tape, being wrapped around and around from his forehead to his neck. The evidence shows he struggled, and we'll never know how long he fought before they bound his wrists, his forearms, and his ankles with duct tape. That white bag that was placed over his head, that was duct taped over his head, cut off his airways. So he stopped breathing. His heart stopped beating, and he died. It was a brutal, horrific murder of a 7-year-old boy with special needs. A 7-year-old boy with special needs. JJ's body was placed in a black plastic and buried like a piece of trash in Chad Daybell's backyard. In a shallow, but well-prepared and precise grave. Just like Tylee, JJ was the recipient of Social Security benefits from the death of his father, Charles Vallow. Just like Tylee, Lori never reported that JJ was missing or dead. Why? He had to remain hidden so she could keep receiving the money. Not only did she not report, she lied to multiple people about his location. She even asked a friend, Melanie Gibb, to lie to the police about JJ's location, and further asked her to falsify evidence of his location. Just like Tylee, after JJ was murdered, she kept collecting the money. Idaho murder number 3. Between the night of October 19th and the morning of October 20th, or between the night of October 18th and October 20th, 2019, Tammy Daybell, a loving, active, healthy 49-year-old mother of 5, and a school librarian, was murdered in her own home. She was asphyxiated in her own home. The evidence is clear that Lori Vallow, Chad Daybell, and Alex Cox conspired to murder Tammy. Acting together, they caused her death. Her death occurred just a little over a week after a masked gunman had attempted to shoot her. She entered her home after a night of church activities. When their first plan didn't work, they formed a second plan, and she was asphyxiated. Lori was conveniently gone for both the attempted murder and the successful murder. She was conveniently out of the state. Those trips were not coincidences. And just like Tylee and JJ, There was money to be gained from Tammy's death. $430,000 worth of life insurance. And Lori wasted no time in making sure she could benefit from that money. A mere 2.5 weeks after Tammy Daybell died on November 5th, 2019, Lori Vallow married Chad Daybell on a beach in Hawaii. So less than 2 months after Tylee and JJ are murdered, and within weeks of Tammy's murder, Lori and Chad are on a beach, in the words of her sister, dancing on a beach in Hawaii, free from the obstacles that were Tylee, JJ, and Tammy, but living with the money that was gained from each of their deaths. Ladies and gentlemen, I want to quickly talk to you about the timeline of this case. The timeline tells the truth, and Lori Vallow is convicted by the timeline she created. She meets Chad in October of 2018. You have seen plenty of evidence of the affair that took place after they met. July 11th, 2019, Lori's brother, Alex, shoots and kills Charles Vallow, Lori's husband. September 8th and 9th, Tylee Ryan, Lori Vallow's daughter, is killed. September 22nd to 23rd, JJ Vallow, her son, is killed. October 19th, 2019, Tammy Daybell is killed. These are not coincidences. And there is one common thread through these murders. Lori Vallow. She is the one person who ties these all together. You heard about the investigation and how it got started, looking for a Jeep that was used in an attempted shooting at Brandon Boudreaux on October 2nd. You heard about Chad and the life insurance. They're married November 5th. You heard about how the Rexburg police got a call looking for JJ towards the end of November. And that kicks off the investigation looking for JJ and Tylee, how they searched the apartments, and how finally, through their investigation, the bodies of Tylee Ryan and JJ Vallow were found on June 9th. Tammy's body was exhumed on December 11th. Alex Cox died December 12th. Ladies and gentlemen, I want to speak with you about the law a little bit. The judge already read it to you. And I'm not going to go through and read it to you again, but there's some things that are important to point out. And so in the jury instructions, you have them, you don't need to turn to them, but as you go back and deliberate, there's things we want you to think about. In jury instruction number 28, which is the elements you need to find to establish that Lori Vallow is guilty of conspiracy to commit murder and grand theft against Tylee Ryan. Some of those things are easy. The dates, the state of Idaho, those are incontrovertible. Conspiracy comes down to, this is a crime of agreement. Did Lori agree to have Tylee killed and to steal that money? Did she intend for those events to actually happen? And did someone, any of the conspirators, perform an overt act in furtherance of that agreement? Now, as you read the jury instructions and you read over the overt acts, it'll be number 6 in your instruction. It is that one of the parties to the agreement performed at least one of the following acts. So when it comes to conspiracy, what you need to ask yourself, who murdered these people? Did Lori conspire for these murders and for these thefts? Did she intend for it to happen? And was one of these overt acts accomplished in furtherance of the conspiracy? As it says, you only need to find one overt act. The state has met its burden for each of the overt acts. You only need to find one. Turning to jury instruction number 29, which is the actual murder of Tylee Ryan. Because we want to differentiate. There's the crime of conspiracy to murder, which is crime of agreement, and the actual murder. And what you need to ask yourselves, again, on or about certain dates in the state of Idaho, that's incontrovertible. What you need to ask yourself, who killed Tylee Ryan? And did Lori aid, abet, advise, or counsel that murder? Did she encourage that murder? You remember in voir dire, when you were all asked, and you all raised your hand, about the question, someone is proven to have aided or abetted, could you still find them guilty? Under the law, if you find that Lori aided, abetted, advised, or counseled, you must find her guilty. Jury instruction 29 is the conspiracy for JJ. You need to go over those same questions. Who killed him? Did Lori conspire to that? Did she agree to JJ being killed? Did she intend for it to happen? And did one of those overt acts happen in furtherance of that agreement? 31 is the murder of JJ. Again, remember to separate the crimes of conspiracy from the crime of murder. Instruction 32 is the conspiracy on Tammy. Again, who killed her? Did Lori agree to it? Was there an overt act taken in furtherance of that? And the final, instruction 34, the grand theft. Find her guilty, you need to find that she deprived the United States of money that belonged to them and not her. You can find it by two ways, that she deceived them or that she just intended to keep the money. That's a summary of the jury instructions, ladies and gentlemen. When you go back to deliberate, read them carefully. And as you do, you will find that the state has met its burden of proving these elements, each and every one of them, beyond a reasonable doubt. A few things to consider. This is just a portion of the definition of reasonable doubt taken directly out of your jury instruction. Follow the jury instruction, read the whole jury instruction. But I want to point out, a reasonable doubt is not a mere possible or imaginary doubt. It's not something you make up. It's a doubt based on reason and common sense. Reason and common sense. So ladies and gentlemen, as you go back and deliberate, and you consider these elements, and you consider these crimes that were committed, use your reason and your common sense. Malice. It's one of those words that may mean something out in the normal world, and in court may mean something a little bit different. Follow the jury instruction. Malice can be express, where someone says they want this to happen. It can be implied. You will find express and implied malice in this case. There is an abundance of malice. Aiding and abetting, again, already went over this, but any person who aids and abets, who assists, facilitates, promotes, or encourages a crime to happen is just as guilty as anyone else involved in the crime. Aiding and abetting is just the same as pulling the trigger. Overt acts. As I mentioned, you need to find on a conspiracy that at least one overt act was committed. You need to find at least one overt act beyond a reasonable doubt. In your jury instructions, there's a list, and we're going to go over them in a second. You need to find that one of those acts was done for the purpose of carrying out the agreement. Overt acts do not need to be, in and of themselves, illegal. Remember that. They don't need to be illegal. But if it's an act done in furtherance of the conspiracy, then it is an overt act and makes it a part of the crime. Let's quickly go through the overt acts. We're not going to discuss them a lot. That's for you to do when you get back in deliberations. But in regards to Tylee, JJ, and Tammy, Lori is charged with endorsing and espousing religious beliefs for the purpose of encouraging and or justifying murder. To be clear, no one here has been charged because of their religious beliefs. They are charged for using those beliefs for the purpose of justifying murder. In terms of Tylee, Lori Vallow, on or around August 16th, 2019, changed the deposit for the Social Security benefits to go from Tylee's JP Morgan account to Lori's personal BBVA account. You saw that evidence. In regards to the conspiracies on Tylee, JJ, and Tammy, Lori Vallow, along with Alex Cox, Tylee Ryan, and Joshua Jackson Vallow, JJ Vallow, moved from Arizona to Rexburg. Why is that important? Why is that an overt act? They couldn't kill the kids in Arizona, where they had friends and family. Moving to Rexburg was the catalyst for these murders. They had to hide Tylee and JJ. They had to go somewhere where nobody knew them. So moving to Rexburg furthered the conspiracy to kill Tylee and JJ, and it brought Alex Cox to where he could kill and help kill Tammy Daybell. In regards to Tylee's conspiracy, Chad Daybell Googled south-southwest wind and visited the website. What's the definition of south-southwest wind? In regards to Tylee, you heard evidence that in the early morning hours of September 9th, Alex Cox went to 565 Pioneer Road, apartment 175. That was Lori's apartment. Also in regards to Tylee, that Lori failed or refused to contact Social Security to let them know of Tylee's death, and that she continued to wrongfully collect those Social Security benefits. In regards to JJ, on September 23rd, Alex Cox took JJ. He took custody of him. Also in regards to JJ, November 26, 2019, Lori Vallow provided a false and or misleading physical location of JJ to the police. You saw that on video. Also, in regards to JJ, September 23rd, 20th through the 19th, that she failed or refused to contact Social Security to inform them of JJ's death. Why? To further the conspiracy of grand theft, to keep the money. And that she continued to collect that money, furthering the conspiracy. In regards to the conspiracy to murder Tammy, again, Chad Daybell and Lori Vallow espoused or endorsed religious beliefs for the purpose of justifying Tammy's homicide. September 1, 2019, again, they moved to Rexburg. I've already spoken about that. There were text messages in regards to the conspiracy for Tammy between Chad and Lori regarding death percentages for Tammy and JJ, July 30th, 2019. Chad Daybell obtained a burner phone on September 18th, 2019. Alex Cox obtained a burner phone October 9th, 2019. All these steps taken to further their conspiracy. Further on Tammy, text messages between Chad and Lori about Tammy being in limbo and Tammy being possessed by a spirit. In regards to Tammy, Chad co-signed a life insurance policy increasing the amount of insurance he would get upon her death. On October 9th, Alex Cox attempted to shoot Tammy. Between October 8th and October 12th, Alex Cox conducted multiple internet searches related to Grendel Drop, related to a Dodge Dakota, all in furtherance of the conspiracy to kill Tammy. He goes to gun ranges in furtherance of the conspiracy. He went to Sportsman's Warehouse. You saw what he bought there. And then on the night that Tammy died, Alex Cox goes to a church parking lot just about 2.5 miles south of Chad Daybell's house. These are all overt acts. Things done to further the conspiracy, steps taken to get to murder. Let's talk about some of the digital evidence you've seen in this case. You've heard evidence from Homer J. Maximus at gmail.com, chad.daybell at gmail.com, lollytimeforever at gmail.com, other phone data, and iCloud accounts. Let's look now, as we're thinking about these overt acts and the steps taken for murder. What was Alex Cox Googling? On October 1st, the day before Brandon Boudreaux was shot at, he Googles Brandon Boudreaux's address. October 8th, the day before Tammy is shot at, he Googles drop from 100 yards to 300 yards. He's figuring out how to sight in his rifle. October 10th, after the failed shooting, in what you heard from the Gilberts, Todd and Alice Gilbert, was an unseasonably cold October. How to prep your AR for the cold. AR-15 cold weather operation. How to help your AR load in the cold. FBI simulation shooting a 5.56 through car doors and walls. Then, 2008 Dodge Dakota steel body thickness. You heard testimony Tammy and Chad had. It was a 2004 Dodge Dakota. But he's figuring out shooting the steel body thickness just the day after he messed up his first attempt on Tammy's life. How to drill baffles to make a suppressor. Chad Daybell. Talking about overt acts again. September 8th, he searched south-southwest wind and visited what is the definition of south-southwest wind direction. Why? Because the next day he knows he will be burning Tylee Ryan in his fire pit, and he needs to know which way the wind will be blowing. You heard testimony of the officers who searched that account. This is the only time he searches wind direction. The only time. Lori on lollytimeforever at gmail.com, 8/25/2019. She's searching wedding bands made of malachite. Tammy's not dead yet. They've gotten rid of Charles, but Tammy is still alive, and she's already searching for wedding rings. 9/30/2019, a couple of days before Brandon Boudreaux was shot at from the back of a Jeep Wrangler. How to take the back seat out of my Jeep Wrangler. October 22nd, 2019, the day that Tammy Daybell is being buried. What is Lori doing? She's looking up wedding dresses in Kauai. Her boyfriend's wife is being buried that day, and she's already looking for wedding dresses. Let's talk about Tammy Daybell's phone and the text that was recovered from that phone. September 9th, 2019 at 11:53 a.m. Chad Daybell places himself in his own backyard and he says, well, to Tammy, well, I've had an interesting morning. I felt I should burn all of the limb debris by the fire pit before it got too soaked by the coming storms. While I did so, I spotted a big raccoon along the fence. I hurried and got my gun, and he was still walking along. I got close enough that one shot did the trick. He is now in our pet cemetery. Fun times. This text is where Chad Daybell told us where to locate Tylee Ryan. This text is where Chad Daybell told us he burnt her limbs. This text was further suspicious. Raccoons in daylight. It's not impossible, but they're nocturnal. And then he buries it in his pet cemetery. You saw the satellite footage of later in the day of September 9th, the disturbance in the ground near the pet cemetery. The day after Tylee Ryan is last seen in Yellowstone National Park. She's never seen again. But she turned up in that pet cemetery Chad Daybell was talking about that day. He told law enforcement where to find her. There are patterns that emerge through the digital evidence and through these iCloud accounts. About Chad and Lori's affair, you've read and you'll have back in deliberations the James and Elena story. Their future together. This was all a plan. Like I said at the beginning, a plan for them to be together without obstacles. Obstacles is the word they used. You learn about the relationship between Chad and Lori and Alex, and how Lori is the conduit of information to Alex. How Alex does what Lori tells him. The plan to remove obstacles. And those obstacles are Tylee Ryan, JJ Vallow, and their spouses, Charles Vallow and Tammy Daybell. And you also start seeing the need for money. How this revolves around money. I'm going to remind you about Colby Ryan's testimony. Her son's own testimony. That every 2 to 3 months, Lori would tell him, we're out of money. So it was a concern for her. In terms of the digital evidence, one of the overt acts is that on September 9th, Alex Cox went to Lori's apartment. You see here, September 9th, from 2:42 a.m. in the morning to 3:37 a.m. in the morning. Alex Cox goes to Lori's apartment. Why is that significant? September 8th, the last known sighting of Tylee Ryan. September 9th, she's buried in Chad Daybell's backyard. That morning, there's a phone call between Chad Daybell and Alex Cox. It's a 3-minute phone call at 8:11 a.m. By 8:49, Alex Cox is moving. We can track him by his phone. And at 9:15, he's just south of Chad Daybell's residence. These are the hits on GPS on Alex's phone on September 9th. From 9:21 to 10:57. Here's the burn pit that Tylee was burned in. Here's Alex's GPS hits right by where Tylee is buried, feet away. Another hit at the gate coming in. Again, within the same time frame as the text from Chad to Tammy about the raccoon. An overt act taken to further the conspiracy of the murder of Tylee Ryan and to keep stealing her money. At 11:47, Alex is just north of Chad Daybell's residence and heading south. They've done the deed. They've burnt Tylee. They've dismembered her, and they've buried her. And then that same day, phone calls. You saw the full cast report, and you have it to go, and I encourage you in deliberations to go look at it. Chad calls Lori for 3 minutes at 11:45 as Alex is leaving. September 23rd. Before we look at this, let's talk about the testimony you heard about September 23rd. Melanie Gibb and David Warwick spent the weekend of September 22nd and 23rd with Lori Vallow in her apartment. Lori tells Melanie, JJ is a zombie. He's acting totally different, using a religious belief to justify his death. An overt act. On the morning of the 23rd, David Warwick inquires of Lori, where's JJ? She tells him that he's been climbing up the cabinets and the refrigerator. So she sent him with Alex Cox. An overt act. Alex Cox took possession and custody of JJ that morning. We can see that from 9:01 to 9:41, Alex is in his apartment on September 23rd. There's a phone call, a 38-second phone call from Chad Daybell to Alex Cox that morning. 38 seconds at 9:25. By 9:45, Alex is again on his way to Chad Daybell's house, this time with JJ Vallow in tow. September 23rd. Here's Alex's phone, mere feet from where JJ was buried. Last known sighting of JJ, September 22nd. He was never seen again. No matter how many tips the police followed up on, they never found him. They never found Tylee until they found him here, where Alex's phone was being hit by GPS. He shows up, the first is at 9:55. At 10:12, he appears to be leaving on a Wi-Fi hit. So about 17 minutes. That grave was not dug in 17 minutes. That grave was too precise. It was too well prepared. This was planned. This was premeditated murder. Lori encouraged it. She aided it. She handed her boy off to Alex Cox. And then Alex Cox, at 10:12, heads back south to Rexburg. There's a lot of electronic devices in this case. You heard about a lot of electronic devices. This one is significant. Chad Daybell, on October 9th, activates a new phone. In a text to Lori from his old phone number, his normal phone number, he says, I will call right now from a 401 number. That was at 10:26. Oops, went the wrong way. 10:27. He's calling from the new 401 number. Let's talk about the digital evidence on October 9th, the day Tammy was shot at. Alex, from 12 to 1:23 p.m., he's at his sister's house. You saw the evidence. He goes to Sportsman's Warehouse. You saw what he bought, the black mask, the mittens, the black pants. That afternoon, this is one of the overt acts. He goes up and travels by Chad Daybell's residence. You can follow his phone as he scopes out the property again. And then He drives back past it. And then you remember seeing the evidence that his phone that night stayed at his apartment. Here's some of the digital data from that day. 6 texts between Chad and Lori between 5:28 and 7:03. Between 7:13 and 8:43, 15 texts between Alex and Chad. Again, ask yourself, what ties Alex to Chad? Lori Vallow. You remember Zulema Pastena's testimony that night, about that night. She hears Lori get off of a phone call and angrily proclaim, he can't do anything right because he failed. He failed when he tried to kill Tammy that night. October 18th, the night of the successful murder. Between 10:05 p.m. and 10:07, Alex Cox is traveling north. From 10:07 to 10:45, his phone is tracked at the Salem Church. This is just approximately 2.5 miles south of Chad Daybell's house. This is the night Tammy dies. This is the night Tammy was murdered. And you see some of the digital activity. 10 text messages between Alex and Chad between 10:23 and 10:54. At 11:28, an image is deleted off of Tammy's phone. 11:34 to 11:35, Chad sends 2 texts to Lori. 11:46, Alex leaves the parking lot. 11:53 to 12:09, Alex calls Lori. Remember where Lori is. She's in Hawaii. On purpose, not a coincidence. And here's that call from Alex to Lori. And here's her receiving it in Hawaii. Let's talk about the crime scene. Chad Daybell's residence. For some reason this isn't coming through. You've seen this exhibit. You have all the pictures of this exhibit. I encourage you to take them back in deliberations and look at them. Upon discovering the raccoon text, upon reviewing Alex Cox's digital data, law enforcement serves a warrant June 9th, 2020 on Chad Daybell's residence. You remember multiple officers testifying to you of watching Chad Daybell in that front yard, sitting in his car, nervously looking over his shoulder to the location where Tylee was buried. You heard a phone call that morning from Chad and Lori that was recorded. They're searching the property. And you can hear the fear and the guilt in both of their voices. They know what's about to happen. On that crime scene, the fire pit. This is how it was found by law enforcement that day. And you heard testimony, how they removed the debris. They raked it. They sifted that ground, and they found pieces of Tylee Ryan in that fire pit. They found this chain in that fire pit. They found this charm that's also located on State's Exhibit 6, being worn by Tylee Ryan. just approximately 30 feet from that fire pit. And the pet cemetery. Again, you saw satellite footage that same day of the disturbance in the ground. You saw how law enforcement, they started their search. They found a dog and a cat. They moved north. They found what they thought might be a human bone. And they continued to dig. And this is what they found. This is what was left of Tylee Ryan. Charred flesh, dismembered. They came back the next day and found this bucket. You heard the testimony of multiple officers talk about how it felt like this ground had concrete or quickcrete in it. It was hard, and they had to finally use the backhoe to pull it off to get to this bucket. And when they finally did, they found this material that was Tylee Ryan. And again, sitting on top of a piece of her skull. That's not the only place they found Tylee Ryan that day, though. They also found pieces of her here in the shed. You heard how law enforcement searched the shed for tools that could be used in the commission of these crimes. These shovels, this pickaxe were of particular interest to them. You heard testimony of this pickaxe, how it was taken to the Idaho State Lab, how in the eye of that pickaxe there was material that looked different than the dirt, so it was separated out. It was tested for DNA. It was tested against the profile of Tylee, and it was Tylee in the eye of the pickaxe. This shovel, you heard how on the back of this the kick plate of that shovel, there was a piece of material that looked like it could be organic material. Again, it was tested for DNA, and it matched to Tylee Ryan. There was blood on the handle, tested, and it matched for Tylee Ryan. You heard testimony of how Agent Doug Hart was the first person to find this piece of ground, a mound. The vegetation was lower. You heard how he'd had training to find clandestine graves. You heard how he put his hand on the ground of the sod that had been removed, that he tried to probe it, and his probe wouldn't go through. And why? Because they found this, meticulously placed rocks and boards. You heard the testimony of multiple officers about the smell emanating. And they began to see what they thought was a human head. They checked it. There was human hair. Look at this grave. The roots are cut. It's just the right size for J.J. Vallow. This was prepared in advance. This was a premeditated murder. The day was dug. J.J. was murdered. You heard testimony. Again, Lori Vallow handed J.J. off to Alex Cox. Tylee, JJ, and Tammy can't tell us what happened, but their bodies do. You heard testimony about the testing that was done on Tylee. One, they had to do DNA testing just to identify her because she was too broken up and 2 dismembered. You heard Dr. Christensen and Mr. Halapaska talk about puncture wounds in her pelvis. How those wounds were not the wounds of dismemberment. They're separate wounds in her pelvis. J.J. Vallow, gagged and bound. Tammy's body, bruises consistent with restraint, homicide by asphyxiation. This is Tylee. Here are the marks talked about by Dr. Christensen and Mr. Halapaska. That's not where she's being dismembered. Mr. Halapaska said those marks are consistent with stabbing. The white bag over JJ's face, the duct tape that blocked his airway. We know how he died. He was asphyxiated. He was bound with duct tape. A 7-year-old boy with special needs. Tammy's autopsy. You heard from the medical examiner for the state of Utah. She was exhumed. You heard about the extensive toxology they did. They found nothing. They found nothing in her that would have killed her. Her internal were healthy. Her brain was normal. There was nothing in her body that would have killed her. She had bruises on her arms. Remember, JJ had bruises on his arms too. She had bruises on her arms that the ME stated were consistent with restraint. She was murdered by asphyxiation. We told you this was about money, power, and sex. We talked a lot about religion, but this is not a case about religion. It's about money and power and sex. Let's talk about the money for a minute. Lori learned a lesson with Charles Vallow. The lesson she learned was to make sure you get the money coming to you before you commit the murder. She thought she was going to get the insurance money. She texted Chad about it. I talked to the insurance company. He changed it in March. So it was probably Ned. Remember, Ned was one of the other names for Charles before we got rid of him. I'll still get the $4,000 a month. So within a week of killing Charles Vallow, she's already talking about the Social Security she's going to get. It was planned. Tylee Ryan's Social Security. Tylee Ryan started collecting Social Security in June of 2018 when her father died. She collected it monthly. On July 11th, Charles Vallow dies. August 12th through the 20th, I believe the date was August 16th, Lori Vallow changes the deposit on Tylee's Social Security. Tylee was receiving her own money. You heard testimony about her spending habits. She was paying for her Jeep. She bought fast food. She lived like a normal teenager. And then Lori takes that money and starts putting it into her own BBVA account. Because she learned her lesson. She gets the payment on August 28th. September 8th, Tylee dies. She made sure to get the money before she killed Tylee. J.J. Vallow. He collects Social Security after Charles Vallow dies. He collects it as a survivor, and she collects it as a parent in care of a survivor. Again, get the money and then commit the murder. Last proof of life for JJ is the first deposit, September 18th, 2019. Days later, JJ is dead and murdered and buried in Chad Daybell's backyard. She made sure to get the money first. She collected multiple payments. By the way, while we're here, let's talk about grand theft. What do you need to find her guilty of grand theft? That she either used deceit to take money that did not belong to her, or that with the intent to possess that money, she took money that did not belong to her. After this date, she has no right to any of this money. She failed to report. What's the amount you need to find for grand theft? It's $1,000. Ladies and gentlemen, if you find between any of these payments and any of these payments that Lori Vallow collected $1,000 she was not entitled to with the intent to keep it, you must find her guilty of grand theft. They're the benefits of murder. She thought she was getting $1 million from life insurance from Charles. Chad got $430,000 in life insurance from Tammy. From Tylee, she began to collect $1,859 per month in Social Security into her own account. From JJ, $1,951, and as her parent in care, $1,951. Remember Zulema Pastena's testimony when she asked Lori how they were going to finance this gathering that she kept talking about. She said, Melanie Boudreau will take care of us all. Brandon Boudreau was shot at. Brandon Boudreau had a life insurance policy. Money is the motive for murder. Power. Let's talk about religion for 1 second because we've heard a lot about religion. It does not matter what they believed. It matters what they did. They can believe whatever they want. But when they use that to justify homicide, that changes. They used religion as a tool to manipulate others. Lori manipulated Alex Cox through religion. She manipulated Chad through emotional and sexual control. They manipulated their friends through this use of religion. Let's talk about how she groomed Alex Cox. Ladies and gentlemen, you have multiple iCloud conversations in evidence that you can review in deliberations. I encourage you to do so. I'm not going to read everything here, but let's look at some of the things Lori said. March 20th, she says to Alex, I'm finding out some great stuff about you. I learned about you. You're going to like it. We can talk about it. How does he respond? Okay, hurry, please. He's eager for the knowledge. She says, we can talk about it tomorrow, hopefully. They moved to Rexburg. He's going to go sight in his rifles. Fun. You need the practice. Lori Vallow is telling Alex Cox what to do. In these messages, you never see Alex tell her what to do. He's telling her what to do. She's telling him what to do. They have a conversation about JJ and a boy named Zach. And he says, my lip sealed. How does she respond? Good boy. Learning more. I'll fill you in the afternoon. Again, she's the conduit of information to Alex. Remember what Alex's wife, Zulema Pastena, said. He believed all of it. Where does he get it? He gets it from Lori. Why does she give it to him? To justify murder. You heard from Zulema Pastenas. You heard from Melanie Gibb the description about castings, these descriptions of light and dark scales. You heard a lot about it. The only reason it matters is because it's the tool they used to manipulate others. They used it to manipulate Melanie Boudreau. They used it to manipulate Zulema, Melanie Gibb, Alex Cox. Again, who is the common thread here? It's Lori Vallow. We talked about sex in this case, how it was a motive, their affair, how they had to remove obstacles so they could be together. Those conversations often turn sexual. always talking about their future together, their plan to be together. The conversation on July 14th between Chad and Lori, where he wants to kiss her for hours, and it would likely lead to other activities. And she says, likely or luckily lead to nakedness. Again, their conversations. He's saying she's incredible. Their mission has barely begun. Her mission has barely begun. As long as it ends with you, it's all good. Wish I could see with you and be cheek to cheek. Lori uses sex to manipulate Chad. And Chad seeks confirmation from Lori repeatedly. July 13th, he's having a conversation with her about when they can spend time together and about Tammy's passing. And at the end, what does he say? Please ask about that. He's asking her to confirm. Why? Because Lori and Chad are driving this together. It's their plan to be together, to get rid of the obstacles. Chad tells Lori that he's been instructed to focus his efforts on Hillary, who you heard from testimony in other places in the iCloud is established as Tylee Ryan. What does Lori say? She doesn't say, you know what, maybe we shouldn't kill my kids. She says, okay, find out her percentage for me and JJ's. And when Chad talks about Tylee's low death percentage, meaning she's close to death, and how JJ needs to follow Amy into the light. Ladies and gentlemen, we all know what it means to go into the light. He's talking about a young boy's death. And he assures JJ that Chad would be there. James would love and take care of his mommy. Because JJ is going to be gone because he's followed someone in the light. And how does she respond? Again, she doesn't say, maybe we shouldn't kill my kids. That is sweet. I miss you desperately. She wants these children gone. There's no doubt. She wants these children gone. She is encouraging their murder. July 23rd. She asked Chad, need you to check JJ. When you get home, check Tylee. She's being super sweet and helpful. And she cleaned her room. She got switched. Totally not her. See if she got switched. Again, they're using this religion, even amongst themselves, to justify murder. And she's encouraging it. This isn't fantasy. Those children were found in real life, dead in Chad Daybell's backyard. Again, 7/26/2019. In response to a text from Chad, need you to check JJ. She said he was calm and he watched movies all day, which she would never do. Justification for murder. This isn't JJ. Justification. She's encouraging, she's aiding. This text removes any doubt that they are talking about murder. From Chad to Lori, 7/30/2019. I got the inspiration to go back to my original death percentages that helped us track Charles. Not me, us. Charles, Ned, etc. What happened to Charles? Charles got shot in the chest by Alex Cox. Tammy is very close. So after he's talking about death percentages to track Charles, Tammy is close. They are talking about murdering Tammy. Her percentage has fallen. It is encouraging. And how does she respond? What is the percentage now? And then, what about JJ's too? So on July 30th, she's already planning for JJ to go the same way as Charles, to be murdered. Chad responds, Tammy is at 3, JJ is at 2. Both are being heavily shielded to stop intruders. And what does she say? She doesn't say, maybe we shouldn't kill children. She says, 2 and 3%, not 0. She wants the children gone. He says he'll explain when they talk. And this is sexual manipulation. Okay, still feeling hot for you. He's telling her what she wants to hear. She reinforces him with sexual behavior. Again, this is in the iCloud. I encourage you to go look at it. Here, it's a continuation of that conversation. Yes, we might need to release a little steam when we talk. Anyway, this is the chart that checks what percentage mortals are still in their body. It worked for my wife's friend who died, a real person. My neighbor, a real person. George Bush, Stanley, real people. This isn't fantasy. They're talking about the deaths of real people. This afternoon, Tammy said she felt lightheaded, as if her body and spirit weren't connected. They're talking about Tammy's death. Again, Lori, this is at Lori's initiation. Please check JJ. She's asking him to check for these death percentages. He says JJ is still JJ. Is he at 0 yet? August 10th. 6 weeks later, he's dead. August 10th. Is he at 0? She can't wait. Yes, he's at 0. He probably was partly through the veil. Ladies and gentlemen, there is no question what they're talking about. The veil of life and death. They are talking about the death of J.J. Vallow. August 10th. Again, Lori initiating this conversation. Do you think there is a perfectly orchestrated plan to take the children and we just have to wait for it to be carried out? I feel lost, like I should be doing something to help. Not, I think we shouldn't kill the children. I should be doing something to help for the children to be taken. And Chad tells her, there's a plan. What should I be doing? What do I need to do to make this happen? That's what Lori's asking. And he tells her she's doing everything right. He said to just keep resolving the telestial issues so you are unencumbered and fully free. Unencumbered by your children, fully free. Think about the money. Think about how Lori would talk about JJ. She saw him as difficult. The same conversation. Chad expresses his love, and Lori says, I can't wait. Literally can't wait. I have no patience. I want you now. Again, she's using sex to reinforce. Chad's telling her what she wants to hear. There's a plan to get rid of these kids. She reinforces him. The next day, Lori says to Chad, I'm so alone without you. It's devastating. And he says, we are surrounded by celestial relatives that are simply obstacles. I'm so sick of it. Again, she doesn't say, maybe we shouldn't kill our relatives. Me too. What is it that you really want? Never a hesitation. She wants to move forward with this plan. They move to Rexburg. Alex Cox sends Lori a text about setting up their Wi-Fi. The password, too many kids. Too many kids. And she says, funny. It would be funny if her children were alive and just rambunctious and hard to deal with. But that's not what it meant. Her children are dead. There were too many kids and they had to get rid of them. And he says, I can change the password. And she says, we are trying to get to the bottom of what we need to do to eliminate them completely. He had mentioned Z's or zombies in the text above. And then again, I'm sure you will be told also, manipulation of Alex Cox with religion. I will provide you this information in the future. Four days before Tammy is shot at. Big news about Tammy. Please let me know if you're awake and can talk. I love you. Chad goes into this conversation about Tammy being in limbo. There's a demonic entity in her. He goes on, and then what does he say? Please seek a confirmation on this. Why is that important? Because Chad's not going to act without Lori saying so. Seek a confirmation. Not fully sure of the timing for removal, but once your actions verify the differences, I don't want to wait. And he's asking Lori for confirmation on that. Interestingly enough, 2 days after that conversation, Lori texts Melanie Boudreau, I'm really feeling like we need to go to Missouri and work. They go to Missouri. They fly out of Phoenix that the morning of the 9th, head to Missouri. So she's gone at the attempted shooting. So she can try to separate herself from the attempted shooting. Melanie asks her some questions about the kids and about the logistics. Lori tells her, you need to be unavailable. That's the schedule. And how does Melanie respond? Okay, Captain. Why does she say okay, Captain? Because Lori's in charge. The day of Tammy Daybell's death, she's texting Chad, not fun without you. His wife just died. She didn't just die, she was murdered. And that's why she feels comfortable texting him like this. The next day, she says to him, I'm missing you more. I need you desperately. I can't wait. That same day, he texts her about the Lily workout plan. Remember, Lily is another name for Lori. This is her workout plan for him to get in shape. She says, I love that plan. Not soon enough, though. This is torture. She's moving this along. She's moved this plan along the whole time. Again, just more love text between Chad and Lori. Ladies and gentlemen, you have your instructions. You're going to go back and you're going to deliberate. Read them carefully. Consider all the evidence. Look at all the facts. Look at the timeline. Look at the timeline. Charles Vallow, Tylee Ryan, JJ, Tammy, all within a short time frame. How are they tied together? Who could have killed those people? You have Lori Vallow, Chad Daybell, Alex Cox. Who had motive to kill those people? Lori Vallow and Chad Daybell. What is the thread between Alex Cox and Chad Daybell? Lori Vallow. Who benefits from these murders? Lori Vallow gets Tylee's money. She gets JJ's money. She and Chad get Tammy's money. Ladies and gentlemen, the burden is beyond a reasonable doubt. A doubt based on reason and common sense. What does your reason and common sense tell you? You've seen what happened to her children. What happened to Tammy? She never reported the children missing. She lied and she lied and she lied about where they were. And while she lied, she kept collecting the money. You saw the text between her and Chad. She is moving this plan forward. That's why they moved her expert. She's moving this plan forward. There is no question that Tylee Ryan, JJ Vallow, and Tammy Daybell were murdered. Who is the common thread? Lori Vallow. What does justice for these victims require? It requires a conviction of each and every count. She conspired for Tylee to die and to keep her money. She conspired for JJ to die and to keep his money. She aided and abetted in Tylee's murder. She encouraged it. She aided and abetted and encouraged JJ's murder. She aided and abetted and encouraged, or she conspired. Let me repeat that. She conspired and agreed to Tammy Daybell's murder. Look at the timeline. Ladies and gentlemen, go back through the elements, go back through the evidence, and you must convict her.
Right, that concludes the state's closing argument. I'm going to suggest we take another recess at this point, if that's all right, Mr. Archibald, and then we'll hear closing arguments from the defendant.
All right, please.
All right, we'll come back on in about 20 minutes. Thank you. Let's have the jurors brought in, please.
All right, please.
Thank you, Mr. Bailiff. Please be seated. We're back on the record on KCR 22-21-1624. Concluded our morning recess. The jurors are all properly seated. The defense is present with counsel as well as the state. At this time, the state concluded its closing argument. The defense may now present its closing argument. Mr. Archibald.
So
Looks like I'm going to go into the lunch hour. Do any of you need to have any plans to make phone calls or anything for lunch? I'm going to go into the lunch. Okay. So, first of all, thank you for your service. You have a tough job. We talked about this almost 7 weeks ago when we first met. You came in and filled out your questionnaires, and we talked about hardship and bias, and we talked about that this would be a difficult case. So you were asked if you could be fair and impartial, reserve judgment till the end, and we're getting close to the end. So you were asked to be patient and attentive while putting your job, your family, your life on hold. So again, thank you. And thanks to opposing counsel. We're small town lawyers. We're not from Boise. We see each other frequently. We have to get along. We have a lot of cases together. Our system is adversarial in nature. We're called opposing counsel, but we do respect each other, and we respect the positions and the jobs that we have to do. You've seen a lot of PowerPoints over the past month, and I'm sorry that I don't have one. So I'm just going to talk to you, if that's okay, talk to you about the evidence and the arguments and the law. And my clients always ask me, why does the prosecutor start and end? So after I'm done, then the state gets to have another crack at it. And that's just because of their burden of proof, that the state has the burden of proof. So they get to go first and they get to go last. And so my clients always wonder, that's not fair. It's just our system. That's how it works. So who is Lori Vallow? What happened? Where did it happen? When did it happen? Why did it happen? That's what you've been asked to figure out. And that's what you need to be convinced of beyond a reasonable doubt. So you've heard a bit about her background from her sister, her son, her friends. She was born in 1973 in California. She turns 50 next month. Raised there, dad, mom, brothers, sisters, attended schools there, got married right out of high school, got divorced, went to beauty school, got married again in Texas. Her son Colby, who you met, born and raised in Texas and Arizona. She worked hard as a single mother, got married and divorced again. And her third marriage was to Joe Ryan in Texas. Tylee was born. We've heard a lot about Tylee. She had some medical issues. Children needed protected from her third husband. So a divorce, court involvement, fourth marriage to Charles Vallow, lived in Texas and Arizona and Hawaii. Heard about that. Charles had 2 kids. Lori had 2 kids. So they adopted a child to have one together, and that was JJ. 5 kids between them. 5 kids forever. You heard what that was about. You heard that JJ had medical issues when he was born, and that Charles and Lori were a good fit for him, and they loved him and they cared for him. So then the story about Lori Vallow, as you've heard, changes dramatically in October of 2018. Who is Chad Daybell? She had read some of his End of the World books. She knew about some of his sayings. The first time they met, he told her they were married in previous lives. They had multiple lives, multiple probations. We are archangels. We have other names like Methuselah and Raphael and James and Elena. We've been selected to lead 144,000. Our mission on earth is to prepare for the second coming of Jesus. Evil spirits are real. When they possess a body, they need to be cast out. People have light and dark ratings. And then she and Chad were married in the temple, and Jesus was there. So quite a remarkable change from the people who knew Lori. What the heck is going on? How can this be? So fast forward a year from October of 2018 to November of 2019, 1 year after meeting Chad, 4 people are dead. One of those deaths you don't consider as guilt for this case. It's really difficult for jurors to do. Wait a second, you told me that Charles was killed, but you don't want me to consider it for guilt. But for some other reason, what other reason is there? So the judge gave you an instruction about that, and that's difficult. It's difficult for lawyers to figure out. And so if you have questions about that, that's a tricky instruction. So 3 others are dead in Idaho. Lori's arrested first, as you heard the jail calls, and then Chad. So you've now heard about a summary of the indictment, what she's charged with. I talked to you weeks ago about pay attention to who does what. Pay attention to burden of proof, that I don't have to prove anything. I don't have to call a witness. My client doesn't have to testify. And you can't hold any of that against me. You can't hold it against her. Because sometimes that just happens in a trial. And so it's not for you to guess who or why, but to just consider the evidence that's been presented. So the judge has talked to you about what reasonable doubt means, what presumption of innocence means. And this is an important job that you have to do. And so again, I want to thank you for that. Pretty soon, 6 of you are going to get bumped. And that is terrible, to have to sit through a trial. There's 18 of you, and the judge is going to pick numbers out of a hat to see who stays and who goes, because only 12 can deliberate at once. And so I think the plan was that during a long trial, someone's going to get sick, someone's going to have issues at work or at home or a death in the family. Something's going to happen that some of you aren't going to show up. And all of you showed up, every single one of you. And that typically when we have so many alternates, there's a reason for that, is because over a long time, things happen at home. So it's super bad to sit here for 7 weeks and then have to go home and don't even get to deliberate. And so for you alternates who get bumped, again, we don't know who you are yet. Thanks again for your service, but I'm sorry you don't get to deliberate with your fellow jurors. So since the trial started, you've been able to see my client. You've been able to see her responses to the evidence. You've been able to see all the evil eye glares that she gets from the audience directed toward her every single day. You've been able to see the witnesses, you've been able to see the exhibits, and you've been able to listen to the tapes. 6 times during this trial, you heard my client's voice. Detective Stubbs, Melanie Gibb, Colby Ryan, Summer Shiflett, Chad Daybell, and a podcast with others. So if you want to remember how she responded, what she said, go to those 6 pieces of evidence, and you can listen to them again in the jury room. So is this case about money, power, and sex? So that's the state's theme of the case. I respect their theme, and I'd like to talk about it. So is this case about money? Well, you have an exhibit 68A, and this exhibit that was admitted is Tylee buying a car in April of 2019. Charles Vallow is the co-signer. Charles tells the bank that he's a full-time professional marketer, that he makes $500,000 a year. Charles says this in Exhibit 68A. So in other years, Charles has stated he makes $400,000 a year. That's in Exhibit 66D. Either way, the Social Security money that she'll make from a dead spouse will never equal $400,000 or $500,000 a year. Never. So that Social Security money, did Lori, with a spouse who makes $400,000 to $500,000 a year, really want to kill Charles for money? That just doesn't make sense. The math does not add up there. So would she leave Charles and go to Chad for money? And what did we learn about Chad and money? According to Samantha Gwilliam, he's an author who has gone bankrupt because he can't sell enough stupid books about the end of the world. So his wife, Tammy, who would rather stay home with their 5 kids, she has to work at a school for $15,000 a year. And then from an insurance agent, we learned that Chad almost qualifies for Medicaid, but not quite. So he had to find an insurance plan because he made $20,000 to $30,000 a year. So Lori wanted to ditch Charles Vallow, who makes $400,000 to $500,000 a year, and go to Chad, who makes $20,000 to $30,000 a year, and she wanted to do that for money. That, my math, that just doesn't add up. So then the state says, well, maybe she killed for power, and this is about power. So Lori wanted power. So how did that work out, Lori? In the year that Chad convinced her that she was a sexual goddess and a leader of the 144,000, and that she was going to save the world, how many converts did she have? 0. I'm counting a big fat 0. How many converts did Chad have? Again, we have to get to 144,000. How many converts did Chad have? I count maybe 6. Melanie Gibb, Zulema Pastinas, Audrey Baratario, and 3 from the same family: Lori Vallow, Alex Cox, and Melanie Bedreau. Was Ian Pulowski a convert to the cause? No. David Warwick? Nope. April Raymond? Nope. Colby Ryan? No. Summer Shiflett, no. So this great and wonderful cause of saving the world, getting ready for Jesus to come, we need to gather up the 144,000. And in 1 year, we got 6. Chad got 6. Lori got 0. So, again, doing some simple math. Chad has 143,994 people left to gather before Jesus comes. So at the rate of 6 people a year, it'll take Chad 24,000 years to get his army assembled. So the math is ridiculous. So is this case about sex? You want to have sex outside of marriage? Go for it. Happens every day in America, unfortunately. So use your reason and common sense when you look at pictures of Chad and you look at pictures of Charles. Was it a physical attraction to trade in Charles for Chad? Was that a trade up or was that a trade down? Is she falling in love with Chad because of his money? No. She's reading his books during a vulnerable time in her life. And this guy is telling you you're a goddess, a sexual goddess, no less. And you're special and amazing and wonderful. And by the way, we've already been married in previous lives, so it's not really cheating. And also, by the way, we were best friends with Jesus. And so if Jesus approves, then everything's okay. So that's quite a pickup line by Chad to Lori. And it worked. How did that work? Pretty scary that pickup line from Chad to Lori would work. So what did the evidence tell you? What were you convinced of beyond a reasonable doubt? Her children are dead. No question about that. But did she kill anyone? And that's where the state concedes. Yeah, these people are dead, but did Lori do it? So you listen to 60 witnesses, you received hundreds of exhibits, and there's literally thousands of exhibits you can review that are on those flash drives. So I want to go over some of that with you. 60 witnesses included city police, county police, state police, federal police. They have a lot of resources available to them, as we found out. And you can find out a lot of stuff about someone. And what I've learned about doing trials over the years is that you will pick up on something that I didn't. And this juror will pick up something that that juror didn't. And why is that? Because we all have our own common sense and our own reason. And we all have our own life experiences on which to draw. So we see things differently, and that's okay. That's what makes this a great system. For you 12 jurors from 12 different backgrounds to get together and talk about this. So I'm just going to point out some of the witnesses, not all. You have your notes to rely on. If I state things differently than what you state, what you wrote down, then as the judge said, rely on your memory, not mine. So the first witness here in this trial was Kay Woodcock, Charles' sister. She described Charles and Lori as the all-American family. They were great parents. She trusted her brother, Charles. she trusted Lori. They were good parents. They each had 2 kids. Then they adopted one together, and it was just perfect. And she told you, as every other witness, something changed in late 2018 or early 2019. Brandon Bedreau, he testified, gosh, Charles and Lori were great. My kids played with their kids. I loved that family like my own. But then all of the end of the world talks ramped up and things got weird. So Charles died. I got divorced. I got shot at. And so things just got really weird really quick. Officer Hermosillo, what a tough job he has when he had to describe the stench, the smell of decaying bodies during a search of Daybell's property. That was pretty brutal. And what did he tell you? He said Chad Daybell, when the cops showed up, called his lawyer to make sure that the cops could be there. And what's Chad doing? He's outside looking over his shoulder. Then he sped away and got arrested. So when Chad was looking over his shoulder, what's that inference? That Chad knew what was in his backyard. He knew that time was short for him. So then Captain Wilmore, captain at the jail, he recorded a phone call Lori made from the jail to Chad when he was at his property. And when I listen to this call, it's apparent to me that Lori does not know what's in Chad's backyard. But I'm Lori's lawyer, so don't trust me. Listen to it again. So that's the way I hear it. Lori does not know what's in Chad's backyard. She knows her kids are missing. She knows that her kids aren't with her. She knows that they're safe and happy, whatever that means. If that means people are dead, if people are safe and happy if they're in heaven. But does she know that Chad and Alex stuffed her kids in Chad's backyard? So listen to it again, and you make your determination. So then we have other witnesses about, and I know weirdness isn't a legal term, but that's the only way I can describe this, all this religious babble. All about you've been married in previous lives, multiple probations, multiple lives, special missions on earth, light and dark scales, contracts with Jesus or contracts with Satan. Just a lot of stuff that really does not make sense. So you have to sort through that to see, again, in America, you can believe how you want, but you can't go killing people. And so what are they talking about? What's up? What is all this religious talk? Then Melanie Gibb records Lori. You'll have a chance to listen to that. That's where Lori says, with Chad sitting right there, the kids are safe and happy. And so does she know her kids are dead? Well, she knows they're not with her. Does she know that Chad and Alex were out in the backyard together. Remember all the GPS data? Lori's not there. Lori's not in the backyard when Chad and Alex are. She's not coming and going to Chad's property on those days that the state points out. She's not there. They're calling her, they're texting her. Are they texting about, hey, today's the day we're going to kill some people? Is that okay with you? We don't know that. Or are they saying, yeah, I'm just running an errand. I'll be back. Do you want a real Coke or a Diet Coke? We don't know the content of those text messages. Unfortunately, we have lots of content of text messages about the James and Elena story. We have lots of that crap, but we don't have any texts about today is the day we kill people. So look for that. Look for the lack of evidence about who's doing what. Part of your job. That's part of your job to figure it out. And if lack of evidence is something that the state hasn't shown, you can't hold that against me. You can't hold that against my client. You hold the lack of evidence against the state because they have the burden of proof. And I didn't make up those rules. The judge didn't make up those rules. We're all following the law. And that's what the law tells you to do. And so we have other witnesses. Chad's blessing on Alex. You can listen to that if you want to. Listen to that again. Just to me, it's craziness. Opening the portals of time, third creation, fourth creation, great warriors exalted in the fourth creation could have gone on to exaltation, but came back in the fifth creation. In the heck is Chad talking about? He's the leader of his new church, Church of the Firstborn. He calls himself a patriarch. Just goofy stuff. You hear from other witnesses about this religious talk. You hear from Colby Ryan, my client's son. Lori was a great mom. She did everything to protect us kids. I would never think she'd do anything to harm anyone. She taught us to do good, to follow Jesus. After she met Chad Daybell, she changed. Her beliefs changed. That telephone call that you heard, and again, if you want to hear it again, please do. Just so painful. So painful for Colby. You heard from April Raymond, Lori's friend from Hawaii. Lori was nice and normal. She was a friend, a neighbor. We went to church together. And then Lori came back a year or two later for a visit, and she had changed. She talked about demons. She talked about people being possessed. She talked about leaders of the 144,000. She asked me if I would join them and be separated from my children to join them. And I could leave my children with their father. And what was April Raymond's response? No thanks. I'll stay here in Hawaii. But good luck to you on your mission. You heard from Sydney Shank, a BYUI student hired by Lori for babysitting JJ. Now, if Lori has a plan to kill her kid next week, why go to all the trouble to hire a babysitter? Why bring the babysitter over and introduce her to JJ and the medicines and the routine and the school? Why check JJ into school if you're going to kill your kid next week? Why do that? Because Lori didn't have a plan. The state wants you to think that this was Lori's plan to kill her kids. Look at Exhibit 82A. It's Lori's rental application for a Rexburg apartment. It's dated August 14th, 2019. It's 2 weeks before she moves to Idaho. She wants to rent in Rexburg. So Exhibit 82A is a rental application. She puts on there that she has 2 kids, Tylee and JJ. She puts on there that she's living on Social Security income. So if her plan was to kill the kids as she got to Idaho, in fact, the state's saying Tylee went missing the same week they got to Idaho. Why list her kids on the rental application? If you're moving from Arizona to Idaho, why not go drop off the kids somewhere else? Why not? Why tell everyone you have 2 kids? Why enroll them in school? Why hire a babysitter? The only thing that makes sense to me is that she didn't have a plan. She wanted to be with Chad. They were obviously having an affair. Chad told her all the time about dark and light things, but there was no plan by Lori to kill her kids, or else she wouldn't have done that. So did she lie about it? Yeah, she did. When people started showing up, hey, where are your kids? And notice that she lied. Well, they're in Arizona. Well, they're with grandma. They're at a movie. That's right. They're at a movie, Frozen 2. So all lies. So why was she doing that? To protect Chad, her lover, her eternal in how many worlds companion. How can someone have that much control over you? And we've heard about that over the years, haven't we? That reason and common sense of people just go out the window sometimes when religious principles are involved. It doesn't make any sense to us, does it? We heard evidence from the FBI that one thing the FBI pointed out is that Lori did not get life insurance for the children. Okay, so they're saying she's cunningly crafting a plan to knock off all these people. How about go get an insurance policy on the kids? No proof of that, is there? So she didn't go get an insurance policy on her children. Well, does that tell you maybe she was not planning to kill her kids, or else she would have gone? People do that all the time, right? I'm going to go get insurance on someone and then kill him, and then I'll get a bunch of money. And that is no insurance policies on the 2 children. We heard from the FBI about who's out in the backyard. Well, Chad and Alex are out in the backyard, not Lori. And we heard from Summer Shiflett, similar to Colby Ryan, just a real touching witness. Known Lori her whole life. I'm Lori's younger sister. I'm close with Lori. She would have never done anything like this. That conversation is recorded. So if I've misstated anything, listen to it again. I have supported you your whole life. Chad has lied to you. Chad has deceived you. She also told us about who Alex was. Alex was an adult man stuck in a 16-year-old brain because of a car accident, traumatic brain injury. That's who Alex was. Lori Summer told us was a good mother. She loved her children. She took care of them. She protected them from abuse. She never talked about zombies. She never talked about 144,000 or other weird stuff. She never talked about saving the world. Never talked about light and dark ratings. She taught her children good things. Tylee and Lori were cute together. Lori would never kill her kids, never agree for someone else to kill her kids. That's what Summer told you. So then we dove into more evidence. What was the cause of death? So evidence that I'm sure you have notes on. I'm sure the photos are burned into your brain that you'd wish would go away, but those photos will be with you for a while. They're hard to delete that stuff. We talked about a hair on tape, on a piece of duct tape. So JJ's body had tape wrapped around it, and one of Lori's hairs was found on that duct tape. So is that a smoking gun? No, not at all. And why not? Because that decomposition fluid was also in that bag. The pajamas were also in that bag. Kids' socks were also in that bag. A kid's blanket was in that bag. And so to say Lori's a killer because they found a piece of her hair on duct tape, that's not true. I would hope all of you, your mothers, all of you who are mothers, I would hope that your hair is somewhere on your kids' pajamas, your kids' socks, your kids' blanket. There probably is. That doesn't mean that she's a killer. We talked a lot about Tammy's death, and Lori was in Missouri when she was shot at by either a paintball gun or a real gun. We don't know which, because we didn't find any paintball residue and we didn't find any bullets. So the evidence is we just don't know. We spent a lot of time talking about what we don't know. And the evidence is clear that Lori was in Hawaii when Tammy died. And what did Tammy die of? Well, natural causes at first, then asphyxia second. And so what did the doctor tell you? Well, I talked to the police as part of my investigation as to what they think happened. that's okay. That's what a doctor's supposed to do, get the history. So the doctor gets the history and says, well, maybe it was asphyxia instead of natural causes. And then the doctor said, well, yeah, I guess it could have also been seizures because Tammy had been on Prozac for a long time. And seizures are a side effect of long-term use of Prozac. So that death is up in the air. Was she even murdered? Is it a natural death? Chad, to believe that she was murdered, Chad is so smooth that he convinced a county coroner, a county assistant coroner or deputy coroner, and a police and another policeman that it was all natural causes, and convinced his kids. Because remember, the kids showed up. Oh my, what happened to mom? And Chad convinced them all, sorry kids, mom died in her sleep. Okay, Dad. So just evidence. You're being asked to convict Lori on killing Tammy when Lori's in Hawaii. You're being asked to convict Lori for killing Tammy when do we even know for sure it's a homicide? Have you been convinced beyond a reasonable doubt that it's even a homicide? So we hear from the neighbors, good folks, Alice Gilbert and Todd Gilbert, nice people who say, yeah, Chad told us that his wife Tammy was going to die before she hit 50 years old. And so if Chad had told that to the nice neighbors who hung out with Tammy, wouldn't Tammy had also known about her husband's prophecy? Wouldn't that explain why Tammy increased her life insurance? Not because Chad was manipulating her to get more life insurance, but because Tammy, what do we know about that? That Tammy was still with Chad. Even how nutty Chad was, she was still there. She still had 5 kids with him. She went bankrupt with him, trying to sell his stupid books, and she's still there with him. She's still loyal to him. So her prophetic husband, who says, dear wife, you're going to die next year, would that cause her to increase her life insurance so that her kids could be provided for? Prove to me that that's false. There's no proof that that's false. Then after the nice, and the Lori's statements are also introduced as evidence with the Gilberts as well. So if you want to listen to that, you can. Then we hear from Audrey Baratario, and I got a little excited during that testimony. So if I offended any of you, I apologize. That testimony, I thought the witness was making up stuff, and so I got a little excited. But what did we learn from Audrey? Well, she's married to Jesus. That's kind of cool. I'll follow you to 5 different states, but I'm really not a follower. And I don't like it when my good friend Lori tells me for no reason that she's going to kill me. And I'm not going to testify about that under oath because I'm scared. So just again, more weird stuff. Chad had been Methuselah in the Old Testament. He'd been James in the New Testament. I moved to Missouri because that's where Jesus is coming. And by the way, I'm married to Jesus. I moved to Missouri because that's where Adam and Eve lived. So you just have to sort through that and figure out what's credible and what's not credible with these witnesses. What is real and what is imaginary. We heard from witnesses about texting and all the texting back and forth. Chad keeps telling Lori what's been revealed to him. Lori keeps asking Chad what's gonna happen next, because he knows he's the equal to Jesus. Chad has actually been to heaven and come back, and so Chad knows everything. When Chad's naming of evil spirits doesn't work, oh, it's because another one's there. When sometimes Chad, yep, someone's close to 0%, and then another time, yep, this person's close to 99%. So even Chad's making it up as he goes. He can't remember if 0% is where people die or if 100% is where people die. I got that mixed up. Here's a chart that works, says Chad. This is when my friend's wife died, my neighbor died, George Bush, Stan Lee. So Chad makes references to Stan Lee, Marvel comic, right? Also makes reference to Harry Potter. So what's going on in Chad's brain? Well, you and I wouldn't believe it, would we? But some people do. Haven't we seen in history that some people follow religious leaders when it doesn't make sense to us? So was it proven who killed Charles? Yes, it was Alex. But you can't consider that for guilt. That's kind of tricky, huh? You can't consider that for guilt on the other three, but for some other reason. Was it proven who killed Tylee? No, but Alex and Chad were at her grave site in Chad's backyard. Alex's fingerprints were on the tools. Chad had said, Tylee doesn't like me. He had told that to people. So I'm guessing Chad and Alex on Tylee. Did they prove that Lori directed it or conspired? Of the 15,000 texts that you have in evidence, show me one where it says from Lori, so when are you killing Tylee? Was it proven who killed JJ? No, but Alex and Chad were at his gravesite in Chad's backyard. Chad got in a scratch fight. Remember that testimony? Chad got in a scratch fight with JJ the night before. Maybe that could explain the scratches on JJ's neck. So witnesses described this scratch fight. And how about JJ's burial site? That Alex was only out there, what was it, 17 minutes? Is that what the FBI guy said? That Alex was out there 17 minutes on that day. So certainly not enough time to dig a meticulous grave and bury a child, find a board from the garage, find rocks that lined up perfectly. Certainly not enough time for Alex to do that on his own. So I'm guessing he had help from Chad. And of the 15,000 texts that you have in evidence, show me one where Lori's part of that conspiracy. When are you killing JJ, by the way? There is no such text. We have 15,000 of them, remember? So why can't people escape religious cult figures? Why can't they break out? Why can't they break away from that mind control? The promises are marvelous to some people. They sound like stupid gibberish to the rest of us. There are examples, you all know of examples of people committing suicide because their religious leader told them to. And you just have to keep asking yourself, why can't people escape? Why can't Lori escape and get back to her good mom life? Lori is not a leader of Chad's new church, the Church of the Firstborn. Lori so wants to testify of Jesus. You heard her on her podcast. She wants to tell the world how much she loves Jesus. She wants to tell you that she personally met him on more than one occasion. But is Lori a leader, or is she a follower of Chad? She so wants to be a leader, but she's not leading anyone. She's following Chad. She thinks Chad is following Jesus, but he's not. He's unfortunately being led by the storm. Not the first guy to be led by the storm. Chad, you'll see in the text, Chad, what about this? What about that? What should I do? Move to Idaho? Lori has never lived in Idaho. She's never lived in a cold place. She's always lived in warm places like California, you heard, Arizona, Texas, Hawaii. But Chad, you want me to move to one of the coldest places in Idaho to be near you? Okay, I'll do it. Lori sees Chad as if Chad is Jesus. Lori tells people she's seen Jesus, but yet she still follows Chad. Blessings are being handed out like flies with some of the testimony. What does that even mean? I bless you. No, I bless you. Well, if you're going to bless me, then I'm going to bless you. What does Brandon Bedreau even mean when he says that? That the religious aspects of this group is so intense that common sense has vanished. So groups who actually do follow Jesus, they do good things, right? Jesus never killed anyone. He blessed everyone. He taught people how to get along. Jesus taught how to be respectful, how to be helpful. If someone wants your coat, give them your coat and your cloak. If someone wants you to walk a mile, walk 2 miles with them. However you can help someone, do that. Treat people like you want to be treated. Judge people like you want to be judged. Since you're a sinner, be kind and forgiving to sinners. If someone has offended you, forgive them. That's the Jesus that we know. That's the Jesus that Lori knew. That's the Jesus that Lori taught her children about. That's the Jesus that Lori believed in until she met Chad Daybell. So on your verdict form, there's not a box to check for, did Lori have an affair? And we spent a lot of time on that issue, remember? On the verdict form, there's not a box to check to see if a crime was committed in Arizona. How many weeks did we spend on that issue? It's very specific, your verdict form. Did she kill? Did she plan to kill and steal? Not kill or steal, but kill and steal. And the proof has to be beyond a reasonable doubt. If it's not, the law says you must find her not guilty. No one here thinks Lori actually killed anyone. That's why she's charged with conspiracy, because they think someone else did the killing. So they want you to be convinced that she's part of this plan, that there's a specific plan to kill on certain days. So if you find her guilty, will that bring the kids back? Nope. If you find her not guilty, will that bring the kids back? Nope. So you can't be concerned about that. What you are concerned about is following the law and following the evidence. Follow the law and the lack of evidence. This case is not about multiple lives or multiple creations. It's not about zombies, not about being a leader of the 144,000. If there's anything we learned about a storm, it's that you hide from a storm. You seek shelter from a storm. That's what you teach your kids, and that's what you know. Her sister and her son, those two who testified about her in this courtroom, have known her the longest. They would never imagine she would be guilty as charged. She spent her whole life protecting her children. Thank you again.
All right, that'll conclude the closing argument of the defense. At this point, the state will, well, let me just inquire, is the state going to offer a rebuttal?
We will, Your Honor.
Okay, with the state offering a rebuttal, the court is going to take the lunch break at this point for the benefit of the jurors, and we will plan on coming back on, let's say in about 45 minutes if we can, for the rebuttal argument.
All right, please.
This is why the state gets the last crack at the apple, because the defense comes in there, states all this nonsense, puts smoke in the air, and then they have the right to set things back straight.
Mr. Bailiff, if we could have the jurors brought in, please. Thank you, Mr. Bailiff. Please be seated. Okay, we're back on the record on case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. The defense just concluded their closing argument, and then we had the lunch recess. The court will note parties are all present, including the defendant. The jurors are also present and all properly seated. With that, Mr. Wood, the state, I believe, will now offer its rebuttal. Is that correct?
Yes, Your Honor. And if I can have my computer run through the monitor.
Okay, you can set that up.
Ladies and gentlemen, the state has met its burden beyond a reasonable doubt. Reason and common sense. Reason and common sense. The evidence in this case is clear. The evidence in this case points to one common thread, and that thread is Lori Vallow. The defense says she's not a killer. She is a killer. Lori is the connection to the deaths. What connection did Chad Daybell have to Charles Vallow? Lori. Why did we talk about Charles Vallow? For the motive. The defense says the math doesn't add up. Well, the defense didn't give you all the numbers, and you know that. The defense gave you a choice of $400,000 to $500,000 a year versus Social Security. That's not all the numbers. Lori believed, and you've seen it through her text, she believed she was getting $1 million, not Social Security funds. She thought she was getting $1 million. The math adds up. And what you see in this case consistently When Lori wants something, she finds a way to make it happen, and she will get rid of any obstacle. She wanted the $1 million from Charles. She learned her lesson. She learned her lesson when she didn't end up getting the money that she found out afterwards. So when she needed more money, she went after Tylee's money. But remember, she learned her lesson. She waited until after the money hit her bank, and then they killed Tylee. Heard evidence multiple times. She called Tylee dark. With JJ, she learned her lesson. She waited until after the money hit her bank, and then they killed JJ. The defense says she's a good mom. Does a good mom, when the whole world is out looking for your kids, dance and laugh on a beach in Hawaii? No. Does a good mom abandon her children in the ground and go marry a recent widower? No. The defense spoke about her call with her sister, Summer Shiflett. Go listen to it. Please listen to it. And when Summer says, you were dancing on a beach in Hawaii, she's talking about the kids dying, and says, and you were dancing on a beach in Hawaii, what does Lori say? Yeah, months later. Months later. It's an admission. She knew her children were dead because she helped plan it. She knew her children were dead because she encouraged it. The defense talked to you about life insurance versus Social Security. Doesn't really make sense. You have to show the dead body to get the life insurance. They couldn't do that. They kept the Social Security. Ongoing payments, monthly payments. The defense brought up, why would she put her son in school and get a nanny? You've heard from her own mouth or her own texts. She was tired of the obstacles. She was tired of JJ. She didn't want to deal with him, so she found someone else who could until they buried him in the ground. Let's talk a little bit about the lies Lori told, and then we'll go over the evidence just a little bit one more time. The lies Lori told tell us what really happened. Let's see what she lied about. She lied about Tylee being at BYU, Idaho. She lied to the police about she was going to go back to Arizona and take JJ to a special school. She lied to the school, Kennedy School in Rexburg, that JJ was with his grandparents. She lied to the police about her brother trying to kill her. She lied when she sent an email to Chad disguised as KK Walker. She lied to Colby Ryan, JJ and Tylee's brother, about where they were. She lied to Colby Ryan about how Charles Vallow died. Remember what he testified to. He had a heart attack. She told him he had a heart attack. She lied to Melanie Gibb. She told Melanie Gibb that JJ was with Kay Woodcock. She told Zulema that JJ was with Kay Woodcock. She lied to the nanny. She said that JJ had gone with his grandparents. She lied to the police about how well she knew Chad. Called him her brother's friend, not her husband. They were married at that point. She lied to the police about JJ being with Melanie. Remember the last thing that Summer testified to you, her own sister, when she was asked if Lori had been honest with her about the kids. Her response was that Lori had lied. Lori lied to cover her crimes repeatedly. Again, does a good mom jet off to Hawaii when the rest of the world is looking for her kids? She knew where her children were. In fact, again, go back and listen to the tape with Summer. Go back and listen to the tape with Melanie Gibb. And she says, I know exactly where JJ is. That might be the one thing you've heard her say that's true, because she did know where JJ was. Lori's lies tell us she's guilty. The innocent don't need to lie. The guilty lie. Think about all the evidence you've seen and her reaction. The body cam, when the police went and spoke with her. Go back and watch it. Count the lies. Watch her getting served poolside with the order to produce her children. And watch how she reacts. Listen. The defense asked you to listen to the jail phone call on June 9th. When Chad calls her and says they're searching the property. She's scared. You will hear it in her voice. You will hear the guilt and the fear in her voice, because she and Chad both know what the police are about to find. Think about some of the physical evidence here. Bruises on JJ and Tammy. Think about the iCloud. Her words. Her words. The defense says there's no text where she says, I'm going to kill the kids today. Well, no, she doesn't say it like that. But she says it. Let's talk about some more of the physical evidence. The defense mentioned Lori's hair. It wasn't on JJ's socks. It wasn't in his pajamas. That hair was on the duct tape wrapped around the black bag. On the same black bag that Alex Cox's fingerprint and palm print were on. It wasn't on JJ. It was in the duct tape that secured that bag. Think about all the electronic data you've watched or you've seen. Alex's movements, the flurry of information going before in form of text and phone calls on those critical dates. Lori knew exactly what was going on. Again, $1 million, not 500,000 versus Social Security. The math adds up. And just quickly, because the defense brought up the text again. We bolded here where Lori is bringing up the kids. When they're talking about death percentages, from Lori, okay, find out her percentage, meaning Hillary, who is Tylee, find that out for me, and JJ's. They mentioned the storm text, but they didn't tell you all the text. What does Chad say? Just grab me by the storm, and I will follow you to the ends of the universe. Not you will follow me, Lori. I will follow you. Don't let Lori pin this all on one other person. She was 100% involved in this, and all the evidence points to that. When she's talking to Melanie Boudreau, telling her, you can't go at all. This is the 2 days before Charles Vallow is shot. She says to Melanie Boudreau, you can't leave. We both need to stay here to defend ourselves. It's coming to a head. This week will change everything. And then they killed Charles. Again, when Chad Daybell is texting her about JJ going into the light, we all know what that means. He doesn't have to say die. We all know what going into the light means. And again, what does she say? She doesn't say, let's not kill kids. She says, that is sweet. Again, here's Lori. I need you to check JJ. Check Tylee. She is encouraging. She is aiding. She's part of the plan. Again, Lori's own words. Hold her words against her. See if she got switched. Need you to check JJ. Think about all the times she says she has no more patience. And again, this text, one more time, from Chad. I got the inspiration to go back to my original death percentages that helped us track Charles. And we know what happened to Charles. He's dead. Not fantasy dead, not weird religion dead. He is dead. 2 bullets in the chest. Tammy is close. And how does she respond? What about JJ? This is clear. They're talking about dead people and tying Tammy to it, tying JJ to it. And when he says they're at 2 or 3%, she's upset that it's not 0 yet. Again, please check JJ. Is he at 0 yet? The defense says there's no text about killing the kids. Do you think there is a perfectly orchestrated plan to take the children, and I should be doing something to help? Remember the text about Nathan Pachenko, who you heard was a singer? And she asked Chad what he thinks. He gives her a dark rating. He gives him a dark rating. Lori gives him a light rating. What does Chad do? Okay, we'll go with you. He will follow her till the end of the universe. Let's talk briefly, just briefly, one more time about what you need to find. The question you need to ask. Lori agree with Chad and Alex to commit the crime of first-degree murder against Tylee? Yes, she did. There's no question. And did she and grand theft? Yes, the math is there. Did she intend for these children to die? Yes. What mother, if she didn't intend for her children to die, doesn't go report that she's missing or dead? It makes no sense to say that she's a good mom when she's not reporting the death of her children or that her children are missing. She intended the death. We've gone through the overt acts. We've met them in spades. You have the evidence. You must convict her. In regards to the murder of Tylee Ryan, you have to ask, did Lori Vallow engage in conduct, or did aid, abet, advise, or counsel another to engage in conduct which caused the death of Tylee Ryan? Yes. It is clear. The same applies to JJ. The same applies to Tammy. As the defense spoke, it reminded me of some of Zulema Pastana's testimony. When Lori would tell her friends that nothing she did in this life counted for her. She could do whatever she wanted. Nothing in this life counted for her. And she made a little motion she did. She'd go, doesn't count for me. Make it count for her. Make it count for Lori Vallow that Tylee Ryan was burnt, mutilated, buried in a bucket next to a dog and cat. That Tylee Ryan will never get to go to college, will never get to fully grow up. Make it count for Lori Vallow that JJ a boy with special needs, had a plastic bag placed over his head and had to fight for his life. Make that count for her. And make it count for Lori. Tammy Daybell had to die so that Lori could get to that money, so that Lori could get to Chad Daybell. And make it count for her that she stole. Again, reason and common sense. Reason and common sense. Lori's behavior shows you that she is a killer. Lori's behavior is not the behavior of a mom concerned for the safety and welfare of her children. Justice for these victims requires a conviction. The state has met its burden. Ladies and gentlemen, reason and common sense. Reason and common sense. You must convict her. Thank you.
All right, ladies and gentlemen of the jury, that now concludes the closing arguments. The evidence has been concluded in this case as well. So very soon you will retire for your deliberations. Before so, I do want to address the jurors here. At the beginning of this case, 18 of you were seated to comprise the jury that would hear this case. At that time, you were all advised that upon the conclusion of the evidence and closing arguments, only 12 of you would proceed to deliberate and reach a verdict, and that time has come. Before I instruct the clerk to draw at random 6 numbers corresponding to your seat numbers to determine which 6 of you will become our alternates, I wish to thank you for your willingness to give of your time away from your accustomed daily pursuits and faithfully discharge your duty as jurors. I have a few instructions for you also. Number 1, if your number is selected as an alternate, you will be dismissed, but you should remain reachable and in contact with the bailiffs should you need to be recalled in your duty as an alternate. Second, you will receive some additional information to assist you as you leave today through the court administration office. Third, and importantly, while remaining an alternate, you're still under the obligation to continue to adhere to the admonishment you've been given each day by me as jurors when we break for the day. In the event you need to be recalled to rejoin your fellow jurors to deliberate, you won't be able to do so if you've discussed this case with other people, researched it in any way, or been exposed to any reporting or media that would compromise your impartiality. For that reason, please continue to abide by that instruction until you've been notified that either a verdict was reached in this case or you are recalled to assist your fellow jurors in additional deliberations. So 18 of you were called to serve as jurors in this case, while only 12 of you will deliberate and reach a verdict. All 18 of you have been a necessary part of this case to ensure the administration of justice. And for that, you have the sincere thanks of this court. At this time, then, I'm going to ask our clerk to please draw at random 6 numbers as assigned to the juror seat numbers. And so we're clear with the seating chart. It's juror number 1 on the front row to my right, going to juror 8, juror 9, far right on the back row to juror number 18. So I will ask the clerks at this time to please one by one draw out a total of 6 numbers, and we'll indicate one at a time then who the alternates will be. Madam Clerk, you can proceed with that.
Juror number 18. Juror number 1. Juror number 2. Juror number 17. Juror number 3. And juror number 7.
All right. So based on the random draw then, jurors 18, 1, 2, 17, 3, and 7 will be the alternate jurors. As I mentioned, in the event a juror remaining becomes ill or is excused for some reason, the alternate will need to return and the deliberations would start over. Again, you are excused with the sincere thanks of this court. Please leave us your contact information and continue to abide by those admonitions. And with that in mind, would all please rise for the jurors.
Okay, well that concludes that. Let me do a last look on Twitter and see if there's anything new about the verdict, because I have a hard time believing that it was announced we'd have a 9 a.m. verdict and it not be mentioned anywhere on YouTube or Twitter. That just doesn't feel accurate. We've got 45 minutes left of when they're supposed to be deliberating today. And they haven't said they've gone home for the night either. So I'm a bit puzzled. But once again, we'll play it by ear. And if it looks like it's genuinely a 9 a.m. verdict, I will know by 8 a.m. And so I'll post it at 9. And if not, I'll start it at 10. And we'll find some commentary to review while we're on jury watch. So thank you all so much for sticking with me here. And we look forward to hopefully a very momentous day. See, he was first on back order, so he canceled it. Oh, okay. All right. Well, I'll bid you good night. We're over the 10-hour mark here, so I think we're all due for a break. So we'll see you tomorrow. All right. Bye-bye.